Hello, everyone, and welcome back to Immigration and Jobs Talk Show. I'm very happy to have you join us. And before we start off with today's show, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Thank you so much, folks out there, for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook, and on X. So please feel free to join us, by commenting, especially with regard to our topic of today. And before I tell you who's going to join us, you can also join us on call by dialing this number 425-436-6335, and the access code is 988-888. And once you're in, you just say hello, we will be able to hear you. So, folks, today's topic of discussion is Trump 2025. Who's on his new team and what does it mean for America? I know there has been a lot of discussions and news on this. Every day you hear something about Trump's team, and we are all excited to know what's going to happen once Trump returns to office. And, I'm very, very excited because today we have a truly distinguished guest joining us, someone whose name resonates in the field of business and immigration worldwide, by the way. And so, ladies and gentlemen, it is an absolute honor to introduce Charles Cook. Thank you so much, Charles, for joining us. And
Apostle,
Charles,
thank you very much for having me.
thank you so much, Charles. This is probably our second time, and I'm very excited that we're going to have this discussion today.
Well, I'm looking forward to it because nothing gets the blood going more than talking about Donald Trump.
I know passion comes running in, right? Both ways. So, Charles, folks out there, Charles is a globally recognized business and investor immigration attorney and a fierce advocate for sensible immigration reform. So, I'm sure it's going to be awesome if you could join us, especially with your questions. You can comment or call us. And, Charles, maybe tell us what's going on with you these days.
Well, with me, in the United States, we're getting ready for Christmas, hence your Christmas theme, and it's of course a great time to be alive. And I'm looking forward to my grandchildren coming to my farm this weekend and having just a wonderful and joyous time.
Absolutely, I'm sure. Will you be playing Santa?
No, I'm not big enough to play Santa. I don't want to ever get big enough to play Santa. But if my checkbook counts, yes, then I'm playing Santa. It just depends on how you approach it.
It works. I'm sure it's going to be very exciting. And here's wishing you and your lovely family a happy Christmas season, happy holidays, a good time in your farm. And I'm sure it's going to be awesome with you.
Thank you. It's going to be a good time. But we have to get back to the topic at hand, don't we?
Yes. So
you probably
what can folks out there expect?
You're probably not aware that even though Trump doesn't become president until January 20th, I believe, he's already basically acting like the president. And we literally are in our very first, right now as we speak, the very first Trump crisis of his second term, in that he's basically telling Congress to shut the government down today at midnight. There's literally 2 votes that have failed. President Musk has put his imprimatur on some items here. So as co-president, Donald Trump and him are deciding, even before he's president, what's going to happen to America. And if this little taste of chaos isn't enough for you, we can jump right into the immigration stuff, because chaos will rule supreme for the next 4 years.
So yes, this shutting down of the government, is it true? What's going to happen? So it's like the transition period, or?
No, well, it's really interesting. The reason it's shutting down is because the government doesn't have a budget. So no budget is passed, and there's no budget. The government just stops working. Now, the interesting thing, part of that, Nepal, is that the Immigration Service, USCIS, is actually not funded by the budget. So USCIS keeps operating, but ICE is funded by the budget, which is the immigration enforcement side. The consulates are funded by the budget. They shut down. And at midnight tonight, the budget is over. So what I heard literally just before coming on the air, that they're trying to consider a plan C, since plan A and B have failed. Plan C will be a series of votes on a series of proposals that will ultimately lead to the government not shutting down. But Republicans who control the House, and in our system, the House controls the budget. All budget bills have to come out of the House. Republicans only have an 8-seat majority, and they have about 35 members who are basically insane. And they basically love shutting down the government's the greatest thing. They hate the government. Isn't that ironic? They became congressmen so they could hate the government and shut it down. So they need Democrats to support the bill. But if Democrats, look, if you want us to support the bill, you gotta give us some cheese. You gotta do something for us. And that was the very first bill that President Musk came down and said, no, this is terrible. This is terrible. We can't do this. And so Democrats are now sitting on the sidelines going, not really our problem. We don't have enough votes to pass our bill. What are you going to do? So it's literally a chaos show right now, Nipasa. If it wasn't so tragic, it would be funny.
It would. I know, it's crazy. I think we can only keep guessing until it really happens. So let's see what's going to happen after midnight tonight.
I'm sure these things never happen in India. I'm sure it's nothing like this.
No, never heard of anything as such anywhere, actually. All right. So let's go on. Let's go on to our topic. And I have a few questions. So let's dive right into our first one. So, given the Trump administration's historical stance of immigration, how do you foresee the key changes or continuations in immigration policy if he returns to power after January 20th?
Well, it's interesting. I've seen a lot of stuff on a lot of websites, particularly from India, about how Elon Musk is going to temper the hawkish nativist movement within the Trump administration. And to that, I say, you're delusional. President Trump said that his primary key advisor on immigration is a man named Stephen Miller. Stephen Miller is the grandson of Holocaust survivors, Jewish, and truly hates immigrants. The irony doesn't escape anybody. He was the principal architect of all of the anti-immigrant nativist movement in the first term, and his position has been elevated into the second term. And people will say, well, they're only going to go after illegals. It's just the undocumented people. That literally is not true. There are already laws allowing Trump to deport people. They just need money to do it. What was evident in the first term will become more evident in the second term. The lowest levels of legal immigration that we had since 1789 were during the Trump years. Why? Because they're going to do certain things to, one, slow down every process. Now, Biden has been no jewel. He's been no great immigration god to anybody. He's done a crappy job as far as I'm concerned. But Trump will intentionally destroy the system. So I'll give you a great example. One of the things that Biden did fix was the naturalization process. People had green cards, become citizens. Under Trump, those were taking about 2 to 3 years. The last couple of years under Biden, it's been taking 4 to 8 months, much quicker to become a citizen. Green cards. The Trump administration is the administration that did not use all of the available immigrant visas that I had to sue them on back in 2020. They also are the ones that proposed terrible H1B regulations that I had to sue them on in 2018 and 2019. All of those things are coming back, except this time, the people that are in charge have learned their lesson. Everybody under Trump previously were newbies. They were new people. They really weren't ever in government. They didn't know how the mechanisms of government worked. They've now had 8 years to learn, and they now know. So starting with Stephen Miller, who is basically the number 3 or 4 guy in the White House, and then followed behind him on the enforcement side is a guy named Tom Homan. Tom Homan used to be the head of, well, he wasn't even head of ICE. He worked at ICE, but he's been a Fox News contributor on immigration for years now. And he portrays this kind of tough guy. Yeah, you lawyers, we're going to arrest you for helping immigrants. Really a tough guy kind of thing. But actually, it's the people below them they're going to make a difference. So the key changes, one, we will see things like a slowdown in immigrant visas, I-140s, for example, slower processing. We will see slower appointment times at the consulates. We will see tougher adjudication standards on a lot of different applications. And we will see things like the H1B visa. We anticipate that sometime in the first year or so, the Trump administration will propose a new H1B regulation on wages and say that, yes, there's a lottery, but this lottery will be on the wages. Whoever is getting paid the most will get the H1B visa, as opposed to just what we have this next year, just a sheer lottery, basically by individual, not by employer anymore. So all of those things, and that's kind of the 35,000 foot view, but we can go into a lot more detail as we talk about this today.
For sure. I mean, I hear about that. We had a few discussions, and I mean, if people who are going to be paid most wages are going to be preferred, then I'm sure a lot of small businesses, startup companies are going to suffer on that.
Nonprofits, hospitals, it would be disastrous. But Elon Musk would get all of his people that he wants to hire. The irony here is that Musk is an immigrant, right? That's the ultimate irony here. And in fact, he appears to have been undocumented for a period of time after he was from a student visa before he got an H1B. And when he was getting his H1B back in the 90s, it was much easier to get an H. There was a lot more H1Bs available. So the irony doesn't escape anybody, but here's a guy that's kind of a nativist that started out as an immigrant. It's something we actually see quite often, which is kind of shocking. Close the door behind me kind of people. So go ahead, ask some more questions. We got some great questions here. I know you've got a lot more you want to ask me. We can even talk about the individuals that we know will be running things besides the guys in the White House.
Yes, absolutely. And you were talking about Stephen Miller. So I think I want to ask about him, when you talk about immigration reforms and, the executive actions, particularly concerning asylum policies and refugee camps. What would you like to say about that?
Well, I have just briefly about that. Biden this last month, this November, appears to have been the lowest number of people that came to our border illegally in about 10 years. So even lower than when Donald Trump was president. These are, of course, Biden policies. The thing that's helping is that Republicans are no longer saying, the border's open! The border is open! They go on Fox, the border is open! Well, if you've got Congressman or Trump yelling that, you know where that plays on the news? Guatemala, El Salvador, Nicaragua, Colombia, China. Oh, the border's open. They said it was open. I'm going to come to the border. Since they stopped talking about it, the numbers go down. How ironic is that? Biden had just enacted this last week some asylum reforms that will make getting asylum, the initial interview of asylum, much harder than it has been, and allow for asylum officers to reject people faster. That doesn't mean that they will. I mean, one thing you have to understand about asylum, people coming to the border, is that desperation drives a lot of people. There's a lot of desperation that goes on there. And you can't build walls high enough. You can't erect barriers big enough to stop desperate people. You just can't. What you could do is have a legal immigration system that paves way for them to come, which of course we don't have. So the reform, now Trump wants to put back into place something called MPP. MPP is called Remain in Mexico. Let's say somebody from India says, I'm going to, they're going to kill me in India. I'm going to come to the United States. I'll go to the border, go to Mexico, go to the border. What MPP says, you're going to wait in Mexico until we have time to talk to you. Well, you know who that was great for? The Mexican cartels. Mexican cartels would rape, kidnap, extort, charge people for that. Their cartels were in seventh heaven under MPP. But MPP didn't stop people from coming, because one of the weird things that MPP did was that if you came in and were tossed back, that did not count as an illegal entry. So the bars that are in our laws that then punish you for doing that were gone. It literally was the least effective program ever created for the border, besides the fact it's probably illegal and in fact was stopped one time by a judge. So these asylum things that you see at the border, that's probably history at this point. The numbers are now equalized. They're fine. More people come in by appointment to apply for asylum than come illegally. So, that, and I know, and it upset a lot of people that were legal here, justifiably. People that were been here for 10 years, no papers, and people were coming in right now and applying for getting a work permit. Well, it doesn't sound fair, but that's what the law is, right? So if you do apply for asylum, you do get a work permit. It doesn't put you in front of the line, though. The line is still what the line is. And even if you get asylum, even if you get approved, which only 30% of people do, the reality is you have years before you're going to become a permanent resident. So unfortunately, there was a lot of misinformation. It caused a lot of bad feelings. Immigrant groups cannot afford to fight each other. They need to fight together to make the pie bigger rather than fight over one piece of pie. And hopefully we can come to that kind of understanding this year, because it's going to be really important under the Trump administration.
I hope so. And talking about, border security, you were saying, do you think, that the Trump administration, in terms of border security and immigration enforcement, what do you think is going to look like? Especially with the movement, coming into force, the border czar.
It's going to look really ugly. The image that people have of America, the shining city on the hill, as Reagan talked about, the Statue of Liberty, we might as well burn all that down, because they're coming for people. Now, you have to ask, how are they going to identify bad guys, undocumented? How are they going to do that? Nipasa, there's really only one way to do that, and is to look at you. And they'll say, oh, Nipasa, show me your papers. Like we live in Germany in 1933 or something. Now, what they will do is they will actually begin with the easy stuff. So ICE, which is the enforcement part of immigration in the United States, Immigration Customs Enforcement, they're inherently lazy. All right. They're not, in order to go find people, they're not going to drive buses through trailer parks looking for Mexicans. They're going to go after first people with criminal convictions. Now, here's the thing that is truly ironic. If you ask an American, just an average American who voted for Trump, how many illegal aliens with criminal convictions do you think there are? They will tell you, and there's a poll that said this, like 4 million. There's 60,000. There's 60,000. Now, there's about 300,000 people that do have criminal convictions that actually have orders of deportation that are not in custody because they cannot be deported. Their country refused to take them. Now, one thing that Trump did that was good last term, that no other president really did, he basically threatened countries. If they didn't take the people that we wanted to deport back to them, he would start a trade war. He would just put sanctions on them. He would put tariffs on them. He would cut off aid. And miraculously, some of these countries actually took people back. China was one of them. China doesn't take anybody back. Cuba is another one. Israel doesn't take Palestinians back. There's all over the world that people don't go back. But what's the purpose of detaining them? You can't deport them. So the next group of people are those that are simply have removal orders. There are over 1.5 million people in the United States, as far as the government understands, that actually have deep final orders. They've had the due process. They got denied. But they don't know where they are. So they're going to have to put resources towards literally finding them. Now, are they findable? Of course. ICE is already using AI to do that. But ICE is only funded to deport at the most 400,000 people a year. It just was announced that last year, Biden deported more people in 2024, fiscal year 2024, than Trump ever did in any year. So Biden is right after Obama in deporting people. Trump wants to get up there and do that. And, they talk about deporting 8 million, 9 million, 10. That's completely unrealistic. It's not going to happen. But what they will be doing is scaring people. They will drive undocumented further underground. And if you think that all undocumented are Mexicans, you're sadly mistaken. Do you know how many Indian nationals that I know that are undocumented? I probably have a couple thousand that are my clients that are undocumented Indians. There's probably close to 500,000 undocumented Indians in the United States. So it's not just a Latino problem or a Central American or Latin American problem. It's a worldwide problem that we have. So I see this very aggressive type of work. Now, on the flip side, so Holman's going to do that. That's kind of his bailiwick. ICE is going to also do worksite enforcement, and for H1Bs, lots of what's called FDNS, or fraud detection national security visits to H1B visa holders. They're asking for more money in the bill that will likely pass in April or May or March, something like that, to get more officers to do worksite visits for H1Bs. ICE will also be doing they don't really do random audits. What ICE did last time, and they'll do again, they have a phone number. And they say, look, if you are an American and you think you see undocumented workers at a company, call us. And under Trump, they had lists they never even could get to. The Biden administration did no worksite enforcement, none. There was no new worksite enforcement. So we'll see that. But what's going to happen, a lot of these people that own these businesses that employ undocumented workers, typically working on fake documents, they voted for Trump. So when ICE starts going after these businesses who are Trump voters, you're going to start hearing weeping and wailing and gnashing of teeth, biblical level complaining. And what you will see is ICE will back off because Trump doesn't want to hurt his friends. I would love to see, though, an employer site visit to SpaceX. It would be kind of cool. Or Tesla plant. So this is undocumented workers going to be under pressure. This will be nothing like the Trump years, the Obama year. Obama's were worse, honestly. The first years of Obama were terrible. We'll see. We'll approach it, but we won't get there. Mostly because it's a very different world we live in than even just 10 years ago, or 12 years ago, or 14 years ago when Obama was president. So it's gonna be crazy, and a lot of innocent people will get caught up, including a lot of Indian nationals.
So do you think, because, Biden, during Biden, it was not so strict with regard to, in the borders, right? So many people could come in and
that's not true. See, the boss, I'm going to cut you off because that's literally not true. Okay. There is a perception here that Biden let anybody in. You know what Biden did?
Of course not.
Biden followed the law. He followed the law. 8 USC 208. Anyone who comes to a port of entry is allowed to apply for asylum. Period. Mm-hmm. End of story. It's the law. The law was the problem, not Biden. It's Trump that was violating the law. So Biden did his best to follow the law and then change policy and regulation so he could still be within the law and try to stem the flow. But Biden didn't open the borders. They didn't say come in. In fact, it was, as I said, Republicans said the borders are open now. Biden's president, and I think this didn't happen.
It didn't. Right. But yeah, thank you so much. I mean, that was very, very intense, but we have so much to cover. So let's go on to our next. No, it's cool.
Hey, I need a vacation for Christmas.
Well, I do hope we end with good things and good notes so that people can enjoy their holidays at least.
I hope so. But there's a lot of people. Let's talk just briefly, if you don't mind, about the people that will be running immigration. So they've been identified now. There's two former Trump people that worked extensively in the immigration service in his last term. One guy's name is Joe Edlow. Joe was actually acting head of immigration at one point, and the other guy's name is John Zadrozny. Both of them are true believers in Trump. Now, this is USCIS. These are the affirmative visa people. So one immediate change, we'll see. They have to be confirmed first, but some immediate changes within January, February, March that we'll see. We'll go back to interviewing everybody that's getting a green card. Everybody getting a green card will be interviewed. Trump started that. Biden kind of ended it. It'll go back. This includes every employment-based case. Everybody gets interviewed. Now, when you do that, Napasa, and you don't hire more people, what happens? It just gets longer and longer and longer and longer and longer and longer. That's what leads to 2 and 3 year adjustment of status. Because we've had a lot of clients get approved in the last couple of years on, let's say, an I-140 is approved, file an adjustment. Boom, it's approved in 30, 60, 90 days. Those days are over. They're gone. That's one policy. The other thing that we will see is some changes proposed to the H-1B. We talked about the fee rule, but Biden just changed the definition of specialty occupation, how to prove specialty occupation, and who doesn't qualify for an H-1B. So a BCom no longer is an H-1B. A degree, a bachelor's degree in business is now not a specialty occupation. You need something very much more specific for H-1Bs. Trump will take that to the next level as part of this application. So we're going to see a lot longer visa processing times within the USCIS, and we're going to see a lot more green card processing times. The other thing they're going to do, and this is truly tad, when Biden took over and Urchanu became USCIS director, she let us know that immigration was only staffed at 60% of what they needed to do the work that they had. They were 40% understaffed. So they literally last month finally got fully staffed. What these guys are going to do is shrink that workforce. Again, if you have fewer people adjudicating cases and you have the same number or more cases, it's going to take longer. And so we're going to see these really long visa processing times just to get an H-1B approved, which means a lot more people will pay, when available, premium processing. So immigration will make more money by being incompetent. It's a great deal if you can get it. So those are some of the big impacts we will see. We're also going to see, like on L visas, an even more tightening up of what a manager executive is. We're going to see a tightening up on O's and extraordinary ability. And I think Trump may end the Biden policy on NI, national interest waivers, and make those as hard as they were back in the day. Because national interest waivers have become very easy in the last several years with the Biden policy. And that's a policy. That's literally a day one. I dismiss this order. I cancel it. It's gone. Boom. Overnight, you have a pending case that would have been approved, now gets denied. So if listeners have an NIW pending, they should be premium processing that, because you don't want that still pending when Trump's president.
Yes. And you still got exactly 1 month, you can say, for that. So as soon as possible, get things done. Yeah.
31 days and Trump is president.
Yes. And well, about the H1B new regulations also, we hear a lot of changes coming in. So do you think that is also going to affect, or it's going to be great during Trump's reign?
Well, the ironic part of these new regulations on H-1Bs is that some of them are proposals made by Trump, like the tightening up of specialty occupation. If anybody goes on Twitter, there's a lot of hate towards H-1Bs. I mean, a lot of hate towards H-1Bs. And as a result, Trump hears this, his minions see it, and they say, what can we do to limit? I mean, they can't eliminate H-1Bs. They can't do that, but they can make them a lot harder to get. And a lot of the complaint, of course, is that job shops use these. Now, if you go back and look at the biggest users of H-1Bs last year, there's only like one job shop on them. There's only one outsource. I mean, the rest are like Amazon's the number one user, Microsoft, Tesla is up there in the top 10. So it's not that there's a lot of outsourcing jobs here. And that's, of course, you hear from is Americans who were laid off. So as an Indian H-1B engineer making $60,000 can do his job. Well, if you're doing a job that somebody else with a less education and experience can do, then you need a different job. I mean, then you're in the wrong job. So it's but there'll be going to be a lot of pushback on these H-1Bs. There's not going to be, I don't see any litigation possible on these new regulations. They're well within the authority of the Immigration Service to issue. None of them are truly outrageous. And there are a couple good things in there. For example, if you were previously approved for the same job with the same employer, they're basically going to approve the extension. There's going to be a deference policy. Anything changes, no deference, but deference is a really, really important thing. So that's how I see those H-1B rules shaking out. We have to modify how we do a couple things internally at the firm, but for the most part, it's going to be business as usual on H-1Bs that we do.
Okay. Now coming back to more questions, let's talk about Vivek Ramaswamy, advocating for merit-based system. So how do you anticipate his policies will reshape employment-based immigration categories or even family-sponsored visa programs?
Well, the good news is that Vivek Ramaswamy has no power over immigration. And there can be no merit-based system or point system unless Congress gets involved. Congress has to change our law. Vivek Ramaswamy can't change our laws. The irony is, of course, his parents were H1B visa holders, right? And would his dad have come under the new regulations? That's a good question. I don't know. Maybe he would have, maybe he wouldn't have. Ramaswamy and Musk are examples of close the door behind me, I'm here kind of immigrants. The kind I truly detest. People that don't want others to have the same opportunity we did. America is a big country. It's a big country. I mean, it's not India. It's only a fifth the size of India, right? But physically, it's a big country. Economic power. There is room for hundreds of millions of more people. There is. And there's the opportunity. When we bring an H1B immigrant in, on average, they create 4 to 5 jobs for Americans. On average, they create jobs. H1B immigrants are job creators. They're not job takers. And that's true from the janitor or the guy picking your mushrooms or picking your melons in the field to the guy building rockets for SpaceX. We've got room for a lot more people. We're still living, however, under 1990 rules. All these rules we talk about for employment-based immigrants were created in 1990. We were a very different country. Heck, my cell phone in 1990 was in a bag that I carried around that only reached 3 miles. So we live in a very, very different country, and maybe Trump's the guy to fix it. More power to them if he can fix it. I just don't see the level of competence in the administration doing that. And of course, I see a real nativist streak in Stephen Miller and Tom Homan. They don't want more immigrants. They don't. So do Musk and Ramaswamy have the power against Miller and Toman? Well, Miller and Toman are sitting in the White House. Ramaswamy and Musk are too busy down at Mar-a-Lago. So I think the nativists are going to win the day here, and we're going to have to wait till 2029 to fix stuff again. That's my prediction.
Logical, very much. Thank you so much. Now let's go on. So do you anticipate any changes in approach to also family-sponsored immigration categories, F1, F3, F4 visa categories under Trump?
You left out F2. Again, we've had extra employment-based visas for several years because the consulates, who do most of these are under the consulates, were slow. So I suspect that there will be a slowdown in visa processing. Heck, the Muslim ban that he's going to put back in place, there will be a Muslim ban. It'll be broader than before. That will slow down massive family-based immigration, which means there'll be more employment-based visas in fiscal year 2026 is my guess. So yeah, it'll be a slowdown. He can't deny the visas. I mean, the visas are the visas. But I also see him bringing back a new, what's called the affidavit support rule, the public benefits rule, and making it much harder for people to come in who are poor, whose families aren't wealthy. I see them bringing that back. That's going to be quite a fight, as I can tell you.
Okay, thank you for that. I think we should quickly take up RK's question on YouTube before we head on with more questions from us.
There's a lot of great questions here.
Yeah. Do you think for H1B wage base, it would be the highest wage per occupation? And that means if you're the highest paid for your occupation, you're eligible for the lottery regardless another occupation.
No, it will be the highest wage. So you're at Apple and you're getting paid $395,000 a year. You're getting an H1B. You're working as a software engineer at Bob's muffler shop, and you're making $40,000. You're not getting it. This is not across teachers, software engineers, doctors. No, the highest wages. That's what is going to happen. That's what they want to see.
Okay,
it's a great question. I like it, but it's not going to happen.
There's another one that follows. Example, highest paid teacher. Okay, you've already explained. Okay, let's take up.
Ankit has a great question.
Who?
Ankit's got a great question there. 123505.
Hello,
and not
Charles,
because he said our show was amazing.
Yes, he says. So glad, Ankit, you've been following. And he's saying, I also want to ask that the RFE ask for additional evidence to prove that my job qualities as a specialty occupation. What kind of
Well,
documentation should I submit to demonstrate that position requires bachelor's degree or higher?
Well, you shouldn't be filing it. Your lawyer should be filing it. Basically, you're going to start with the Occupational Outlook Handbook, which describes every job in America and what the educational requirements are. You're next going to look at advertisements for that job from other employers. What do other employers say is required for that particular position? And remember, it's not that a bachelor's degree or higher is required. Under the new rules, it's a specific bachelor's degree is required. So they're saying that jobs like systems analyst no longer requires a degree, because I can teach somebody to do that in a week. I don't need anybody to do that. So a lot of H1Bs are going to lose their H1B when they renew because of this. So you're going to look at what is generally required in the industry. You're going to look at what the academics say the requirements are. You get letters from experts that say a bachelor's degree is required for this job. You get a very detailed letter from the employer explaining why a bachelor's degree, you have to take these classes in order to understand how this widget works. So all those things have to be part, and that's why H1Bs are going to get a lot more expensive, because it's going to get a lot harder to do this.
Right. Thank you so much, Ankit.
At least for some jobs. I mean, I'm filing an H1B for a lawyer. That's easy, right? Requires a JD. Thank you very much. Boom.
So I think he will need an evaluation as well, right?
The evaluations are done for the individual. Do they qualify for the job? You want to get an expert opinion that says this job at this company and in this industry, this requires a degree. And here's how I know, because I've been teaching this subject at Harvard for the last 30 years and blah, 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 blah. That's what you kind of need. And again, you're going to pay those guys. So H1Bs are going to get more expensive.
Mm-hmm. Okay, let's take up Rogers now. This is from LinkedIn. Feliz Navidad, guys. Merry Christmas to you too, Roger, and to your family. And he says he has a question. I have a green card that got expired when I was 11 years old. Is it possible to renew it even though it passed 30 years since then?
Well, it's a question. Roger, are you in the United States? If you're in the United States, that green card's still valid. I assume it's a pink one. It should be a pink one, or maybe even it's probably not a green one, but it's probably a pink one with no expiration date. If you've been in the U.S. the whole time, the card is fine. If you've been out of the country, that card's expired, right? That card's done, because if you're out of the country for more than a year, you abandon your residence. But if you've been in the United States, you can just file a renewal. Just file a 990 and get a new card. Piece of cake.
Even though
Better question, 30 years in the United States, why haven't you naturalized?
Roger, tell us more about yourself. Which is the one you have? Which color is it? Pink or green? And why have you not naturalized if you're still in the US? All right. Cool. So let's take up Tamara's question now. I have sent my RFE response for STEM approval to USCIS. It is reflecting as received on portal. How long does it take to get an update? And in scenario where it gets denied, what options does Tamara have?
Generally, it takes 30 days or less on a STEM OPT extension. Gets denied, you will have 60 days to leave the United States. Or change status to a visitor or go back to school. Those will be your options.
Okay. Thank you. Thank you for taking that up for Tamara. And let's go on to one more. Let's take Chandra's question. My employer is a small business and doesn't have the same resource as large companies. How can we prove that they have the ability to pay my salary and fulfill the job requirements for the H1B?
So we just had it. We just won an RFE on this issue that another lawyer had lost, and we actually did a motion to reopen and won it. You start with the employer's tax returns. So is the amount of money they claimed as taxable profit for the business, is that more than your salary? If so, you're fine. If you were already working there under OPT and you're getting paid the salary, you show your pay stubs as part of it. You also look at the person's tax return, company's tax returns. Do they have assets? Do they have carry forward profits? All those things are part of the consideration and are very case specific. So, if you've got that and you're an RFE and your lawyer is not handling it right, just give us a call. We're happy to help. We just actually, I'm very proud of my partner, Danielle Claffey. She just won. There's a fellow who used to be an H1B worker, a fellow from India at a state agency. And there was some weird stuff going on where he was blamed for something that wasn't his fault. And he went to a different employer and he ultimately got his I-140, became current, filed, and immigration denied it because they said he did something bad at his employer. And he came to us, and it's taken us a year, and we had to file litigation in federal court. But yesterday, he got his green card. They reopened the case and gave it to him. So fighting hard is worth it most times, because immigration makes mistakes and presumes the worst of immigrants all the time. They presume the worst.
All the time, yes. But yes, kudos to you, your team, and Danielle out there. A big shout out. And folks out there, you
He's a
can
rock star.
contact, yes, you can contact Charles Cuck, have a one-on-one consultation. And you can call him up on his number. His number is 404 949 8154. Let me repeat that: 404 949 8154.
But don't call now. Don't call now. I'm on the show.
Right after the show, maybe. But yes, you can even email Chuck, and his email address is chuck@immigration.net, and go visit www.immigration.net to get to know more about Charles Cuck. Thank you so much. And let's go on now, Charles, to my next question. I have this, and that is: the Trump 2025 team really appears to blend restrictive and reformative voices. So how might their combined influence impact DACA, and other programs supporting undocumented youth?
I'm glad you asked about DACA. DACA is kind of apart from what Trump has done and will do going forward. The DACA has a strange history. Started by Obama. Trump ended it in September 2017. At least he thought he did. But litigation was filed because Trump ended it wrong. He was required to follow the Administrative Procedures Act, and he didn't. And they're just obstinate. They just never did it. So litigation kept on going, and you couldn't file a new DACA, but you could keep extending your DACA. Biden comes along and says, "Oh, we're going to do it the right way." Biden extends DACA. And then the court says, "Yeah, you extended it the right way, but we don't think you have the power to do it." So the court ended it, but said, "Yeah, they can keep extending people with DACA." It's about 500,000 people. Now there's been argument on appeal of that decision at the Court of Appeals. They'll make a decision probably before Trump comes into office saying DACA is illegal, but then it will be appealed to the Supreme Court. And during this time, DACA will continue. In order for Trump to cancel it, he has to go through this same process that he didn't go through before, but which Biden did, and it takes a year. So DACA is not going away. DACA is going to be around for the next year and a half. Supreme Court won't even hear the case until 2026. What we're telling people, my advice, we have thousands of DACA clients, is if you have DACA and it expires in 2025, you should be filing your extension today. File your extension today to get that extra time, that extra year on the back end, year and a half, 18 months on that back end, because this way you're good till 2027, and you don't know what's going to happen in 2027. So that's kind of where we are with DACA, but Congress isn't going to touch it. Trump spoke approvingly of it in an interview on Meet the Press a couple weeks ago, but Stephen Miller runs immigration. He hates DACA. So it's not going to get approved. Congress isn't going to do anything. The best we can do is fight to keep it where we're at.
Okay. Thank you so much for, for the detailed explanation. And yes, I have one more. And that is, with Trump's renewed push to end birthright citizenship, through executive action, how feasible do you think it is going to be under constitutional law? And what challenges might arise if his administration attempts to implement such a policy?
I was talking to a friend of mine at the ACLU, which is the American Civil Liberties Union, about this, and they already have the litigation ready to go. Trump will issue an executive order on day one that says anybody born in the United States whose parents weren't citizens or permanent residents are not citizens. By the way, this includes children of H1B visa holders, by the way, are not citizens. And he will order the Department of State not to issue passports. He will order immigration not to approve petitions. and it will be immediately challenged in federal court. It will be immediately struck down because it is contrary to the plain language of the 14th Amendment, which says that any person born in the United States, subject to the jurisdiction or thereof, which means not diplomats. Diplomats' kids are residents, they're not citizens. And that's been interpreted this way for 150 years. There's the seminal case on this is Kim Wong-ark from 1898, who Kim Wong-ark was a Chinese-born person, a U.S.-born person whose parents were residents. That is, they were physically in the United States. We didn't have permanent resident back then. They said, look, he was here. Parents lived here. He's a citizen. Period. End of story. And it's honestly, this is a fringe legal theory that it shocks me that anybody with a soul would agree is a good idea. We fought a civil war over whether somebody born here was a citizen. And it is outrageous that in the 21st century, we're having to do it again. Shame on these people. Truly outrageous. But there will be a fight. There will be a fight. That's why I'm telling clients, if you've got a CLID and you're undocumented or you're having a visa and your kid was born here, get their U.S. passport right now. Get it now and avoid the heartache later or the headache later.
That's a good one. And it's a point to be noted, folks out there. And yes, I hope you have been noting good points throughout this whole show, by the way. And going on. So let's take up a few more from our audience before we leave. And I think RK is back with another one asking, will there be legitimation for H1B about contract for bona fide job at the time of filing? And what is the difference from what is happening now?
Well, you will, under the new rules, if there's a third party site that they're working at, that third party site will be viewed as kind of a co-employer and will be required to comply with all the rules on H1Bs, including posting, et cetera, and wage. It's going to make it a lot harder on these companies. It's designed to make it harder on these companies to do the H1Bs. So yeah, it's going to be much harder. I'm glad I don't have any clients like that. All my clients are direct hires.
But thank you so much for taking that up for RK. And RK, thank you for participating. I wish you could join us on call. I mean, anybody could join us on call. So I'm really looking forward. But yeah, let's go on to Ajay's question. In the RFE, they've asked for more evidence about my employer's ability to pay the prevailing wage. What kind of financial documents can we submit to address this concern?
We already talked about this. This is a question I answered before. Tax
Similar
returns,
one, like yeah,
things like that. So I think it looked like the same one, but tax returns, analysis of tax returns, profit from the previous year, current employment with the company, assets the company has that they could liquidate. All those. If it's a closely held company, you can look at if it's an individual. We had one recently. We won where it was an accounting firm, and basically it was a sole proprietorship. So we used the sole proprietor's income to show that he could afford to pay somebody to do that job. And it explained that now that they won't have to do it, so they'll make more money. So it's kind of, again, requires a level of skill that you get when you've been practicing law for 40 years that you don't get with a brand new lawyer.
Mm-hmm. All right, all right. Thank you so much for taking that up. And let's talk about Elon Musk's, given that his influence on the technology sector, how do you think his involvement in the administration is going to affect policies on high-skilled immigration visas, whether it's H1B or STEM-related pathways?
He will be the contrary to voice to Stephen Miller, telling Trump, don't cut out STEM, don't cut out H1Bs, don't do this stuff. But Stephen Miller is going to win that argument. Just is. You have to understand that. Stephen Miller is like a son to Donald Trump, an evil son, but a son nonetheless. Musk will quickly lose focus, and he'll go on to the next thing. But while President Musk is still around, I guess we'll see what he does. But again, I don't see him really affecting policy in a positive way. I don't see it. He's a chaos agent. That's what he is.
Okay, let's see what's going to happen. But I know what you mean. I think it's always most of the time contradicting with many others in Trump's team, right? So let's see what happens. So
True.
what legal challenges? Sorry.
I just said true. It's absolutely true.
Yeah. Yeah. So, what legal challenges do you see if Trump seeks to implement similar policies as before? We've been speaking that it's going to happen nonetheless. So, with regard to existing federal court rulings against such measures, If you can just
Well,
tell us about.
actually, we're kind of. I mean, I litigate a lot. I was a part of a number of teams that litigated last Trump administration. There's a recent Supreme Court case that makes our litigation easier. There used to be a Supreme Court case that said that if an agency makes a policy, that the court should give deference. Should say, you're the experts. I'm not. I'm going to uphold it. That was overturned last term by the Supreme Court. So it is now much easier to challenge policies of the federal government. And I'm actually looking forward to litigating in this context, because I think you have to understand, we won virtually every case filed against Trump. Virtually every case we won. And I would say of the 300 cases we filed when he was president, I think we won 299 of them. We won almost all of them. We will win all of them next time. Because while these guys are, these nativists have a vision of the way they want America to be, our laws don't let them do it. And so we will bring declaratory judgment actions, challenges under the Administrative Procedures Act, and for delayed cases, mandamus cases, and we will win them.
Yes.
And nothing's better than beating Trump at court. Nothing's better.
Okay. Looking forward for a lot happening in 2025 is all I can say. So, how do you expect, the potential for litigation to evolve with regard to Trump's immigration policies, especially if they are perceived to be restrictive or discriminatory?
As I said, litigation is going to be awesome. We'll be litigating all these issues. It will not, what's one thing about Trump that's happened that's really important is he's created a cadre of immigration litigators that it used to be like 5 of us in the whole country that litigated these cases. There's hundreds now, hundreds of experienced, qualified litigators. We're going to bury these people in lawsuits. We're going to become the sand in the gears to slow down the deportation machine. And we're going to do that under the law, because we're going to make them follow every jot and tittle that exists in the law to protect immigrants in the United States.
For sure. All right. So I think I have a few more questions. But before that, we should address one more from the audience. Sudhir. All right, so let's take up this last one then I have, and that is, what strategies can immigrants and their families employ to navigate any changes or uncertainties that might arise under Trump 2025 administration?
Well, don't be traveling outside the United States if you're from a Muslim majority country on January 20th. If you're from a Muslim majority country, you should be in the United States on January 20th if you want to come here next year, because that's going to be litigation. If you got kids born here, get them passports. If you are in the United States on a visa, make sure you're meticulous in making sure that visa is extended early at the 6-month mark to make sure you're always in status. Make sure all the lights work in your car so you don't get pulled over for a reason that cops make up that your lights are out. Simply live a perfect life, because that's what the Trump administration will want you to do to avoid you being deported. You don't want to end up in an immigration jail cell. That is a really depressing note to end on, isn't it? And be happy, because people like me fighting for you.
For sure, yes. And you can find Trump's telephone number scrolling on the screen, 404-949-8154. And you can email chuck@immigration.net. So, folks out there, I think it's a wrap for now. I'm so excited that the holidays are coming up. It's the Christmas season. So, here's wishing you, Charles, and your family out there a Merry Christmas, and, of course, a great end to 2024. And also to our viewers, if you have anything to say before we go, Charles.
Oh, well, again, we want to wish everybody an extraordinary Christmas season. It is a great time of year to remember the great blessings that we have with our family and our friends. Enjoy this time together and be prepared in a week, in 10 days, to begin the fight again. Have a Merry Christmas and a Happy New Year.
Thank you so much, Charles, for that very sweet message. And here's saying bye for now. And I'm hoping to see you in 2025. And I think by then there'll be so much happening. So there'll be a lot to talk about. So I'm looking forward for it already.
Have a happy holiday. Bye-bye.
Happy holidays. Bye-bye. So thank you so much, everyone out there, for joining us today. It was great having you. Please do not forget to like, share, and subscribe to Immigration and Jobs Talk Show. We are on YouTube, LinkedIn, Facebook, and on X. And also, you can call me, write to me if you have any queries, and we can direct your questions to our attorneys. And my number is 408 335 6444. And you can also email me. My email address is nipa@staffingly.com. Thank you so much, everyone, and stay back. Watch out, Immigration and Jobs Talk Show, because we have so much awesome content that we have shared with you and a lot more coming up. Bye bye for now.
Grab a water while you do the intro.
Hello, everyone, and welcome to Immigration and Jobs Talk Show. I'm really happy to have you all join us. And I'm Nipasa Pradhan, your host for today. Before we go on to today's discussion and we have our guest for today, I want to read out this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks out there, thank you so much for joining us today. We are streaming live right now on YouTube, LinkedIn, and on Facebook, and also on X. So, please feel free to join us by commenting wherever you're watching us, and I will definitely tell you what is today's discussion going to be. But yes, for most of you all, thank you so much. It's been great that you join us, in these webinars. But we would love it if you can also join us, on call, conversation with us and of course our guest. And you can do that by dialing this number 425-436-6335, and the access code is 988-888. So once you're in, you just say hello and we will be able to hear you. So, yes, today we are going to dive into this. One of the most anticipated updates in immigration policy. I think, it's been a while that we have been anticipating this, wanting this to happen, and it's finally happening. So, modernizing the H1B program. This is a critical topic for both employers and also workers, as the Department of Homeland Security, that is DHS, has announced significant changes and has aimed at improving flexibility and efficiency in the H1B visa process. So, we are going to discuss in details today about this. And joining us today to break down these updates and discuss their impact is none other than Attorney Justin Rivera, who is an immigration attorney and an expert in employment based immigration law. Thank you so much, Justin, for joining us once again. Really good to have you.
Yeah, thank you for having me, and an early Merry Christmas to everybody.
Absolutely. He's wishing you too a Merry Christmas. I can see it's looking very festive out there at your home. So here's wishing you a good one, to your whole family out there.
Thank you.
And also to yeah, and also to Wasden immigration litigation. I think I should wish them all.
Thank you. Yeah, appreciate it. Looking forward to the time off.
Absolutely. So, Justin, I mean, today's discussion on this topic, modernization, the modernizing the H1B program, and what to expect and how will it impact your business. So, could you tell the folks out there what can they expect from our episode today so that they stay with us?
Yeah, I mean, in terms of what this does for us going into next year, I think it's a very important changes. I mean, some of the stuff is going to be good, as I'll highlight, but some of the stuff, well, I think a lot of it is good, to be honest. So a lot of it's good, some of it's bad. One aspect of it is probably going to be very bad for specific types of employers. We'll dive into it. A big point to point out on this is the regulations themselves actually go into effect on January 17th. And a question that's already on everyone's minds is, after these regulations go in and are codified and the administration changes, are there additional changes made? Is there anything that's pulled back? How would that happen? So the impact of them is TBD. We will have to kind of see what the impact is in Congress with what the new administration wants to do. But for now, this is the playbook. This is what we're going to have moving forward and what we're going to be dealing with. And like I said, some of it is pretty beneficial. There's stuff in here that I think is very helpful, specifically for beneficiaries. Some stuff that's really great for employers as well. Then there's some other stuff that I think is going to make third-party placement more challenging going forward. And then there's some other stuff that's, honestly, it's problematic from my opinion. And I think that you might end up actually seeing litigation on it, if not on some other aspects. But we will do, as deep a dive as is permissible within the hour on all of these aspects. And hopefully everyone comes away more informed and prepared for when these regulations begin their implementation.
Absolutely, Justin, and I'm sure we are all looking forward for this to happen. I mean, long time, right? People have been wanting changes, especially with the H1B visa system. So, yeah, we will dive right in. But before that, hello to you too, Rag. Thank you so much for joining us on YouTube. He says hello, Napasa and Justin. So, also Trisha, hello to you. We are going to address your questions. Just stay with us. So, Justin, my first question to you would be if you could explain, how the DHS rules strengthens U.S. employers' ability to fill jobs and what impact it could have economy.
So, I think at the end of the day, there are certain aspects of this that are great, because I think it's going to modernize and provide clarity on a system that is, for better or worse, overseen by people who are officers who are in service centers that are 9 times out of 10 making decisions that are based off of limited training materials or prior experiences. One of the biggest things that I think is going to be beneficial is the definition of specialty occupation kind of being updated. To point out this, basically what they've said now is that a degree requirement normal does not mean always within the criteria. So right off the bat, what we're establishing here is a specialty occupation can be a position that typically requires a degree in a specific specialty. It doesn't always have to require a degree. Immediately, what that does is create a more expansive definition, which in turn should make it more simplistic to adjudicate that a position is a specialty occupation. Another thing that was great that I saw was that the petitioner can accept a range of qualifying degree fields to qualify, but they must be directly related to the position. And what they mean by that is there has to be a logical connection between the degree and the duties of the position. All of that is great. I think that is very beneficial. What that does is it shows me that when the service is adjudicating these cases for specialty occupation, they are saying, okay, does this position require a degree? And are the degrees that the petitioner says are required, do they make sense in relation to what this person does? Now, does that mean that someone who has a bachelor's degree in, basket weaving is going to be able to qualify for a position as a computer systems analyst? No, There's no logical connection there. But what it does is it allows for a logical expansion of those fields to where it makes sense. And what I mean by that is this. In the previous administration, when the Trump administration was first in, there were denials that were seen for IT related positions where they basically curtailed it to such a narrow view that they basically said, if you don't have a degree in computer science, you can't do this job. You can't hold this position. And modern day, that's ridiculous. Obviously, people can do those types of jobs based on their degrees, even if the degree has a mild variance to not just being computer science. So this opens that door, which puts us in a situation where hopefully the adjudications for specialty occupation makes sense. And so when there is a case that's denied, there's a rational explanation as to the justification for the denial that isn't something as simplistic as you can only hold a degree in X to qualify. So I think that's good. I think that that's going to help people moving forward. Another way that I think that you're going to hopefully see companies benefit is the codification of deference for prior approvals. What that means, just in a non-legalese way, is if you were on an H1B and you're filing a new H1B and there's no big change, you should get your case approved based on the deference to the prior approval. Absent a material change or some new evidence that USCIS did not have at the time of the previous adjudication, it should almost be a rubber stamping. So what that means is, obviously, we know there's a significant visa backlog. There are people who are on H1B now or have been on H1B for several years that are probably going to continue to be on H1B. If they are remaining with that same employer and they're not having a significant alteration to their petition, their extensions should just be streamlined, which is great. Again, we don't know what the impact of that's going to be from the new administration, but in theory right now, that should be what we see. Other small things were the itinerary requirement has been completely removed, which is great. I don't think it was something that was really given any consideration now anyway. The acceptance of matter of semio solutions, without going into too much detail, basically really clarifying, when you need to file an amendment versus when you don't need to file an amendment. That's great. Entrepreneurs saw a huge win for them in that, they are codifying the ability of company owners to sponsor themselves for H1Bs. So that's a big benefit as well. And then there's some other stuff as well that we can kind of get into that's more beneficiary centric. But I think overall, those changes are going to help companies make it easier to bring people in on an H and keep people on an H.
Right. And these changes are only effective from January 17th. So people who have applied before that date, it's not going to affect them, is it?
It should not. There should not be any impact from it until that 17th date, range of implementation. Okay. Inevitably, when there is changes, though, you're going to see a period of transition where things are weird, because attorneys, we play within the rules that are provided to us, but a lot of what we do is related to precedent. What have we seen before, and how do we use that information moving forward? So you may see some weird RFPs come out initially as both the petitioners and the officers begin to kind of play within the rules of the new changes. But I'm hoping, at least for these perspectives, it'll be a positive change.
Absolutely. So we'll quickly take up Rag's question. He's asking, the H4L2 bundling with H1L1 ends on January 18, 2025. Will this affect first-time H4 or L2 applicants, with regard to, I guess he's saying, I-539 and I-765?
So this kind of is a remain to be seen thing. It's not. I don't necessarily think you're going to see an uncoupling of the adjudications. I would wait. I would wait and see what happens closer to the actual end date of this administration to see if there's anything else that's put out or provided. I will definitely say this, as I've spoken about before. I think a big idea of the new administration is going to be delaying things where they can to make processes more difficult. And one of the easiest ways that they can target that is by splitting the premium process benefit for the adjudication of H4s and L2s. So it wouldn't shock me if that's something that we're dealing with. But to go the other way, there is a rational benefit to USCIS in keeping the policy in place, especially when you look at it when it's coupled with the idea of the deference that's going to be provided to previous extensions. I think that if you just are already going to approve the H and you can approve everything else together in unison, you get the case out. And for the officers that are trying to work through large caseloads, that's probably going to be a big consideration for them. So I would really say I would wait and see. Yeah, unfortunately, the first-time filers, that's going to be a problem, right? Because for work authorization, there's already been guidelines put in place that, help people retain work authorization, even though their I-765 is still being adjudicated. And those L2 and the H4, they each have their own classification for that. So people with extensions, they're going to be in a better situation than people it's a first time. If it's a first time and you're looking at the complete unbundling, if you're applying for an H4, you're going to have to wait. And you're going to have to wait and look at those process times. That also being said, I wanted to sneak in at some point during this conversation that I did see that the Vermont Service Center has announced layoffs recently. So they're going to be laying off people, which is going to likely slow down processing even more. So I think that that's something to work into the calculus as well, which how you explain to me that an organization that can continually raise fees has to lay people off, don't really understand. But, I don't understand their business model in the first place. But yeah, I would definitely say, to answer your question, if they do actually put the kibosh on the unbundling, first-time filers aren't going to be in a great situation, because they're going to be kind of going back to how things were, in the late 2000s to early 2020s, where you're looking at those 5, 6, 7 month delays.
Right. Thank you so much for taking that up for Rag. And Rag, thank you for participating with your question. We would really love you to join us on call. Why not call us on this number, 425-436-6335, and the access code is 988888. And this goes out to all the viewers out there, including Ravi, Trisha, and Rag as well. So Justin, let's move on to my next question to you is, how does the modernization of the H1B visa program redefine specialty occupations, and what does it mean for both employers and employees? You said this a little bit in the introduction, but if you could elaborate a little bit.
Yeah, so kind of, piggybacking off of the first my previous, statements, the expanding the definition so that you're not really nailing yourself to one specific degree type for any sort of position or field is fantastic. It's definitely a positive. So that should be helpful for employers because it's going to give them an easier roadmap to showing that a position's a specialty occupation. Our company normally requires a degree to do this, and these are the degree fields that are related. As long as there's a rational basis between the two, should be able to move forward without too much of an issue. So that's the good part for the petitioner. And the good part, I think, for the employee is it gives you a little more wiggle room in terms of what it is you're doing and how you can qualify for the H1B. Because we also got to look at it from the prism of this. The components that USCIS is analyzing are supposed to be, is the position a specialty occupation, and does the individual have the requisite work experience or degree or combination required for the position. And so I think that helps the employee now, because you're not stuck with the idea that you just have to have a degree in, let's say, computer science in order to do an IT related job. Where I think that the modernization is problematic is in related to third-party placement for the specialty occupation definition. There is language included within this new guidance within the regulation that basically says if someone works at a third-party location, the third-party must be providing work that is in a specialty occupation. And as a result of this, the idea is that the third party's requirements for the position are most relevant in determining whether or not the position is a specialty occupation. So I can understand the logical conclusion from this, which would be, okay, yeah, if the person's working at Sears, Sears has to require a degree, in order for the person to do the job. Otherwise, it doesn't make sense that it's a specialty occupation. That's the logical thing. Here's the problem with that. Third-party placement requires you putting someone at a client location. That client is not bound by the same conditions as the petitioner in order to service the employee. The reason why they have a contractor is they don't want to deal with having an employee. So the first issue becomes, is the client even going to furbish that information as part of the process for the petition? Like let's say, for example, an H1B employee is working at Apple and they move to Google. Well, part of that is you file, an amendment to move the person to Google or Apple or whatever. Is the manager of the project going to immediately issue a letter from the company on company letterhead saying, yeah, this is a position with our company that requires a bachelor's degree in XYZ, and turn that over? Or are they going to say, yeah, I'm not giving that right now. Get him over here and let's start him working on the project. So that kind of becomes, I think, the first problem is I think this is a way to almost backdoor the reintroduction of requiring in-client letters, a practice that was definitely used ad nauseum by the Trump administration to deny cases, because let's work backwards from this. If you can't provide the in-client letter to show that the position requires a degree within a specific specialty, then they can deny your case saying they can't establish specialty occupation. So that's one issue that I look at and say that could be problematic. Let's say you even do get the client letter and you provide it to them. USCIS is adjudicating the case and they look at it and say, well, this says it requires a position in X, but I used my favorite tool as an officer, Google, and I went on Google and I looked at the company and I looked at job postings for the company. And the job postings for the company online don't say that this position requires a degree in X. It just says it requires a degree. Well, now they're going to issue a request for evidence and say, well, we can't tell if they actually have a position that's required in the specific specialty. Then you're getting into a fight between them with like, okay, just because you saw something online doesn't mean that it takes away from the evidence that we presented to you. All I'm saying in this is what I don't like about that is you're opening up the door for evidence that has to now be provided that previously wasn't necessary, because it, in my opinion, is kind of outside of the scope of what should be asked for in terms of who makes the decision on whether or not this person's position qualifies. And that, I think, will probably lead to some bad adjudications. And unfortunately, we'll have to wait and see how that is dealt with, because you're going to have to look at what the officer's decision-making is. The benefit, obviously, is that they have to at least issue a request for evidence. But even so, that's not something that I saw that I was a big fan of. And I do think that it could be problematic for employers, any employer that's doing third-party placement.
Right, Justin. Thank you so much for covering that in detail. And you already covered, I think, half of my next question, where I was almost getting to, ask you to tell us about the main benefits, but also if you could highlight and also challenges you've already, highlighted for us. Yeah.
Yeah.
So
No problem. So some of the other things that I saw before, because I'm trying to be positive before I'm negative here. Some of the other things that I saw that were beneficial. The employment authorization expansion for people that is on what's called cap gap. So cap gap is this idea that, if you're on an F1 and you're working and you get an H1B approval and you file an H1B change of status, the cap gap will allow you to remain in the United States and continue working legally up until the date where that person changes status. That's great. But before, cap gap ended on October 1st. So if you were someone who had a change of status that was filed but was not approved on October 1st, you lost your work authorization. You're able to remain in the United States because you have a timely filed change of status, but you can't work. The problem there becomes, if the company can't have you working, then why is the company going to keep you? And obviously there's things that you could say, well, why didn't you do premium? Maybe there's an RFE. All of this is to say it was an issue. which would lead to people basically front loading the adjudication of change of status cases for October 1st, because everyone knew that those people's cases had to be put at the front of the line. What has changed is they have now moved that cap gap authorization all the way to April 1st of the following
of the next year.
Mm-hmm. Yes. And that's a phenomenal benefit, because what it does is two things. It removes the stress from the employee in worrying about having work authorization, and it removes the stress from the service centers in having to front load their review of petitions that are change of status. Hopefully, at the end of the day, it provides a more streamlined process and less issues. Another thing that was really good is they are allowing you to change the start and end date as the reason for a denial if a case is denied and then subsequently approved. And I know you're thinking, okay, how is that much of a benefit? A motion to reopen takes forever. A motion to reconsider takes forever. An appeal. The benefit there is there have definitely been scenarios where someone ends up with a denial and then it's appealed. And then let's say it's on their cap exempt H1B, their first H1B where they've gone through the lottery. Well, if for whatever reason that case ends up getting reopened, it could in theory be denied if the end date had passed. So because of that, you had seen situations where perhaps USCIS had said, yeah, we made a mistake, we're going to reopen the case, but we can't approve it because the end date of the validity period that's been requested on the petition is passed. Now what they're saying is, instead of doing that, what we'll do is, if we reopen the case and the end date is passed, we're going to send you a request for evidence and basically tell you, give us a new LCA, give us your new start and end date, and we will honor it on this petition. So I think that's beneficial. It should be helpful. Will it help a lot of people? Probably not. It's probably going to help a very rare sliver of people. But for that sliver of people who the benefit is they, don't have to go through the lottery again. They have an approved H1B and they can, file an extension and maybe get their perm sponsored. That's a huge deal for them. So I think that that's great too. The other thing that I thought was good was they expanded the definition of nonprofit. Basically, they changed it to say, instead of saying the primary reason of the entity must be research, it's now fundamentally a fundamental activity. So I think what the whole purpose of that was is they want to expand the scope of nonprofits being able to use H1Bs. And obviously, if you're not aware, if you work on an H1B at a nonprofit, if it's a cap exempt employer, that means that you can work there without having to go through the lottery. So that's beneficial. And I do think, from my reading, the goal is they do want to expand the ability for nonprofits to have access to these employees. Because the regulations itself, it actually says, we're not worried about people cheating the system, because we know that this is research is very competitive already. So the fact of the matter is they already want to hire the best and brightest. So let's give them the ability to do that. The last thing is the beneficiaries can be cap exempt even if they're not employed by a qualifying organization, as long as they spend half of their time providing essential work to support a fundamental objective of a qualifying organization. So what that means is, theoretically, you could be placed at a client location as long as it's a nonprofit organization and more than 50% of your work falls within that parameter, and be cap exempt. So I think all of that stuff's great. I think it's very positive, and I'm very hopeful that it will be used in the best way possible, and that there's no one trying to do anything untoward or fraudulent to, get within that nonprofit parameter. Just the entrepreneur stuff. I apologize. I feel like I'm running on time so fast. The entrepreneur stuff. Yeah. The fact that entrepreneurs can now, sponsor themselves for H1Bs. That's a positive too. And that it's been established before, but now it's been clear cut. That's great. The bad stuff, bona fide employer. It seems like they've basically changed the definition of employer-employee relationship to bona fide employer. Under the guise of bona fide employer, they are attempting to reiterate the idea that contracts or similar evidence to confirm the position is bona fide are required. My reading of that is if you haven't already, be ready if you're a third-party company to be asked for contracts and work orders between everyone in the succession of contracts. So if you're going from petitioner to vendor to end client, they're going to say, give us everything in there. So will that stand? I'm not sure. We'll have to see, but that's not something I like. A random one, petitioner needs to be have a legal presence in the U.S. and be amenable to service of process. I think that's clearly coming off the basis of they want to try and hit employers for fraud. And in order to do that, they have to be able to go after them. So they want those people in the U.S. A thing that I didn't like about the beneficiary ownership, the initial approval can only be 18 months. And the first extension can only be 18 months as well. What that basically means is they want you to prove to them that this is legit, that this business is legitimate, probably that it's growing, bringing in revenue, bringing employees. I would say it would not shock me if we saw a lot of denials between the first approval and the first extension, meaning that first extension, I wonder what they're really going to look at to show that you qualify for the second 18-month extension. We'll have to see. Lastly, before we move on, we can talk about this in more detail later, but I know I am going over on time. The really bad aspect of this is the codifying of site visits and noncompliance. Before, site visits were they were not mandatory. They were, you choose whether or not to participate in the site visit as part of the program. Allegedly, under this, they're now saying that you must comply with site visits, and failure to comply can actually lead to a denial of an active petition or a revocation of a prior petition. This is different than before, and it's going to have to change how everyone looks at things. But I'm going to come out and just tell you guys right now, because the language was in the regulation. The language within the regulation clearly states that based on their data, non-compliance rates were found to be higher for workers placed at off-site or third-party locations as compared to workers placed at a petitioner's on-site location. They have initially claimed that close to 19% of their investigations have yielded a fraud finding. And that's non-compliance. That's where people are able to opt out and not participate. Now that the participation is mandatory, coupled with their already stated conclusion that more fraud is committed at third-party placement, it will be open season on third-party placement. That's going to be a huge part of, I think, regardless of the administration change moving into next year. It will be a huge thing. So, as I've said before, and I'll say again here, you really need to make sure that you're ready for that and that your employees are ready for that. But yeah, that's pretty much it in terms of what everything is, as kind of an overview of what's good and what's bad. There's some other small stuff in there that I'll try to get to, but I think those are the big points to highlight of what will be beneficial and then what will be challenging.
Thank you so much, Justin. I mean, that was a detailed coverage, and I think very important points that you've highlighted. And folks out there, thank you so much. And if you have resonated, please let us know in the comment section. And also, you can join us on this conversation by dialing the number that's displayed on the screen. And so Justin, let's go on. And I have my next question, and that is, what are the conditions under which H1B holders with controlling interest can qualify, and how does this impact their ability to start or lead businesses in the U.S.?
Right. So this is again one of those positive things. Essentially, they're saying that individuals who are beneficiary owners, and a beneficiary owner is someone that owns a controlling interest, which they have defined as more than 50% or a majority of voting rights, it's permissible for that individual to sponsor an H1B for themselves. The purpose of this, as stated in the regulations, is they want to give entrepreneurs the opportunity to essentially open new businesses in the United States, because opening new businesses should lead to job growth, right? You open a business, you hire employees, that job growth helps the community. So that's their basis or point. What is interesting is, and they even admit in the regulation, is there's still a further need for guidance kind of on how you qualify for that specialty occupation as the owner of the company. I think there's language out there right now that says something along the lines of more than a certain amount of your duties, maybe it's 50%, qualify within that specialty occupation parameter. But what that might lead to is a bit of confusion over what kind of positions are and are not a specialty occupation. I mean, I think obviously if you're going to be running a company that has 10 or 15 employees, and you're doing high level, let's say IT work or healthcare work or something of that nature, you're probably going to be able to show that you require a specific degree. The things that might be more complicated are the more recent technological developments, like artificial intelligence, things like that, where there's not as much prior guidance to show whether or not the person qualifies. So we might see pushback on that with RFEs, but I'm not super worried about it. At the end of the day, I definitely think it's beneficial. I think that it's great that this is done. And I think that it should lead to people, doing the sponsorship, being able to be on an H1B while having the organization, while beginning to start up an organization, and it should be helpful. As I said before, my only caveat to it is only approved for 18 months, and the first extension is also only approved for 18 months. Most people know this. A lot of businesses fail. That's just, how it is. You start a new business, you're not able to generate revenue. The business isn't going well. The business goes under, whatever. Only giving someone 18 months to then establish that the company should continue because, it's experiencing growth or whatever. I am a bit hesitant as to what those adjudications are going to look like, because I don't know what it is that the service centers are going to think shows that the person qualifies for the extension. Now, let's look at deference. If we're still implementing the idea of deference, the original petition and everything's the same for the extension, should the extension be approved? The thing about it is, you can see by looking at the language that the reason why they have these short approval notices is they want to deal with fraud. They want to stop the idea of someone saying, I'm going to create a company for myself because really I just don't have a job available and I'm on an H1B. So I'm going to start, Jay's Consulting Inc. and open the company and file. And now I'm going to be back on an H1B. And once that time's done and I find another employer, I'm just going to file it. Because that's not the underlying purpose of this. The purpose is to have people open legitimate businesses. So I think overall it's great. I think that people that fall into this category of controlling interest, the more than 50% of majority voting rights, they're going to be able to successfully get these H1Bs. The thing I'm really interested in looking at, though, is what ends up being the approval rate of those initial extensions.
Absolutely. I think we all are looking forward, and I really hope that these changes are going to benefit most folks out there. And we also hear that people who are going to be paid more, like they're going to select people on wage levels, right? If they are going to be paid more, they're going to be selected first. Is it going to be like that, Justin?
So, here's the thing about when you're talking about the wage levels for the H1Bs. There's this idea floating around about in the lottery, kind of applying a weight to what a wage is going to be. Saying if you're filing a position at level 3, then you get accorded more weight than somebody whose position's at level 1. I haven't seen the actual implementation of that coming down the pipeline. I also think that it would be much harder to do because the way the system's set up now for the lottery is it's beneficiary centric. And what that means is you enter a person in, and no matter how many times you enter that person in, their number rate is 1. It's always 1. So 7 petitioners can sponsor for a person, but the person is the person for the rate of selection. It's just 1. How does that work if you then bring in a weighting system with the levels? Are you saying, okay, we've selected 1 who put the highest amount of money, and then you go to the person that has the highest amount of money? I'm not sure. And the other thing with that is what happens with actually making those changes within the system. Now, before, all you have to do now to register, very easy. You create a petitioner page, you enter the beneficiary's information, you sign, you pay the $10. Or actually it's going to go up, right? So the amount's going to go up now. But you pay the amount. Now you're adding in a labor condition application. So now the LCA is going to have to be certified. You're going to have to know the position and where the person's going to be working. And remember, they can't start working for your company in this position until October 1st. So you're adding in a lot of calculus to a system that's already kind of rudimentary. And they've already come out and admit they've admitted that the way the system is now is working. They actually came out and said, we're not really trying to mess with this. It's worked. Registrations went down last year. So we think the underlying goal, which is to remove the fraud that was taking place, is gone. I'm not sure they would then subsequently go back and then tack on new issues. Now, where you could see wage levels as an issue is in their relation to qualifications for a specialty occupation. And what I mean by that is we saw a lot of in the previous Trump administration of it's the level 1 wage issue. Basically, the argument coming out saying, if it's an entry-level position, how is it a specialty occupation? How does it require a degree? And I think that's where you saw people basically start to say, we don't want to deal with that issue, so we're just going to put the wage up. We're going to go up to level 2 or up to level 3. And because we don't want to mess around with level 1 at all. Could I see that coming back in a big way? Absolutely. So I definitely think that that's probably going to be something where if you're a petitioner and you're filing a level 1 wage for someone on an extension, someone that's already been with your organization for 3 years, and you're saying they're still a level 1, they're going to stay there, that could be an issue for you. The other thing would definitely be, looking at someone who's in a position where they manage or supervise others, people that create things. If you're creating technologies, I don't know if you can be level 1 and create technologies, or they don't at least, and then you have to prove it to them. So that's where I think you'll probably see that come in more. And then who knows with the next administration, if they want to come out and figure out a system, devise a way to increase the wages further, then we'll have to wait and see if they do.
Okay. Thank you so much, Justin, for addressing that and for the detailed explanation. I think we should address some of the questions from our audience now. Rag is back with another question, so let's take that up first. Does USCIS still use Dun and Bradstreet data, and how imperative is it to update location details in DNB?
Yeah, I don't really know. I mean, it's probably a tool that they still can and may utilize. So I would say for those that do, continue to update it. Yeah, but it's not something that I have readily available off the top of my head. But I would just definitely say if it's something that you have been using already as a tool, just continue to use it, and expect if USCIS has used it with you previously that they will prospectively.
Okay. Now let's take up Amay's question. Hi, Amay. Thank you so much for joining us. Let's take it up. I am on H1B and working as a contractor. My spouse is on H4 EAD and she's working for another client as FTE. My current client has offered me the FTE role. If I switch to a new employer, will it impact my spouse's visa status? Please let me know.
Yeah, so generally speaking, no, it won't impact her. The F4 or the H4, the H4 is conditioned upon the maintenance of the primary status. What that means is the H1B holder, has to maintain their status, and by proxy of that, the H4 holder is able to show that they qualify as long as they meet the underlying guidelines, and that's if you're a spouse, marriage, that can be proven. So if you move to another employer and you're still maintaining your H1B, it shouldn't be an issue. There shouldn't be any problem with transferring. Now, here comes the issues associated with that, though. Just off the top of my head, when you move to when you move your H1B, you transfer to another employer. Your period of approval, your validity period, is going to change, right? Your validity period is no longer going to match your spouse's because your spouse's validity period was subject to your previous H1B. What that means is you have to be mindful of the fact that when her H4 is set to expire, she needs to file an extension, and it's going to be an extension that's probably well before your extension. So that's issue one. Have I seen that be a problem? Absolutely. I have seen people who come to file their extensions that have moved to an employer, and that H4 has been invalid for 6 or 7 months. But they didn't think about it because they just thought, okay, the H1B transferred, we're fine. So that's one thing to think about. And also to think about as well, if you're filing that transfer, maybe just file an H4 with it as well for her, just so that you guys have those same validity periods for your approval notices. So that's one thing to consider. The other thing to consider is this. In very rare circumstances, so, I can't do an exact percentage, but very rare circumstances, I've seen where someone moves to another employer with a transfer, that the H1B employer is going to withdraw the H1, right? Because they don't want you're not working on it anymore. In very rare circumstances, I have seen that H1 withdrawal trigger the H4's withdrawal. And basically what happens is USCIS says, well, that H is no longer active, so the H4 is no longer active. That's wrong from a policy perspective, but in a legal perspective, it's wrong. But here's the problem with that. You have no grounds to attack a withdrawal. If an H4 is withdrawn, it's not like a denial. There's no appeal. There's no ability to reopen or reconsider. Withdrawal is withdrawal. It's gone. It's done. So you have somebody who's moved to another employer and started working, and then they or their lawyer receives a withdrawal for the H4, and they're like, why did this happen? Well, now you're in a position where you have to file a nunc-pro-tunc H4, basically saying you should forgive my time out of status because you guys screwed up. Is it going to get approved? Probably. Why wouldn't the government approve it? I mean, they're the ones that screwed up. Is it going to get approved? Great. But what about the problems associated with that? If your wife's working with an employer and she's no longer in H4 status, is the employer going to come back and say, hey, you can't work with us, you're fired? You know? So avoiding that issue is just, again, filing the H1 and H4 together and just filing it for peace of mind. Is it necessary 100%? No. Can you do it just to avoid those two scenarios? Yes.
Okay. There you go, Amay. Thank you so much, Justin, for taking them up. Amay, I hope you got your answer. Well, Rag is back with another one. When is FDNS visit done for L1H1, and is it on time or periodical? One time or periodical?
So, yeah, I will say, Raj, I'll answer your question, but I do want to say if we could get to Trisha's question as well, because she had asked one at the very beginning, I think that maybe we could get to that too and speak with her as well. But
yes,
okay,
so sorry, Trisha, for leaving you out and your
it's okay.
question out.
She got in at the very beginning, so I want to reward
Yes.
that participation.
Let's take it up. Yes. Our company
Okay.
heavily relies on H1B employees for specialized roles. So, if the program becomes stricter or more selective, how should we adapt our hiring practices to ensure compliance and still get the talent we need?
Yeah, so I mean, like I said before, I don't think that the way that they've changed specialty occupation, the definition is actually harmful. I think it's positive. I think it's beneficial. The way that I don't like it is obviously the notion that if you place someone at a third party, that third party has to make the determination that the position qualifies for specialty occupation rather than the actual employer. But that being said, I think regardless of that, you're still going to see an administration change where the new administration is going to come in and try to tighten guidelines, even if they've been changed. My thought process for that is this. I would probably, if I could do whatever I want, if I ran a company that hired H1Bs and I wanted to ensure my continued ability to hire people in specialized positions, what I would probably do is make sure that your hiring practices are up to date with compliance for the definitions of specialty occupation. So what does that mean? Well, when you make positions publicly available, you post them, right? Most of the time when they're posted, you can access them on the internet through, LinkedIn or Glassdoor or anything like that. I would consider ensuring that those requirements for the position show that the position requires a degree in a myriad of fields, maybe going as far as to listing some of those fields. You could maybe tack something on like, this is not an exhaustive list of the position of the, fields that are acceptable, but are the position or the fields that most likely align with the position, something like that. Long story short, doing that kind of gives you the opportunity to say at the outset, like when we're hiring, we're only considering these kinds of degrees and people with degrees in this field, because that's what we know is needed for the position. So that's one thing I would do. In your hiring practices proactively, I mean, if you already hire people with degrees and you're continuing to do so, you should be fine, because one of the ways you can show evidence of specialty occupation is showing that similar individuals within your organization hold a degree in a specific specialty. If you're able to produce that evidence and show, look, I have 17 programmer analysts. All 17 of my programmer analysts have degrees that are logically related to the roles that they're performing. I'm hiring an 18th programmer analyst. Makes complete sense that, you're showing that requisite requirement. So I think those are ways that you can do that. And I mean, honestly, if you have the ability to do so, I would just start doing it now. You have a little bit of time and opportunity to do that. So I would say prospectively try, and hopefully that aids you in the event that you're, filing in the future and you're having to deal with an RFE or a notice or whatever. Sorry, I dropped something.
No worries. But yeah, thank you so much for taking that up. And Trisha, thank you so much for your question. If you have more questions, you can keep commenting. Now, if you can, let's go on to some of our questions we have. But if you would like to take this by any chance.
Yeah,
from
absolutely. Raj, thank you for coming back, man. FDNS done for L1H1, is it one time or periodical? Mostly it's going to be one time. And I say mostly because unless they have a real reason or justification to make another visit, they're gonna try and empty the clip on the first one. So they're going to want to try to go and procure as much information as they can in person, and they want to physically talk to you and get whatever information they can. The regulations are basically kind of saying when they talk to people now, they want to talk to the person, they want to talk to the person's manager. So already they're with these new regulations, they're saying, well, not only do we want to talk to you, we need to talk to your manager. And if you're at a third party site, that means we need to talk to the manager at the third party site as well. So right out of the gate, they're basically saying, you're not heading us off by just saying, just talk to me, or just talk to my attorney. They're going to say that these other parties need to be involved as well. Now, does that remove the ability of you to have an attorney handle the answers for you? No, it doesn't, because you can have representation. So I would still marry myself to the idea that if you are a party to a site visit and you are someone who employs people on H's and L's, you need to make sure they're trained, and you need to make sure they know what to say and that they want to move things first off to a record, a platform where there's a record, meaning, either you can do a call that's recorded or you can go on email, and that you want to have representation there. The reason why I say that is I have seen a decent amount this year of officers who have formed conclusions based on statements that the employees are saying they did not make, or they are based on statements that do not align with what they were intending to say. But you have to understand these FDNS officers, and I will say this until I am blue in the face, their goal is to find fraud. They want to find fraud. They're not coming to be your friend. They're not coming because they're just doing their job. They want to find fraud. The more fraud they find, the more they justify the existence of their job. So that is their purpose, to find fraud. And so the reason why I say, involve an attorney and get things on record is you want to make sure that everything has been properly done and all the information that's been provided is legitimate and related. I'll give you a perfect example right now. We just engaged with a company who was completely compliant with the site visit. They provided everything to the officer up front. They provided the additional documents that the officer had emailed them for the first time. And they even provided documents for another employee who was allegedly not related to this site visit at all. Just another person they threw in and said, hey, while we're here, give us this guy's docs, right? In no way related to the petition. They engaged us because the officer has now come back and asked them again for not only the information that they provided, not only the information in their statements, not only the information for the additional person. They now want a list of every employee in their company, every project that person's working at, the wage the person is making, the person's supervisor at the third-party work site on the form, on a detailed form, along with all of these people's approval notices and all of their labor condition applications. So why am I telling you this? The purpose I'm saying is this. If you don't push back against FDNS officers and say, okay, that's enough, I've given you everything that I need. Or if you don't at least know your rights to provide what is and isn't actually necessary, they will take everything. They will take everything available to them. And I'll tell you this, if they provided that information, those documents, they will turn around and subsequently investigate every person on that list. And you got to remember, the purpose of this FDNS site visit is supposed to be related to compliance with the petition at issue. So that's one person's petition in relation to one H1B that has now been extrapolated to include every employee on a non-immigrant visa for the organization. And what I mean by that is not just your H's, your L's, and your F1s, the whole organization. And that's a company that was complying at a timeline where they don't have to comply. So imagine what that's going to look like next year when instead they're going to say, well, I'm going to threaten you with noncompliance and just deny your case.
There you go, Rag. Thank you so much.
It should be one time, but what will not be one time are the amount of email correspondences that the officers will subsequently send you.
Mm-hmm. There you go, Rag. You have your answer. Thank you so much, Justin. And we have a couple more questions from our, on YouTube. So let's take that up. Control, if you could display, please. So this is from Harsh Bansal. This is asking, hi all. My wife's H1B extension was approved last month, but we haven't received the original sorry, 797 approval notice. So her employer provided courtesy copy I-797C. Can we use courtesy copy for the Dropbox appointment in India? We need to travel urgently next month. Really appreciate the help.
Yes, you can. I think that the old school practitioners would say that you must carry the original copy with you. That's not necessarily the case anymore. You can use a copy both at your appointment and when entering through CBP. At the end of the day, we're in a digital world. All the information that they need is already accessible. You're not going to really be able to pull a fast one on them by presenting a copy that's somehow fraudulent or been marked in a way. So you're fine. If at worst, if you're asked about it, explain you never got the original, and you should be okay. You can always request another copy. Thank you, Raj. Happy holidays. You can always request a duplicate. You do have to file for it, and it does cost you money. But if you want peace of mind, you can do that. But at the end of the day, you're completely fine with using a copy. As I tell people often, the only place that I have dealt with pushback lately with originals is the DMV. The whatever department within the state that issues driver's license. For whatever reason, sometimes they push back and say you need the original.
Okay. Thank you so much for taking that up, Justin. Now let's go on to our next one. Control, if you can display our next question. How long does it take to get a receipt if I have filed an H1B transfer in premium processing and new employer sent the FedEx on last Friday and it dispatched this Monday, still like 5 days and they don't have a receipt number?
So this isn't completely surprising. As I said earlier, the Vermont Service Center is going through layoffs. Other service centers are going through layoffs as well. If you filed your case right now, it's the holidays. A lot of people are taking vacation time, which lowers the numbers of officers that are available. So yeah, I wouldn't be shocked if you haven't received the receipt yet. Here's the thing with premium. You get a digital courtesy copy that's going to go to the email address that was provided in the petition. So if you G28'd, then that's going to be the attorney. If you didn't use an attorney, it should go to whoever the signatory for the company is or whatever email address they put on there. So you should be getting something. 5 days is a little vague. I want to be clear. 5 business days matters. 5 days that includes a weekend, you don't count that. That's not part of the calculus. So remember that when you're thinking about this process. If you sent a case on Thursday and it got there I sent it last Friday. Sent FedEx on Friday and it got there on Monday. Oh, sorry. So you did answer. So it has been there for 5 days. So yeah, 5 days is pushing against a long time to not get a receipt notice, but it's not entirely surprising. I would maybe check and see if you did get a courtesy copy. If you don't have a courtesy copy yet, do this. I cannot stress enough. Easiest way to make sure your case was accepted or not if it's been a while. If you filed with checks, see if the checks have been run. If the checks have been run, you're good to go. It means USCIS has accepted your case. If you filed with a credit card, see if the credit card payment has come out. If it has come out, they've accepted your case. And so at least you have the peace of mind, even without the receipt number, you know that the case has been taken in. I had a case recently that I think it took me 6 or 7 business days to get a receipt. And what happened was the night before I got the receipt notice, I got the alert on my phone that the credit card fees had all come out. So that's how I was able to tell. So I would say look at that. Look at the checks and then or the credit card or whatever. If you get to day 8 and you have not had those checks come out, default thought is rejection.
Okay. Well, there you go. I think that's it for today. We should wrap up our show, right, Justin?
We can
Since
take that
you
last question if you want.
cool, so let's do that
If you
then.
don't want,
Control.
if you want to get off of some stuff.
No, I was just worried if you're in a hurry. So H1B visa refused status. So my Dropbox appointment was on December 12th, 2024 in Chennai. The status changed to application received on December 12th. And on December 13th, it has been updated to refused. I'm yet to receive intimation on when I can collect my passport back, which will likely have the slip proving more details on the next steps. This is my third time stamping, not sure why it shows as refused. Any insights?
That's very interesting. That's a very interesting question. So I obviously tell you by the default, most times when the consulate takes your passport, they're going to approve it, even if they need to address additional information. So the fact that it changed to refused is obviously puzzling. What's more puzzling is that you haven't received any correspondence from them in relation to the visa refusal. That's very shocking. Most of the time, you're at least getting a 221G when you walk out of the consulate that gives you an email address or something to reach out to them. So what I would say is if you're trying to be proactive and do something, obviously we all know the consulates don't pick up phones and talk to anybody. That's never something they're going to do. Usually through a little bit of perusing, you can find their email address, right? Other people have gotten it in connection with 221Gs or whatever, and you should be able to find that email address that way. What I would recommend as your first step is emailing them and just giving a very basic explanation. I would honestly front load it with, you guys have my passport, So I think that I would start off with saying, you have my passport. I need my passport back if my visa is refused. And I also need an explanation as to why my visa was refused. They're obligated to provide you with that, and they're obligated to provide you back a copy of your passport. So I would do that, and then hopefully that works out. And then once you get the basis of the refusal, you can work backwards to see if you want to apply again or if you want to use LegalNet or whatever avenue. But yeah, step one is at least getting a copy of that doc. And that would be my starting point because nobody's going to answer you anyway. The other option you would have is if you have a representative, if you've already lived in the U.S. and had property in the U.S., if you have a congressional representative, you could try reaching out to them and explaining. They love to help, and the consulates are more responsive to them than they are to everyday people. So that would be my other option.
Cool. Thank you so much, Justin. And I think, folks out there, you can also consult with Attorney Justin Rivera, and you can contact him and his phone number and his email address. So his phone number is, if you could just put it on the screen, please, so that folks out there can note it down. Control. So the phone number where you can contact with Attorney Justin Rivera is 844-592-7336. Please note it down. It's there on the screen. And you can also email him support@wasden.law and go visit www.wasden.law to get to know more about Attorney Justin Rivera and, of course, Wasden Immigration Litigation. And also, please do not forget to check out Wasden Immigration Litigation on LinkedIn. And last but not the least, it's the holiday season, Justin, and I'm super excited. I'm sure you two are. So here's wishing you, your family, once again, a very Merry Christmas and, of course, happy holidays, and wishing you more love, abundance, and blessings this season.
Thank you very much. Merry Christmas to you and everybody that was on. I hope you all have a great holiday, and I will see you all next year.
For sure. Thank you so much, Justin. And thank you once again, for this very, very insightful session. And if you have anything more to add, before we say bye, you might as well.
Yeah, no, I'm going to get out of here. It was a pleasure. All right. Y'all have a good one. Bye.
Thank you. Thank you so much. You have a good one too. Great day ahead. So, folks out there, thank you so much for joining us today. It was great having you. Really lovely. And Rag says, thanks for this episode and happy holidays to you both. Happy holidays to you too, Rag. Thank you so much for joining and stay with us. Watch out our space here on Immigration and Jobs Talk Show because we keep having interesting discussions on different topics, all related to immigration and jobs. And also, we have another upcoming show coming up, Daily Immigration Dose, which we do with which I and my co-host hosted, and that's with Sam. So look out for it, 4 p.m. Eastern Time. And of course, please do not forget to like, share, and subscribe to our channel. You can also write to me, call me up, or WhatsApp me. And my phone number is 408-335-6444. You can email me at nipa@staffingly.com. So for now, this is it. Y'all out there have a great day ahead and see you again here on Immigration and Jobs Talk Show. Hello, everyone, and welcome back to Immigration and Jobs Talk Show. I'm your host, Nipasa Pradhan, and I'm really happy to welcome you folks. And before we start off with today's discussion, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, friends, thank you so much for joining us today. We are streaming live right now on YouTube, LinkedIn, and on Facebook and on X. So please feel free to join us in this conversation by commenting, whatever questions you have, because we are going to have our guest attorney for today, and it's going to be great to have her for an hour where we can also address your questions. So yes, thank you so much for joining us, and it's a very critical topic we are going to dive in today for all immigrants and their families. So yes, with the release of January 2025 visa bulletin, many of us are wondering, what does it mean for us and our loved ones and our future plans, right? And we're going to unpack this for sure. But before that, please help me welcome a very special guest, Attorney Prashanthi Reddy. She is a leading expert in immigration law with years of experience, guiding individuals and businesses through the complexities of U.S. immigration process. Thank you so much, Prashanthi, for joining us today.
Hi, Nipasa. It's good to be back.
Absolutely. And friends, we have a breaking news regarding the upcoming H1B regulations effective January 17. And there are new changes that aim to streamline, the process and address key compliance issues, raising questions about the impact on both employers and employees. So, Prashanthi, before we really dive into our topic for today, I have this question. If you could tell us, what are the key changes in the new H1B regulations effective January 17th, 2025?
Right. So we had an idea that this was coming, but it was coming because they did publish the regulation in the Federal Register, but then they have a comment period. So they were waiting for comments. And then based on the comments, they often change the final regulation. So this is the final regulation and it's already published. And it was published yesterday. The 17th is effective 30 days from January 17th. Guys, ladies and gentlemen, it is now official. And this will be the final regulation. And this is a big deal because for a while there hasn't been any regulation on H1B. At least there hasn't been a comprehensive regulation such as this on, the H1Bs. So this is a big deal, and that's why we're bringing it to you as breaking news. So let's dive right into and there's some very interesting things and path-breaking changes that you'll see, and some of them are, more of what you saw in the past, which is just being regularized now, because of case law and lawsuits, they were not able to implement. So we knew that it was coming, and some of the aspects of this regulation are completely new and path breaking. So let's dive right into it. As I said, the final rule was and significant changes to the H1B program have been introduced in this rule. And as I said, 30 days to take effect. So we're talking about January 17th, just days before the Trump administration will take over. And this was done deliberately because they wanted to put it in before the Trump administration came in, so that it'll be difficult now for the Trump administration to make their own rules. This is the rules that the present government wants to have, right? It's good and bad. It's not like the Democratic government is completely free on H1s. No government is. So, but at least it's a mixed bag, right? So under the Trump administration, in my opinion, if they wouldn't have passed any regulation, then the Trump administration would have passed a much stricter regulation. So let's go right to it. First is they're giving deference to previously approved cases. So if you're filing a extension or an amendment, and if it's been approved previously, and if nothing has changed, if there are no new material changes, then USCIS will automatically approve those cases without again sending requests for further evidence. So that's called the deference policy, which is, already supposed to be there, but now they're putting it into regulation, so it'll be implemented for sure. They've updated the definition of specialty occupation. This rule revises the definition of what a specialty occupation is. This is the very core of who can get a H1 by revising the definition. That has a significant impact. So they've broadened the range of degree fields related. So right now, as per the regulation, a specialty occupation is an occupation where a bachelor's degree, the job requires a bachelor's degree in a specific field. They've broadened that to include in a range of degree fields that are directly related to the job. So it doesn't have to be one specific field. It can be different fields, as long as those fields you can show that those fields are related to the job, right? So it's not changed drastically, but there is some change, and this really makes a difference because there are some occupations in which a range of degrees are required, and usually those occupations don't get approved for a H1 because then USCIS comes back and says that it's not a specific, it's a range, and therefore we're not approving it. For example, I can give you an example of systems analyst, say, where it says bachelor's degree in engineering, math, physics, computer science is required, and USCIS would previously say that it was not a specialty occupation. Now, as long as you can show that that engineering degree, that math degree, that physics degree is related to the position, even if that's industry, it's still a specialty occupation. They usually go into the Occupational Outlook Handbook, which is a DOL publication, which is online, which you can check. They usually check that, and whenever there's something in the Occupational Outlook Handbook (OH), which says that a range of degrees are required, USCIS will generally send an RFE. So this, we can expect that more jobs will open up for a H1 and less RFEs, as long as we can show that the degrees are related. CAP exempt employers, they are narrowly expanding what the definition of a CAP exempt employer is. So for CAP exempt nonprofit research organizations or government research organizations, they have included a few more organizations into the CAP exempt employer category by replacing the term primarily research to research as a fundamental activity. So it means that the organization doesn't have to be only doing research. Even if they do other activities, as long as the fundamental activity is research, they can still qualify. In the past, their primary job had to be research. Primary mission had to be research. Now it's not so. It just has to be a fundamental or one of the main activities. The other change is bona fide position requirement, meaning the H1B petitions must now show that the offered position is a legitimate specialty occupation position, ensuring that the job meets all the criteria for the program. This basically means, in short, that, for example, if you're a consulting company, you have to show that you actually have specialty work, specialty occupation work available, meaning that you have to submit contracts and work orders. As you know, after 2020, after the Cessna versus IT-Serve decision, USCIS has not been asking for contracts and work orders. Now they will go back to asking that, but not to the extent that they were asking it before 2020, meaning that they will not ask for all 3 years to show that there is a requirement for 3 years, so show 3 years of contract availability. They will ask, at least to start off, you have a legitimate, contract, even if it's 6 months or whatever it might be for. But the contract requirement has come back. So this is significant because in the past CAP, we've seen that people have applied even without any contracts or anything, any client, especially if you're a consulting company, and they've still approved. Now, if you're not a consulting company, you still have to show that you have a bona fide requirement. So if you are hiring this person for not a contract position, but using them within the company, and you're not contracting them out, then you'd have to show that your company has enough business to require this. So you could show a tax return, you could show contracts work or that your company has with their clients in general, and you can show the volume of business in many ways. Maybe a list of clients, maybe your bank statements, maybe your invoices, to show that you actually have a need for this person. But this bona fide position requirement comes up mostly in a consulting scenario. Then they've also codified the site visits. So USCIS earlier always conducted site visits, but it was kind of voluntary. So you could either allow or not allow the officers into your office. Though, I mean, I don't see why you wouldn't, because if you didn't allow them into your office, they would write a negative report, and then your H1 would get denied or revoked, and there would be a black mark against your company. So now USCIS has actually codified their authority to conduct site visits, and they can, by regulation, deny or revoke petitions if a petition refuses to cooperate with their visit. Third-party requirements, they have specifically said for consulting companies, H1B workers assigned to a third-party work site, the job requirements of the end client are important rather than what your internal job requirements are. This is also significant. So if you are hiring someone to work as a consultant, say at AT&T, and the position is that of a software developer, then they will want to look at what AT&T's requirements are to hire a software developer. And if they require a bachelor's degree in computer science, then it's a specialty occupation. Otherwise, it isn't. So you'd have to have much more accessibility to your client and get that information from your client, or get a letter from your client stating what the requirement is. So we're back with, end client requirements, submitting end client requirements or purchase orders which have the end client requirements. Another very, very important change, and this is, I think, a 360-degree range, which is basically the rule now allows H1B to be self-sponsored. Very important. You can file your own H1 even if you are a controlling partner in your company.
Wow.
Very important. This was never the case. So you always had to file through another company, or you had to file through your consulting company. This rule allows certain owners of petitioning entities to self-sponsor Of course, there's a limitation on the amount of the H1, the period of the H1. You can get it for 18 months and then get it for another 18 months. And then I believe you can get it, for a longer period of time. But you have to keep in mind that though the H1 could be self-sponsored, when you're filing a green card, you could still have issues filing your own green card because so this works for H1Bs, but when you have to file your green card again, you'll have to find an employer who's willing to sponsor you on the green card. But this is really important for a lot of entrepreneurs out there who are already able to do their own business but are not doing it because they are they are restricted because of the existing H1B regulations where you can't really sponsor yourself because there has to be an employer-employee relationship. So they have really widened this, loosened it, whatever you want to say. And even if you are managing your own business, as long as you are doing more than 50% of the job is the H1B specialty occupation job. If you're also doing the job of managing your company, which may not be a specialty occupation job, you can still do that. As long as the majority of the time you're doing, so over 50% is your specialty occupation job. So that is very, very significant. I left out the best part for, the last, but
For the last.
but that's very important. And then there are other some more important rules for F1s. So revised cap gap rule. So now
Okay.
you will be authorized to work under cap gap or remain in status under cap gap until April 1 of the next year. Before it was October
Okay.
1st of the existing year, now it's April 1 of the following year. So that's also significant for F1s because they often see that when the H1B gets delayed, if it doesn't get approved by October 1st, then they have to scramble and go back into F1 status, file for, student status for another semester, file for OPT, CPT, whatever it might be to remain in status until the H1 gets approved. So they are taking that out. No need to because it's extended until the next year, April, and H1s don't take that long to get approved.
A little more relaxed.
Little more relaxed for sure. I mean, for the most part, 99% of F1 students will not have to file for an extension to extend their cap gap. Another last change is maintenance of status documents. They want you to send your status documents while you're filing the initial petition itself. So they might ask for more documents with reference to your status. Right now, we just send the H1s and, we don't necessarily send documents from the start of your entry into the US. So now they want all the documents, I think, from the entry of into the US from your first entry, and they might want all your pay stubs, all your W-2s to make sure that you maintained status throughout your. So that's something that they never used to ask for before. Maybe in random cases they would, but now they want that in every single case. So these changes, as you can see, they're a mixed bag. There's some positive and some negative, and that's to be expected. So we have to wait and watch how this actually impacts consulting companies, how this impacts individual H1B petitions, especially the self petitions, how they process them, whether there will be a lot of scrutiny and they have so much scrutiny that they won't actually approve any cases, or the scrutiny will be as it should be under the regulation, and they actually start approving these cases.
Let's see what the 2025 holds for us. But these new changes sound really good, and I really hope that this is going to benefit most individuals under H1B or who are planning to go for an H1B visa. So thank you so much, Prashanthi, for highlighting all those new H1B regulations and also these new changes for F1 students. Thank you so much. Thank you so much. It was great. And these are some of the latest updates, friends. I hope you note it down. And you can always go watch it right from the very beginning, whatever Prashanthi has shared. These are new updates that you wouldn't want to miss. And Prashanthi, we have some folks out there who have questions for us, I think we should address them before we jump into our visa bulletin questions for January 2025. And some of them are from your channel. So let's take them up quickly, please. So Sudhindra, Sud, Sudhindra, sorry if I'm pronouncing your name wrong, but he says, hello, I do have a query. My I-129 was approved on November 25th. I'm still waiting for I-797 forms. So will this new H1B changes affect my case?
No, this is only going to be from January 17th. That is, cases filed after January 17th will have to be filed under this new regulation.
All right. Thank you so much for addressing this one, Prashanthi. Now let's take up Shree's question. Hi, H1B petition is applied on November 24th for extension. Is this third-party placements through consulting apply for H1B applications applied after January 18th, or will it still apply for already applied ones?
Good question. It should only take. It should only be. I don't see that it is retroactive, but I can cross-check. It should only be applicable for petitions that are going to be filed after the 17th. But again, I'll cross-check. And then I'll let you, Nipasa.
Sure.
Nipasa, I'll let you know, and then you can let Sri know.
We
But
can leave
as far as I know, regulations are usually not retroactive. They're always only come into play once they've been once they're active, once they're published
once
and the
they're
comment
active.
period and the 30 days is over. Yeah.
And these
But
changes are
it's
going to be effective on January 17th,
17th,
2025.
17th. Correct. But if it's otherwise, I'll let you know.
Okay, thank you, Shri, for commenting. And if you have any other questions, keep commenting. And otherwise, you can join us on this conversation, folks out there, by dialing this number 425-436-6335. And the access code is 988-888. And Abhishek, hi, thank you for joining us. Charwak, we will address your questions, but please stay with us for now. So, Prashanthi, let's get to our visa bulletin for January 2025. We have some questions also, so let's jump right into them. So, given the significant retrogression in the EB2 and EB3 categories for Indian applicants, what strategies can individuals take to potentially expedite their visa process?
Nipasa, shall we go through the January visa bulletin first, just to give people
Sure,
an idea as
let's do
to?
that.
Okay, so so basically, for starting with the employment-based categories, for dates for filing, there's been no change. For final action date, there has been some advancement for both EB2 and EB3 categories. Let's go into that. So final action date, EB2 has moved up by 2 months to October 1. China is advanced by 1 month to April 22nd, 2020. All other countries advanced by 2 weeks, so not a big leap, but still something's better than nothing. It's moved to April 1, 2023. So India moved by 2 months, China by 1 month, all other country by 2 weeks for EB2. For EB3, India moved up by 3 weeks, 2012. China moved by 2 months to June 2020, and all other countries moved up by 2 weeks. So again, India 3 weeks forward movement, China 2 months, and all other countries 2 weeks. So you see that EB2 and EB3 both have moved forward moderately, not drastically, but any forward movement is good. EB3 also, there's been an advancement. India moved up by 3 weeks to December 1, 2012. All other countries, except of course for China, advanced by 1 week, so very short advancement to December 8, 2020. And then going to the family-based categories, India, China, and worldwide advanced by 1 month for F1. That's unmarried sons and daughters of US citizens. Now they're on November 22, 2015. Philippines advanced only by a week to 2012, March 8, 2012. F2A, spouses and children of permanent residents. Again, Mexico advanced by 1 month. And India, China, and other countries advanced by 3 weeks. For F2B, that's unmarried sons and daughters. For F2A, the only change is Mexico. Married sons and daughters of US citizens, Mexico went up by 1 month, Philippines by 2 months. All other countries went up by 2 months as well. Of course, not US, not India. It's the most backlogged, which is brother and sisters of US citizens. Philippines went up by 3 months. India went up by 1 month. Any advancement is good because it's very rare. Now that was the final action date table, but but the dates for filing table, which we presently can look at, has also changed for family base. So Mexico went up by 3 months. India, China, worldwide. For F2B, Mexico went up by 3 months. That is unmarried sons and daughters of permanent residents. For F3, married sons and daughters of US citizens, India, China, and worldwide went up by 3 months, which is a good advancement. And brothers and sisters, that's the F4 category, which we were just talking about, 5 months to 2008. India advanced moderately by 2 weeks to 2006. So always look at the dates for filing tables, because those, if USCIS is allowing you to use those tables are usually ahead of the final action date table. It's just that you won't get a green card immediately, but you'll be able to file for a 485 and be in a 485 status and get, the advanced parole and employment authorization as well.
Right. Any advancement is good, and this is very rare to see. So all these good advancements are good news, and thank you so much, Prashanthi, for going through the visa bulletin for January 2025 for us and highlighting those important changes in the advancements for both the dates. So now let's go to our questions, if that's fine. But before that, Sudhindra has said, "Thank you, Prashanthi ma'am. This eased my anxiety. Kudos to you both." Thank you for your question, and thank you for that, Sudhindra. So going to our question, we see the significant changes in EB1 and EB2 categories for Indian applicants. So maybe if you could tell us a few strategies that individuals can take to potentially expedite their visa process.
Right. So we see, even though there has been some forward movement, there's still retrogression for EB2 and EB3 for Indian applicants and Chinese, people from China as well. So, in order to navigate this, there's some things we can do. There's not a lot we can do, of course, other than advocacy to change that. But some things is to see if you qualify under EB1. So if you possess extraordinary ability, or you're an outstanding professor, researcher, or you've served as a multinational, you've worked as a multinational executive or manager, you can consider applying under EB1 or see what you can do to make yourself eligible for EB1. You can file under NIW if your work is substantially intrinsic to the US and helpful to the US. Then under EB2, you can file under national interest waiver. The advantage of this is, even though it's still EB2, you can bypass the labor cert process and thereby gain some time, because the labor cert process takes more than a year now. Always make sure you file concurrently. If your dates are current, don't file the I-140 first and then wait. I mean, you could do that, but in order to speed up the process, you should file both the I-140 and 485 together, because by the time you get the I-140 approved, maybe your dates will no longer be current. So concurrent filing, even if the I-140 gets denied and you lose your money, concurrent filing might be the way to go, especially if the dates have become current. Cross-chargeability. If your spouse was born in a different country with a less backlog, so if she's not born in India or China, he or she, then you might benefit from your spouse's countries of birth. Always make sure you cross-check your spouse was not born in this country as you. And last but not the least, always maintain your non-immigrant status. Ensure your current visa remains valid, so that while you're waiting, you don't accrue unlawful presence and then have to leave the country.
Thank you. Thank you so much, Prashanthi, for addressing that and for highlighting those changes. And before we go into our next, let's take up Prabin's question. Does this rule apply for transfer and extension? I think he's talking about the new H1B regulations,
It applies to everyone. Transfer, any H1 that you file, cap, extension, transfer, amendment, anyone.
but after the date, January 17th, 2025, Prabin. Thank you for your question
Correct.
and thank you for participating. Let's go on to our next question now, Prashanthi. So, how does the advancement in family sponsored categories, such as F1 and F3 categories for Indian applicants,
Yeah.
impact the expected wait times for green cards?
Well, so unfortunately, as we've seen, right, there's no significant advancement. There is advancement of 2 or 3 months, but as you've seen, F4 categories still remain backlogged. So I would say, in order to prepare to, so that when your case gets current, what you need to do is document ready, right? So keep all your documents ready, especially your birth certificate, marriage certificate, those kind of documents. You have to keep them ready. So that's one thing to keep in mind. Other thing is stay informed. Regularly check the monthly visa bulletin for any changes in priority dates. And keep yourself updated. Don't miss. Sometimes the priority dates are available only that 1 month, and then they become unavailable the next month. So get an automatic email, and you can register to do that so that you get it into your inbox whenever there is a new visa bulletin. That way, you won't forget to check. The reason I was talking about document readiness is you might not have your birth certificate, you might not have your marriage certificate. Perhaps your birth certificate was never registered. Then you need a non-availability certificate. And this is since you don't have it and you don't have control over how long it'll take, because this has to be done by the registrar of, birth and deaths in the town that you were born. Do that in advance and keep them ready. And then, of course, as I said earlier, consider alternative paths between the employment-based and the family-based and see which one has shorter times and apply for both if you're able to, right? So that's another way to kind of be prepared despite the retrogression.
Thank you so much, Prashanthi, for highlighting that as well. And family sponsored categories, I think folks out there are pretty tensed how to go about this, and especially with all these backlogs that have been significant all the while. And I think thank you so much, Prashanthi, for addressing this again.
You're welcome.
Let's go on to our next question now. Let's take up this one. Can you explain the implications of the EB5 category, showing a favorable environment for investors? And what does this mean for those considering applying for an investor visa?
So while the visa bulletin shows that the dates are pretty good and current for most countries, including India, you have to keep in mind that the processing times for EB5s are not good. So while the priority dates might be available, your processing times are about 4 years just for USCIS to process it, which is ridiculous. I don't know why they're doing this I guess they're doing this because they don't want to give out EB5s. There's no other reason. They're trying to stop the EB5s or kind of stall them or reduce them, whatever it is. So processing times are really, really long. So you have to keep in mind the processing times when you look at the total time taken to get an EB5. And while you might, if you're outside the country especially and you're investing that kind of money, and if the processing time is taking 4 years plus, even if your priority date is available, and then takes another 2 years to get a permanent green card by removing conditions, then you're already looking at 5 to 7 years, and then we don't know what the priority dates will be then, right? We're only looking at the priority dates now. So do it, but keep in mind all these things with reference to processing time and how that might impact you. And keep in mind the requirements of, the 1+ million and the 800,000, depending on where you're investing, and that you need to create and preserve during this time 10 jobs, 10 full-time jobs. So you have to continue to have those 10 full-time jobs. And if you're using a regional center, make sure that you do your due diligence to make sure that the regional center has, has good, good investments. So these are a few things to keep in mind, I think.
Thank you so much, Prashanthi. And folks out there, I would like to tell you that you can also join us in this conversation by dialing this number 425-436-6335. You can join us, and when they ask for the access code, dial in 988-888. Once you're in, you just say hello and we will be able to hear you. And otherwise, folks out there, this is Attorney Prashanthi Reddy, and you can also have a one-on-one consultation with her, and her phone number is there on the screen. Her number is 212-354-1010, and you can also email Attorney Prashanthi Reddy, and that is Prashanthi at reddyesq.com, and go visit www.reddyesq.com to get to know more about Attorney Prashanthi Reddy. Let's go on now, and we have Arpita also, who has joined us with the questions. Arpita, please stay with us. We will address your questions a little while later. Prashanthi, with the visa bulletin, showing current priority dates of most employment-based categories for, other countries, that is, rest of the world, what factors could contribute to these variations in processing times between regions, if you have anything to highlight?
Yes, the processing times, the priority dates are definitely going to be different depending on which country you were born in. It's based on country of birth, remember, not country of citizenship. First of all, it depends on the demand and supply in your particular country. For example, because everyone gets only 7% of the total green cards. Every country gets 7%. So for high demand countries like India, the wait time is much longer due to the country caps, right? Also, each category has, again, a cap. So depending on which category you're filing in and what is the demand in that category. So for EB1, the demand is less. So, the wait time is less. If you're EB2, EB3, the demand is higher. This also, the efficiency of the USCIS in processing these, administrative efficiency also makes a big difference. So processing times, especially if you're filing outside the country, your wait times will differ depending on the consulate that is processing your green card. Even though part of the processing takes place here, the final immigrant visa petition is processed for India, example in Bombay, and Bombay has a wait time because they have only so many slots available for interviews. So that could add to your processing time as well, depending on which consulate. And also USCIS often delays processing of cases. So depending on at that particular time, what USCIS processing times are, that could also account for variations in processing times. So I think all these have an effect on your processing time. Hello, Nipasa? I think we lost you. Oh, there you are.
Ma'am, control here. I'm trying to get in contact with Nipasa again. Let me see.
Okay.
One minute, ma'am. 1 minute, ma'am.
I think she's back.
Nipasa, are you okay? 1 minute, ma'am, please. Sorry.
Sure.
Sorry, folks.
No problem.
Sorry, guys.
Thank you so much, Prashanthi, for addressing that for the rest of the world. I think there was some internet lag. I had to rejoin. But thank you so much, folks, for staying with us. This is Immigration and Jobs Talk Show. I'm Nipasa Pradhan with our guest for today, Attorney Prashanthi Reddy. So it's been great having your questions, and I think we're going to address them in a little while. But Prashanthi, if you could also, tell us. Um, how do the changes in the visa bulletin also affect the family reunification process, especially for siblings of US citizens, the F4 category, which you had touched upon a little bit earlier. But what steps should families take to prepare for possible delays and advancements?
Yes, so the F4 category is severely backlogged for most countries and especially for India, as we discussed. And I guess the only thing we can do is timely file your I-130 petition as soon as possible so that you can, be in the window. Um, Maintain communication, keep in regular contact with NVC if you're outside the country. That's a National Visa Center, to update them on any changes that might have taken place, right? Since it's taking 20 years, you might have had children, you might have gotten married, right? Unfortunately, sometimes the sponsor might be no more as well. So you have to continue to maintain contact with NVC and update them on any changes that are taking place. Also, explore other options. And you might want to think whether you want to file an I-130 or not at this point of time, or you have other ways of coming into the country, or filing a green card if you're already in the country. Consider filing a B2 if you want to come and meet your family members for a short period of time, or consider another non-immigrant petition like a student visa, or coming to work here so that you can, you can reunify with your family members. So alternatives are should always be looked at. If you're filing an I-130, remember it might be better not to file it if you're going to file a non-immigrant petition. That requires you to have intent on not to immigrate. So for example, like a B2, an F1, you may not be able to file an I-130. You might have to hold off on that and file this first and then file an I-130 once you get onto a visa which allows dual intent, like a H1. So these are strategies that you have to think about, considering the long processing times for an I-130. And I think an attorney can really help you and advise you on strategizing on the best path forward.
Absolutely. And folks out there, you should definitely contact Attorney Prashanthi Reddy, and you can email her at prashanthi@reddyesq.com. And moving on, Prashanthi, if you could also tell us what potential legal challenges or policy changes could impact the visa bulletin and immigration trends in the upcoming months. We already touched upon the latest updates on H1B regulations, but anything else you want to add?
Well, with the new administration set to take over in January, um, we have to see. Visa limits are established by the law, right? And unlikely to change immediately. However, there might be legislative proposals or bills like the Fairness for High Skilled Immigration Act that could be reintroduced. You never know. For years and years, nothing has happened. I don't expect anything will happen under the Republican controlled House and Senate legislature, but let's wait and see. You can never say never. This H1B regulation came out after so many years. That will happen. Who knows? Policies can always change for governments, right? Right now, it seems like the Republican Party under Trump is not pro-immigration, but I'm hoping that they'll surprise us and change their policy. And the Elon Musk and people who have Trump's ear might have some influence over the present government, and I'm hoping that they'll have enough influence to bring about bring about some positive changes, at least with reference to business immigration. Court decisions can often influence immigration policies and procedures. I am not sure in what scenario this can go before the court, but if it does, and if they um, then if they or if the judge decides that the visa numbers, the way they're counted wrong, and maybe family members should not be given a separate visa number, if that's something that they can decide after looking at the interpreting the regulation in the Immigration and Nationality Act, then that's a possibility as well. But we have to wait and see.
For sure, Prashanthi. And I think we should also address some of our questions from our viewers. So let's take Abhishek's one. I noticed the January 2025 visa bulletin has some movement in EB categories, but it's not as much as I expected. Why is the movement so slow for certain countries?
Because the demand is so high and they don't want to release numbers quickly. They want to wait and see because we have the entire year ahead of us. So I think they're doing it slowly. That's for that reason. They want to wait and see.
Yes. Thank you,
If they are,
Abhishek, for your question.
if there are visa numbers still available, then you can see likely that there'll be some movement towards the end of the year, maybe August, September, because the year end is October.
Right. Let's hope for the best. Thank you, Prashanthi, for addressing this. Let's take up Charwak's question. What are the key differences between final action dates and days for filing applications for immigrant visa applicants, and how do they impact the application process?
Right. So the final action date table actually is the date when your priority date is available. The dates for filing table is something that the Department of State introduced to allow you to file applications in advance, because the way they um, the way they calculate it is that they're hoping that by the time you file and by the time the case gets processed, your final action date, priority date, will actually be available. So that's how they calculate it. So it's usually dates for filing are a few months in advance or maybe a year in advance of your final action date table. The advantage of the dates for filing table and the huge benefit that it has is that it allows you to file your adjustment of status early, before your actual date becomes available. And this allows you to file for a 485 and allows you to maintain status without having to maintain a non-immigrant status. So it allows you to continue to be on 485 for years together and have EAD and advance parole. That has been a boon for a lot of people who have suffered due to the unavailability of visa numbers, because maintaining a H1 for so many years is very difficult, because a H1 is a very stringent visa status to maintain.
Right. Thank you so much, Charwak, for your question, and thank you, Prashanthi, for addressing this. Let's go on to our questions from our YouTube channels first, and then maybe we can take up Arpita's question. So, Control, if you could display the first one. All right. Meanwhile, Prashanthi, like I have one more question to go. So, given the significant disparities, between employment-based and family-sponsored categories, how should applicants prioritize their visa strategies to align with their personal and professional goals?
Right. So this is again similar to what we discussed with reference to retrogression for the family-based F4 category and how you should maybe look at alternatives. I guess it's the same for this. When you're deciding between, I mean, most family-based categories, immediate relative, of course, is a no-brainer, because if you are a U.S. citizen child under 21, or if you're a spouse or a parent, there is no visa numbers required, so you can file immediately. So obviously, if you're one of those, would definitely file under the family-based immediate relative category. But even if you're a permanent resident spouse, you might consider filing that rather than doing EB1, EB2, or EB3. So you have to assess what are the priority dates for each and evaluate. First, assess your eligibility for each category and see what you qualify under, and then evaluate the wait times categories that you qualify under, and file. You can no one you can file for both under certain circumstances. But again, I think you need to speak to an attorney to see if it's a good idea to file under all categories or just stick to the categories that are better. And also be flexible, be ready to change or file under the other a different category if this category gets backlogged. So always be flexible, be prepared in a month's notice to file under your that particular category. It happens to jump forward. So yeah, these are the few things to keep in mind. Assess your eligibility, evaluate your wait times. Of course, consult with an attorney and stay flexible so that you can pivot to the other category when required. And when I say pivot, I also mean pivoting between employment-based categories, between EB2 and EB3 as well. And
thank you so much.
also, Nipasa, in order to pivot, you have to know there is something called changing of the underlying basis. So you don't have to file a new 485. If you filed under EB2 and you want to pivot to EB3, you can just ask USCIS to change the underlying basis of 85. And this in certain situations is possible even between a family-based and an employment-based category as well. So you might not have to file for a new 485. You can ask USCIS to pivot your 485 to the family-based category. But again, consult with an attorney before doing that.
Absolutely. Thank you so much, Prashanthi, for addressing all these and highlighting the important things to keep in mind. And folks out there, it's always best to consult with an attorney. So it would be great if you could also consult with one, and why not Attorney Prashanthi Reddy. So you can email her about your case, and her email address is prashanthi@reddyesq.com, Prashanthi @reddyesq.com. Thank you, and let's go ahead with our questions now from our YouTube channel. So, Control, if you could display it, please. Um, the first one is: are these rules applicable for already selected H1B applicants whose petition is not yet approved? And please give information about the H1B petition delay happening right now. Prashanthi.
So no, as we discussed, these rules should not be applicable for H1B petitions that are already in pipeline. They should only be applicable for petitions that are going to be filed after January 17th, as per regulation. And again, I had said that I would cross-check that and get back to you with reference to if there's something written in the present regulation, because it only came out yesterday, makes it retroactive. In general, it's only regulations are only are taken into effect from the date that it's published or the date that they say it will take into effect.
Okay. Thank you so much, Prashanthi, for taking this up for Indhu.
Nibasa, about the H1B delays happening right now. In my office, I'm not really seeing those delays, but perhaps you are. Perhaps this is with reference to your particular case, and there could be some reason for it. Maybe you're going to get an RFE, and that's why they're taking longer to respond. I mean, if you want to overcome that, just convert your case to premium processing. If you can do that, I know it's a lot of money, but if you want to get approved faster, that's definitely one way of doing it.
Right. Thank you. And for an RFE, you have around 45 days to respond to it, right? Or 60
actually,
days,
more than that. Depends,
Okay.
but usually the maximum time is 80-something days. So there's plenty of time to respond to an RFE.
Okay. All right. Thank you so much, Prashanthi, for taking this up for Indhu. And I hope this was very helpful for you, Indhu. And even otherwise, you can always contact Attorney Prashanthi Reddy. She could guide you personally on your case. And that is prashanthi@reddyesq.com. Let's go on to our next question. This is also on our YouTube channel. How long does it take to get a receipt if you have filed an H1B transfer in premium processing? New employers sent the FedEx last Friday, and it dispatched on this Monday. Still, after 5 days, don't have a receipt number. They have filed in premium. Is there a delay going on nowadays? I never faced this much delay in premium transfer. Is this normal?
Yes, because it could be that, usually what happens is I would like to advise that, file online because you get a receipt immediately if you file online. So try to make that into a practice rather than FedExing your case to USCIS. Of course, I understand in some instances you cannot file online because you have a H and you want to file then H1 together so that both process together. And in that situation, you cannot file online because you can't file a H4 online. But otherwise, I would suggest file online and you'll get the receipt immediately. But with reference to premium processing, you should usually get an email within the first 1 week of filing with the receipt. But I'm not surprised if you didn't. I wouldn't panic. Sometimes they don't, and that doesn't mean that they're not processing your case. It might just mean that they're as yet. And I've noticed premium processing, it's supposed to be 30 days. They never take the 30 days. It's usually processed within a week or 10 days. The only thing to make sure is that FedEx was delivered and that you have confirmation of the delivery. After that, I wouldn't worry too much about not getting the receipt within the first 5 days. Wait and see.
5 days. Okay.
Not
Thank you
yet
so
time
much
to
for
panic.
not yet time to panic. Yes, Shaba Kahal, thank you so much for your question, but I think you'll just have to be a little more patient and wait. Thank you, Prashanthi, for addressing this one. Let's go on to our next control. If you could display it, please. This is from Pradeep. Is Indian Chartered Accountants considered for H1B specialty accusation for accountant job? I have only Indian Chartered
Occupation,
Accountant
yeah.
certificate.
Right, occupation, I guess. CAs can qualify to work as accountants. They cannot they cannot work as CPAs in the US so that they cannot file taxes, but they can work under a licensed CPA as an accountant. And yes, an accountant is a specialty occupation, and yes, you can file a H1 for an accountant.
All right, this is good news for Pradeep. Then thank you, Prashanthi, for taking this one. I think we have one last one from our.
And the other question he had was if I only have an Indian Chartered Accountant certificate, is that sufficient? You require a bachelor's degree or your degree in accounting, but your chartered account certificate along with your bachelor's degree, if it is in can qualify you or make it if you send it to the evaluator, which your attorney will do. They can consider it to be the equivalent of a bachelor's degree in accounting. So yes, using that, it's possible to qualify as an accountant.
It is. It is. So the evaluation is much needed since he must have done it from an Indian institute. I mean, his studies. So evaluation is a must before that, right? Thank you,
Correct.
Prashanthi, for taking this up.
Yes.
This one is, I think, our last one. I have never traveled to US and working with Company A. My H1B petition got approved with Company A. Now the project is being wrapped up and Company A is not willing to send me. Can I transfer my H1B approved petition with Company B and travel to US? If yes, what will the process be and how long does it take?
Yes, you are cap exempt in this situation because you have previously filed a H1 even though you worked. But of course, or how they exempt is often the interpretation of who is cap exempt and often change. USCIS right now will consider to be a cap exempt case, but moving forward, if USCIS gets more strict with reference to the interpretation of who is cap exempt and who is not, they might insist that in order to be cap exempt, you have to actually start working for the company. But as of now, yes, you are cap exempt. You can file for another H1 and then get your visa. Once you get an approval, if you already have a visa, you can use the existing visa and the new H1B approval to travel as well.
Okay. All right. Thank you so much, Prashanthi, for addressing this one, and thank you, MD Nazim, for joining us with your question. And I hope that was, good. Good. I mean, if you have more questions, you can keep commenting. Thank you. And Prashanthi, maybe we could take up, if you still got a little more time, we can take up Arpita's question.
Sure, one more
I am an
question. Yeah.
Indian national. All right. I am an Indian national currently working in the US on H1B visa, and I'm interested in applying for a green card under EB3 category. However, I'm concerned about the per country limit and potential retrogression. Can you explain how the EB3 category works and what are the specific requirements and procedures I need to follow to increase my chances of a successful application and given the current visa bulletin?
Just that you apply under EB2 category if you qualify. Just to let you know, in order to your job should require either a master's degree or a bachelor's plus a 4-year bachelor's plus 5 years of work experience. So if you qualify under EB2 and you file your I-140 under EB2, then if EB3 becomes available or shoots ahead, then you can always file your I-140 under EB3. This way you can have an EB3 as well as an EB2 application. This gives you more flexibility, and you can use either or. Right, if depending on the dates. If you file under EB3 to start off with, if you file your labor cert under EB3, then you will not qualify under EB2. So if you are EB2, and then you can always, uh, downgrade to EB3. But if you don't qualify for EB2, which may be, yeah. So if you don't qualify though for EB2 and that's why you have interest in filing for EB3, then uh, by all means go ahead and do it. The requirements are the same. You have to file a labor cert. You have to have a bachelor's degree, or if you're doing EB3 under um, specialized workers, then you can have even less than a bachelor's degree. File the labor cert first, then once it gets approved, you have to file the I-140.
Thank you so much, Prashanthi. And Arpita, all the best. I'm sure you will figure out what's going to be best for you. And I think it's always best to consult an attorney. And why not contact attorney Prashanthi Reddy? You can call her directly, and her number is 212-354-1010. You can also email attorney Prashanthi Reddy. Her email address is prashanthi@reddyesq.com. And please go visit www.reddyesq.com to get to know more about attorney Prashanthi Reddy and the law offices of Prashanthi Reddy. Uh, Thank you so much, Prashanthi. It was great discussing, the latest updates on the new H1B regulations and also the visa bulletin for January 2025. Thank you so much for joining us.
Thank you.
Well, I think it's going to be Christmas coming Wednesday. I still hope that I'll be able to see you, but even if not, here's wishing you Merry Christmas to you and your whole team out there.
Thank you. And I like to wish you and the audience that's listening happy holidays as well.
Thank you so much, Prashanthi. Thank you. This is it for now. Folks out there, thank you so much for joining us. And that's all we have for today's discussion. Yes, if you found this session helpful, please don't forget to like, share, and subscribe to Immigration and Jobs Talk Show. And also hit the bell icon so that whenever we have discussions like these, you are notified. And yes, don't forget to follow us on social media because we are there on not just YouTube, but also on Facebook, LinkedIn, and on X. So yes, follow us for updates on future episodes and webinars. And remember to stay informed. It is the first step, to making confident decisions about your immigration journey. Thanks for watching and stay tuned on Immigration and Jobs Talk Show because we got a lot more coming up. And also look out for our 4 p.m. Show, which is Daily Immigration Dose with my co-host Sam. So yes, see you then. For now, keep on having a great day ahead.
Hello and welcome to today's episode of Immigration and Jobs Talk Show. I'm your host Sam and I'm back again with a very exciting episode that is lined up for you today. So before diving into the topic, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So use of information is at your own risk. All right, so folks, once again, welcome back to Immigration and Jobs Talk Show. I'm Sam, your host. And today we have got again a very timely and crucial topic. That is the new H1B rule. What employers and workers need to know and why it's a game changer. Well, it's actually a game changer because the new H1B rule has modernized the visa process. But how, what are the key changes, then how does it impact both workers and employers, and what you need to do to stay ahead? To answer all these questions in detail, we have a very special guest with us who has joined us for the fourth time. That is Attorney Poonam Gupta. And she has over 25 years of experience in immigration law, plus a solid background in intellectual property and litigation. So, welcome, Poonam. It's always a pleasure and lovely having you with us on our immigration show. And it feels so great to have a show with you and so much to learn from you as well. So, thank you so much for joining us.
My pleasure, Sam. It's great to be back, and I'm excited to bring the key topics and key learnings from this new H1B rule that's finally come to fruition. It was first proposed in October of 2023, and it has now just been released and will become effective January of 2025. So, super excited to delve in, and I hope people have lots of questions. If not, I have lots of things to share because a lot is there to pack and unpack.
Absolutely, that is, and but before diving into our today's topic, Poonam, I would like to know it's just 5 days to go Christmas. So, how is your Christmas preparation going on? Are you excited?
I am super excited because I'm going to take some time off and unwind and relax with family and friends. And so, super excited about that. And I hope everyone else does the same.
Absolutely. I think all our viewers are also very much excited because it's Christmas time, right? It's super exciting time, and holiday days also are just coming after a few days. So,
Sure.
yeah, I think with that also, folks out there, let me tell you that we are also live on YouTube, LinkedIn, Facebook, and on X as well. So, watch this session and put all your questions, your queries, whatsoever you would like to know from Attorney Poonam Gupta, and we would be more than happy to have them. All right, so let's begin with this very first question of mine. That is, Poonam, what is, or can you please explain the main changes that has been introduced by the new H1B final rule?
Sure. So there are lots of changes in this new rule.
Mhm.
As I mentioned previously, the first iteration of this rule was proposed back in October of 2023. Partial implementation of the rule happened last December, and those rules went into effect in January of 2024. The remaining portion from that 2023 rulemaking proposed rule has now been issued this week, and this will go in effect on January 17th, 2025, just days before the new president takes office. What is the purpose of this rule? The purpose of this rule is to codify USCIS practices and introduce some new provisions. So, some of the new provisions that were introduced include an expanded and more robust definition of specialty occupation, which is the hallmark of H1B. And to qualify for H1B, the second is the elimination of the itinerary requirement, which is if someone is placed at any at a location, then previously employers were required to identify when they will be working and where, for how
Mhm.
long, and so on, and that requirement has now been removed. And one of the most exciting pieces of the rule is the expansion of the definition of not for profit and what it means to be cap exempt and how to secure cap exempt H1B. The expanded definition makes it a lot easier for organizations to qualify as cap exempt and thus hire more workers. And it actually requires people to not directly work at those organizations, but even if they're working with that organization and working towards that essential function of that organization, they could still qualify for this cap exemption. The next exciting part that's been introduced in this, which was much awaited by entrepreneurs across the across US for a long time, is the option for startup owners to sponsor themselves for H1B as long as they have an entity, a company set up. And even if they own the majority stake and they have the majority ownership, they're still able to sponsor themselves. In addition, there is the codification for that there has to be a bona fide job offer, um, amended petitions, that when an amended petition is required, deference policy was codified, as well as the evidence of maintenance of status that is required for each petition for change or extension of status. The one key piece that has been in USCIS practice, but has now been codified, is USCIS has expanded its authority to conduct site visits to ensure compliance with H1B requirements, including for third-party placements, and non-cooperation with the site visits could result in a denial or revocation of the H1B. So in short, I know it's a lot that I packed in, but in short, that is what is a quick summary of what's happened in this new H1B rule.
All right, all right. Thank you so much, Poonam, for letting us know about what are the main changes that has been introduced by the new H1B final rule. Also, Poonam, do you think that the new H1B rule is going to benefit workers and employers? And if yes, then how?
So there is definitely benefit that will come through for everyone. The biggest benefit will be the clarity that comes through. There is clarity on what is specialty occupation, what is required, the government clarifies in their proposed rule, in their rulemaking document, the notice in the Federal Register, and address the various scenarios, and they go in great depth on what is it that is required for each. When is it considered specialty occupation? When is it not? When is a general degree okay? When is it require a specialized degree? In most instances, a general degree may not work and may not qualify someone for an H1B because it will not be considered specialty occupation, and so on. So there's definitely clarity around that. And removal of the itinerary requirement is a huge benefit, especially for IT staffing companies. That really helps. That should help. What may not be as beneficial may be the increased site visits, the increased access, or sorry, the streamline. I mean, there is streamlined processes, but there's also additional requirements on what is an employer required to present when it comes to qualifying for an H1B. The government has the authority to request contracts, whether it is with end clients or third-party clients, or there may be intervening agencies before the H1B employees placed at an end-party client, and the government has expanded its authority to request any contracts or master services agreements or the like. So that may add more burden on the employers, but by and large, I think all in all, this rule is a positive. is a good thing. There are a lot of good things about this.
All right, that's great. Also, Poonam, there's some mentioning about a specialty occupation. So I would like to know that how does the new rule change the definition of a specialty occupation for H1B visa, and what does directly related mean for the required degree too?
So USCIS has gone and spent considerable time in explaining that they are not actually changing the definition drastically. All they are doing is codifying what USCIS practice currently is with regards to specialty occupation. So the current practice is that the government requires a nexus between the degree that the individual, the beneficiary, or the employee has and the position. So there has to be a direct connection, a direct nexus between the two. If a company cannot show that there is a connection between what the degree required for the position is and what the person has, then there may be problems. But to the extent that a company can show that there is a nexus and there is a connection, then there should not be any problem. It's more clear compared to before, if that makes sense. I can give an example. So one of the examples that the government lists in the rulemaking is an engineering degree for a software developer role. And they say not any engineering degree can surely qualify unless the government shows that there are specific courses within any engineering degree that would help in that software developer role. So, for instance, a chemical engineer or a mechanical engineer, by definition, at least on the title, and the government has spent considerable time explaining that just the title of the degree is not material. It is what the substance and what courses are taught in that degree. And because titles vary from university to university, program to program, the titles are not as positive. It is what is the actual coursework and how that relates to the role that matters. So that is what directly related means, that there has to be a direct nexus, direct connection between the coursework and the position.
All right. But also, Poonam, I have this question in my mind that now we can see another way of specialty occupation definition. So now it shouldn't be much specific about the work that the workers are going to opt for. So do you think it's going to be beneficial for the company? Because if specifically not that employer is looking for that specific degree, that overall degree can be applicable. So do you think it's going to benefit, or that employer or that worker needs to be highly qualified in that specific work, then only it's going to beneficial for the company?
So there are several pieces to this, Sam, right? One piece is when the person has, so the position can require one degree or it can require multiple degrees, right? And the government has always held this position. And what they've done with this new rule is codified that position, is that if an employer requires multiple degrees, it has to show how each degree is relevant to the role. So,
Yeah.
for instance, if a position requires finance, economics, statistics, all related, then it has to show what part of the finance degree is directly related to the role, what part of the economics degree is directly related to the role, what part of the statistics degree is directly related to the role, and so on. So that is the directly related part. In terms of, does it exclude individuals that have experience? No. The government is still going to look at, as it currently does. It's not a change, nothing's changed in that perspective. It's only clarified and codified what USCIS currently does. That if someone has an Indian degree, an Indian bachelor's degree, which is a 3-year degree, and a few years experience, then there is a possibility that the combining the degree and the experience, the person could qualify for a US H1, an H1B role based on a degree equivalency, which is based on just the 3-year degree plus a few years experience, which would equate to a US bachelor's degree, which, as you may know, is required for an H1B. So the government looks at the totality of what the situation is, and not just the title of the degree, not just
Right.
the experience or whatever. So it's everything combined together.
Absolutely. And also, Poonam, we have one of our viewer here, and here's Chetali here, and she's watching us from LinkedIn. So, Chetali has another question that does codifying help H1B holders? Will it protect them from the next administration from, I think,
Making any drastic changes to the H1B. So
yeah.
yes, thanks Chetali for joining us. The question is a good question. Codifying helps both the employers and the employees because it provides clarity to everyone. What is the standard? What is required? In terms of, will it protect someone from drastic change? There is codification of the deference, as in the deference policy, which means that if an employee continues to work for the same employer and applies for an extension of the H1B status, then unless there is a drastic deviation from the previous application, the government will give deference to that same application, that extension application. So to that extent, there is a limited protection under the previous Trump administration. We saw individuals who had held H1B status for an extended period, 10, 12, 14 years. Their H's were denied on extensions because the Trump administration revoked the deference policy, as in every case would be reviewed afresh as if it was a brand new filing. By codifying the deference within this new rule, the government is providing a limited amount of protection, not a blanket protection. They've refrained from expanding the deference, but there is some limited deference.
All right. And thank you so much, Adali, for your question. As this was my about to question because I was about to ask this question only. But that's okay. I think, Poonam, you have explained it. And Chitali, if you still have any follow up question or would like to know any other topic or any other question that you have in your mind, then please feel free to post them in the comment section. And for an hour, we are here. So please go ahead and utilize this opportunity. We will definitely take your question up. And here's another question from Anisha. And Anisha is asking that does the rule address dependent visa like H4 or their work authorization?
No, Anisha, thank you again for joining us. Unfortunately or fortunately, we don't know, we'll see. But the rule is focused purely on H1B and does not address any dependents or the H4 work authorization. There were some comments in the rulemaking about immigrant visas, and the government said that is the outside the scope of this rulemaking. But there were no comments about, or at least I didn't see any comments about dependents. But there are definitely no rules or no impact or changes to the dependents or their work authorization in this new rule.
All right. So thank you so much, Poonam, and thank you so much, Anisha, also for your question. And Chitali is saying thank you. This was really helpful. Thank you so much, Chitali, also. And let's move ahead with another question, Poonam, that I have for you. That is, how does this rule impact the eligibility of workers with degrees in business administration or other fields that were previously considered general?
Right. So this is where this may be slightly problematic, right? Individuals that had a general business degree, and the government clarifies that it is only the bachelors of business administration that may be problematic without a specific major or a minor. When there is a major in that, even in that business administration degree, it is considered specialized. It is when there is no major that that is a problematic issue. If there is a major, no issue. If it is a master's in business administration, again, no issue. They are considered specialized by virtue of being master's degree. But it's only the bachelor's in business administration, which did not have a specialization, that may run into trouble under this new codification. Everyone else should be okay.
All right. Okay. So here we have also Anisha, and who says, "Okay, thank you so much, Anisha." And to you also, if you have any question or follow up, then please go ahead and post them on the comment section. We will take them up. And thank you so much, Poonam, for detailing that up and answering all the questions very patiently. Here's another question that I would like to know from you about the site visits. So, what role do site visits play in the new rule, and what should employers be prepared for?
So previously, site visits were always part of USCIS arsenal. The FENS arm of USCIS, which is the fraud detection unit, always was involved in investigating any situations where they thought there was fraud in the USCIS, in the H1B applications. But with this new rule, they've codified their authority and said we can conduct site visits to see what is happening and to request information from the employer as well as the employee. And these site visits are unannounced, but if there are attorneys that are representing those employers, they can ask the site visit to be rescheduled so that the attorney can be present. The attorney can join by phone as well, but it is possible that they can reschedule it to allow the attorney to be present. But they are very, very clear that if the employer or the employee do not cooperate or provide the requested information, it can result in the denial or revocation of the H1B. So it is absolutely critical that employers are prepared for any site visits. They are prepared with having all their documentation absolutely in order so that they are well ahead of the curve. In addition to the site visits, I anticipate that under the Trump administration, the site visits will definitely increase given the focus on enforcement. In addition, I imagine the I-9 audits will increase under the Trump administration as well. So those two, while separate, are all part of the immigration compliance, which every employer, if they are not thinking about, should think very, very seriously about. These are not things to take lightly. There are severe consequences
Yeah.
of not being prepared, including revocation of petitions, including fines and criminal penalties in some situations in an I-9 situation. So there's a lot to be prepared. And I urge all employers to talk to their immigration counsel, talk to their attorneys, and get ahead and be prepared for what's coming very soon.
Absolutely. I think everyone should be very much aware about this, and they shouldn't be taking this thing lightly because some or the other it's going to harm them. But also, Poonam, as you said, that we can see in Trump's administration the site visits going to be more stricter. But
Correct.
till now, we have heard this from most of the people that most of the people are against site visit. They don't like this concept, and Trump is completely in favor of this. So, what's your take on this? Do you think that site visits can be beneficiary, or is it going to some of the other? There are some other challenges that people they might not know about it.
So, site visits are a double-edged sword, right?
Mm-hmm.
Um, For employers that are fully compliant,
Mm-hmm.
site visits help establish their credibility with the government. They help cement um, the perception that the government may have
Mm-hmm.
for how a company and the amount of scrutiny that the company may receive from the government going forward after a site visit. But for employers that are playing fast and loose with the rules, or you know on the edge of compliance and not really focused on compliance,
Mm-hmm.
this may be problematic. So it is important to focus on the compliance piece more than ever under the upcoming administration.
Right. I think very well explained. And meanwhile, we also have another viewer, Zishan. So, Zishan is here with another question that can you please talk about opening up the company or startup?
Sure. So, Zishan, welcome, and great question. Lot of students, lot of individuals want to start their own companies as a student on OPT or so on. And up until now, being you could start a business on OPT, but when it came to STEM OPT, you couldn't, or you could, but they could. I mean, there were ways around it, and there still are ways around opening your own and working on your startup while you're on OPT or STEM OPT. But then what about after you're done with OPT and STEM OPT? What was the path forward? Up until these regulations, there was no path forward. Now there is a path forward. Individuals who have a majority ownership in their companies, not them individually. So the government has made this distinction. It is not individuals, not entrepreneurs who are looking to sponsor themselves that will be able to benefit from this rule. It will be individuals who set up a formal entity, a company, of which they may own the majority share, majority ownership, but that company is able to sponsor the owner for H1B as long as the individual is working in a role or performing duties that are majority specialized in nature, that are aligned with their degrees, that have a direct connection to their degrees, and for the majority of the time, they're performing that role. The government does not expect 100% of the time to be on those specialized duties, but only a majority. They've given and acknowledged that a company owner needs to do other things, whether it's making copies or making calls or seeking investors or pitching to business or pitching for funding or anything else, as long as that running of the business does not overtake the individual's role, they can qualify for H1B. One of the guardrails that they have put in place to prevent fraud and abuse of the system is that the petition will be only valid, that H1B initial petition by an entrepreneur for their sponsored by their own company for themselves will only be valid for 18 months, and then it can be extended for another 18 months, during which time they will have to show the government what percentage of time they've been spending on what duty. And once, if the government is satisfied, they will extend that initial H1B for an entrepreneur by another 18 months. And then after that, they can get a full 3 years. So they will be able to get a full 6 years with their own company without relying on any other employer, which is groundbreaking by any stretch, which is monumental and a welcome relief for entrepreneurs.
Wow, that's so good. Okay, so Zishan, I hope you got your answer. And still, if you have any follow up question, then please go ahead and post them on the comment section. And we have another question from Chetali as well. But here's a request, Chetali, please wait for some time. We have another questions also. So let me take from YouTube user also. That's Kunal. So, I own a small tech consulting firm and rely on H1B workers for critical projects. With this new rule prioritizing higher wages, does it mean I'll be forced to pay top tier salaries just to stay competitive? What options do small businesses like mine have?
Kunal, welcome and thank you for that question. I want to clarify one thing. There is no requirement under this new rule that forces employers to pay higher salaries. The employers are required to comply with the LCA requirements. An LCA is a labor condition application, which is a prerequisite for an H1B.
Mhm.
An LCA mandates that an employer pay an H1B employee a prevailing wage. That is mandatory. That does not change. And nothing about that LCA or the prevailing wage is changing under this new rule. So if you were competitive under the previous version of the H1B rule, you will remain competitive under this new rule as well. Nothing's changing from that perspective. The only thing I would urge you to do is to make sure that you're following, um, taking steps to ensure all your immigration compliance pieces are aligned. For LCAs, your public access files are available because there will be more and more Department of Labor audits that I anticipate under the new administration. There could be site visits for smaller employers. If you're placing employees at third-party sites, then what is the difference between whether those employees being placed are the employees being placed on a small project, which is a discrete short-term project, or is it a long-term assignment where that employee becomes a part of that company's hierarchy and organizational structure, and you are providing additional talent to that company. So the requirements have changed in those two scenarios, but by and large, from a wage perspective, nothing has changed. So I don't think you have anything to worry from a wage perspective, but there are other things that you need to be mindful of.
Absolutely. Thank you so much, Poonam, for your answer. And Kunal, also, I hope you got your answer. But still, if you have any other question or still you're navigating any tricky legal issue or want to have guidance, then you can also contact Attorney Poonam Gupta. And you can email her on info@summit-legal.com. And you can also visit her website, that is www.summit-legal.com. So this is for all our lovely viewers who all are watching us right now. You can also contact Attorney Poonam Gupta, and I'm sure she is going to give you a brilliant advice and definitely going to navigate all your legal issues smoothly. All right, so let's move ahead with Chetali's comment. That is, what about employees working remote? Is there a requirement for the employer and employee to be present at the company site?
Great question, Chetali. The government has refrained from imposing limitations on remote or in person or any of that. All they've said in this new rule about this requirement is whatever the employer's preference is, the only thing they need to be mindful of is that they're complying with the LCA requirements. If an employee is going to work 100% remote, and there are plenty of companies that are fully remote that don't have any employees on site, then as long as they are mindful of where their employees are and that the employees are only working from the location for which they have an approved LCA, they should be fine. If the employees move to a different location, please note it is now codified. It was always, has been required for a few years since the decision in matter of Simeo, but now it's codified under these new regulations as well in this new H1B rule, is that anytime a new LCA is required, an amended petition needs to be filed. The employee can start working as soon as the petition is filed, but there is no grace period for that amended petition to be filed. If there is a change, the petition must be filed before the change takes effect. It is absolutely critical to note that there is no grace period from any changes, material changes to the H1B. And that includes change in location outside of the certified LCA. If person moves to a new area, then a new LCA is required and a new H1B petition, an amended petition is required. And for that, as long as the employers are complying with that and mindful that the employees are following those rules and staying put, then there should not be an issue. There's no requirement that that USCIS is not managing, micromanaging where an employer and employee need to be. All they're saying is that employers should comply with the DOL and regulations pertaining to LCA.
All right. So, Poonam, we have another questions too from our Facebook people as well. But I would like to ask one more question from you: that how will the new rule is going to impact the companies that place H1B workers at third-party client locations?
So third party, I believe I talked about this when in response to Kunal's question, but third party placement, the one benefit is that there is no requirement to include an itinerary with the petition. But what is required, and the government will inquire, is they can ask for contracts. They've codified that. They said we will ask for contracts, any relevant information that helps us understand what the relationship is. And then the nature of inquiry that they have is twofold. One, what is the nature of that placement? Is that placement a short-term discrete project placement? And the employee, the staffing company, for instance, are they placing them for a project that is discrete and not adding to the headcount or supplementing the company's headcount? Or is it an additional talent that the staffing company or the company is providing to the end client such that that placement becomes part of that headcount or that organizational structure and a critical piece of that function within that company? In the latter situation, where the employee is placed as part of a bigger team within the end client, then the big change now is under these new rules is that the requirements, the education and degree requirements for the role that is being filled at the end client control. It is not the H1B employers, that requirements that control. It is the end client's requirements that control. So if the end client requires X number of years and degree in a specific area, then the employee has to be able to meet those requirements, and the government will ask for those specific requirements. So please be prepared to ask for those requirements from your end clients and be very clear that that is something that may be required. So that may be something employers will be asked to share their MSAs and contracts and statements of work and so on. But please be mindful that the government can also come back and ask for requirements, the degree and the position requirements for the position that's being filled at the end client.
Absolutely. They have to be very mindful with this. And thank you so much, Poonam, for taking these questions up and explaining all them in detail. And we also have a few questions that I would like to take. That is of Roshni's. Wait, this one. Yeah. So Roshni is saying that I work in a non-tech field, specifically healthcare. It seems like this rule is designed around tech jobs with high salaries. So do you think that workers in fields like mine will be at disadvantage under the new system?
Roshni, thank you for joining, and a great question. So, while there is a lot of discussion around IT companies and staffing agencies and so on, there's actually a huge advantage to companies, potentially in the healthcare industry, if they are affiliated with a hospital or a university that is a nonprofit. There is, as I mentioned very briefly in the beginning, there is an expansion of the definition of cap exempt. Currently, hospitals and universities are allowed and do benefit from not being subject to the H1B cap. And with the expansion of this cap exemption, um, my sense is that the healthcare field will benefit even more and not less. So there is actually a bigger advantage to the healthcare industry, in my view.
All right. So, thank you so much, Roshni, for your answer, and sorry, for your comment. And let's take one more that is of LinkedIn user that we got right now. And it's saying that does the end client, in case of third party, need to provide a job description?
Correct. And thank you for joining. Yes, the end client, again, USCIS could ask not only for a job description, but also for the position requirements in terms of education and experience that is required for that role to determine whether or not whether that individual who's being filled in that role qualifies for that role. So yes, job description can definitely be required in addition to the requirements.
Okay. So I think from control we got to know the user is Jigarji. So welcome Jigarji, and thank you so much for your question. And it would be lovely if you could also ask another question that you would like to know, and we will definitely take them up. Meanwhile, I would also like to take Ashwarya's question. And she's saying that if my employer decides to sponsor me for an H1B but can't afford to pay the top wage levels, will I still have a fair chance in the lottery, or is it now all about money?
Ishwarya, thank you for joining, and that's a great question. So the one thing is very clear and has always been clear that the H1B program is designed to protect not only US workers but also foreign workers. Every employer is required to pay a prevailing wage as they attest to on the labor condition application included with the H1B. An employer cannot bench an H1B employee without paying them. There is no benching time that's permitted under H1B. So if an employer cannot pay the prevailing wage, then there is a problem. But it doesn't have to be top wage levels. The wage level is determined by the job description and the requirements for the role, and as well as the location for the role. So if your role, like some of the situations, and a legal way to get around the wage level issue in some situations is to move away from areas where the wage levels may be higher and move to locations where the same role can be performed for a lower wage. So if the role, for instance, is a remote role, then it is perfectly legal for the company to mandate that the employee work out of a certain area that is not as high in their salary. And if the employees do not conform to being restricted in that area, then the employees are exposing the employers to compliance issues and violation of H1B. So it's in both the employer and employee's interest to manage and make sure that they comply with the LCA requirements. And as I said, it is not about paying the top wage levels, it is about whether or not it complies with the law. And in terms of fair chance in the lottery, The lottery is not determined by what wage level you're at, where you're located. It is simply now, since 2024, the H1B lottery is beneficiary centric, as in each individual gets a fair chance in the lottery, regardless of how many employers may sponsor them, or regardless of which country or which occupation or what level they're coming in at. H1B lottery is agnostic to all these factors. The only information the lottery requires is the individual's name, the individual's date of birth, and their passport information, purely for identification purposes and to prevent fraud. It has nothing to do with money. It has nothing to do with anything else. The lottery is completely separate. And then, if you're selected in the lottery, then the employer is required to comply with the H1B requirements, including the LCA. I hope that helps you, and good luck.
Well, that wonderfully explained, Poonam. And this was also a very eye-catching comment that I also wanted to take that out. And I have some other questions from Facebook group as well, but we have lots of viewers that has been worried on today's topic. So I think firstly I'll take their questions. So let's take Aman's question. That is, hi, this is Aman. I heard that the new H1B rules have eased restrictions, allowing entrepreneurs to establish their own companies. I'm wondering, can I continue working for my current employer while simultaneously filing for an H1B through a company I create? Is that possible?
Welcome, Aman, and thank you for joining. And a great question. While I did address the piece about employer and entrepreneurs being able to sponsor themselves, this is a nuance. The question that you raised is a nuance that is also addressed in these new rules. And that is, an individual, in addition to an individual setting up their own company and being sponsored by their own company, they're also able to file for a concurrent H1B where they can work for multiple H1B employers as long as they have a valid H1B approved for each employer, whether it is one employer or multiple employers. And in the scenario that you list out, you could work for if I'm understanding you correctly, you're planning to work for two employers. One is your current employer, and the second would be your company where you are the owner and your company would be your employer. And yes, that is possible. Concurrent employment is possible. And one of the nuances that may benefit someone else, if not you, Aman, would be that the individual, if they are able to find or they're working at a cap exempt H1B employment, they could work for their own company simultaneously without going through the lottery ever, as long as they continue to work for that cap exempt H1B. I hope that helps, and good luck.
All right. So I think, Aman, you had a great question, and we would like you to ask more questions. It would be so great to answer your comments and your questions. And next, we also have another question from Jigger, I guess. And he's asking that my LCA is filed for another state at client side. Client has allowed me initial 2 months to work remote to prepare for relocation. Do I need to change anything in the petition?
So if your LCA is filed for a state another than where you are currently, the client does not have. I'm not sure I fully understand what you say. The client has allowed you 2 months to prepare for relocation. Does that mean that your LCA has your current location as well as the client site, or only the client site? If the LCA only has the client site, then you are not permitted to work from any location other than the client site. If the LCA lists your current location as well as the client site, then that flexibility makes sense where the client is saying you can work where you are for 2 months, and then once in 2 months, you need to relocate to where the client site is. So this is the only piece that I would request that you check. If it is both locations, then you're fine. Nothing needs to change. Yes, thank you for confirming that it has both, because that is critical. So if it has both, you're fine. The client has given you the flexibility and the comfort of taking 2 months to relocate, but you need to move to the client site within the 2 months as they have requested.
All right. So I think, Jigar, you got your answer. And still, if you have any questions, then please feel free to comment them. And right now, I think, Poonam, I would also like to take some of the questions, that we got from our last episode. So, Control, I would like to share the screen, and also want to know, Poonam, that, from our last episode, we got some questions. So, I would like to take them up as well.
Sure.
So,
Um,
yeah.
and
Mhm.
also, I believe there is a question from Sudhir in the chat that we should address as well that we didn't get to. But happy to answer this J1 while we look up that Sudhir's question. Could you please put up the J1 question from
Okay,
last?
okay. Okay, Poonam, so let's take the Sudhir's question first.
Oh, sure.
I
Whatever.
think I think now we are getting confused, but that's okay. Let's take Sudhir's question first. So, yeah. So here's a question that Sudhir is asking, that I have heard there's more scrutiny on the employer-employee relationship under this rule. I frequently place H1B workers at client sites. So what does this mean for my business, and how can I prove compliance to avoid trouble?
Great. Thanks, Sudhir, for joining, and thank you for that question. As I have been harping on incessantly on this topic today, immigration compliance is critical. You need to have documentation to prove the employer-employee relationship per se. All you need to do is to show that you control the employee's work and you are managing their work at the client site. In terms of how to avoid scrutiny, as long as you are compliant and have all the paperwork that shows the agreement that you have with the end client, what work the H1B employee will do at the end client, what are the requirements for the end client, and the distinctions that I made between whether it is a discrete project for an end client versus whether it is a headcount increase for the end client. As long as you have clarity on that, if it is the latter, you should get the job description and the requirements for the role and ensure that the employees that you place at before you place the employees at their role, so that you can confirm that those employees will qualify for H1B. Um, as long as you have all your documents, I don't anticipate that you need to do anything extra on top of it. But you do need to maintain your corporate documentation and your contracts fairly carefully and more diligently and much more organized, so that if you're ever questioned about it, you have them handy. And it may be worth discussing this change with your end clients to say, so that they are prepared for providing that information. There are plenty of clients that we've heard where the end clients are hesitant and reluctant, and sometimes outright deny any requests for cooperation for H1B for employees placed on their site, on client side. And it's worth proactively bringing this up with your end clients so that you can avoid any compliance issues or any scrutiny down the road. But if you are compliant and if your end clients are cooperative, then it should not be an issue whatsoever.
All right. So here we have another question from Amit too, and Amit is saying that I run a staffing agency and place H1B workers at different client locations. So does this rule mean I'll have to provide more paperwork or evidence of work relationships? If so, then what kind of documents are we talking about?
Great. Thanks, Amit, for joining, and thank you for that question. You are correct. There is a possibility that you may need to provide more paperwork and more evidence of the relationships. Um, it's up to the government what information they want, but proactively, when you're filing these H1Bs going forward, I would suggest, at least for the petitions that you file after January 17th, to include proof of any end party placement. If you are placing them at a third party, then proactively provide your contract with that third party, the statement of work, the scope of work, and again, if it is a discrete project, then you don't need to provide anything else. But if it is a headcount increase or where the employee will become part of the organizational structure of the end client, then you should proactively ask for the job description and the job requirements for that role and provide them with the H1B filing and prove that the employee has the necessary skills and the specialized knowledge to qualify for that H1B. So yes, there are more documents, but they are common sense documents. But agreed, it is more burdensome. There is a higher burden in that sense on the employers, but the goal is to ultimately prevent fraud and abuse, which ultimately benefits everyone. So in short term, yes, it is problematic and more burdensome, but long term, I think it only helps all of us if we proactively provide all the information upfront without the government asking for it.
Absolutely. Wonderfully explained, Poonam. And I think, our viewers are also loving your insightful conversation that you are sharing with us today. And also, we have RK. So let's take RK's comments as well. So RK is saying that why so must employers concern about site visits? With more site visits, it can help with the improving the views that there is a lot of fraud in the H1B program.
Right. So why should the employers be concerned about site visits? Up until now, the site visits it was optional to cooperate with the site visit, if you will, but now it's mandatory. Under this new rule, employers and employees are mandated and required to cooperate with the government. If they do not, then the H1B petition could be revoked or denied, depending on where they are in that state. If the H1B petition is pending and then the site visit happens, then if the employer does not allow the FDNS officer, access to the site to whatever documents they want and confirm whatever information they want, then there is the potential for denial of that H1B. If the site visit is after the H1B is approved, then, and if the company does not cooperate or does not provide all the documents, then there is the potential for revocation and more site visits. So it is in the best interest of the employers to comply with the site visit requests and help address any concerns for abuse. And I have to tell you, these site visits are random and common. We've had situations where employers, like the same employer, had 3, 4 site visits in a span of 1 month. And it all worked out. The questions were not crazy, intrusive, or in any way something that were not anticipated. And there were no questions that we did not have easy access to. I would also highly recommend, whenever you get notified of a site visit, or if an officer just shows up at the door, which most of the time they will, then you should call up your attorney. And if the attorney cannot join by phone, or if the attorney wants to join in person at the time of the site visit, to request the officer to reschedule the site visit at a time when your attorney can be present. I would not recommend any employer to go through the site visit without their attorney, just because it gives the attorneys able to address those questions and address anything that the officer may be asking that they should not be asking right at that point, and push back if needed. But most of the time, in my experience, it's a fairly straightforward request, and just providing that information helps not only that employer but everyone else.
Absolutely. And I think, Poonam, site visit are being a very hot topic nowadays. People are very much concerned about it. And I think we have another follow up question or follow up comment from RK, that is, with more sites, this will allow the government to publish data to show X amount of companies and compliant. This concern about this provision may wrongfully imply that there is a lot of fraud. What do you say?
Thanks, RK, for that. I'm not sure exactly what you're trying to say, but what I can discern is that the government occasionally does publish the site visit data, or other data, not necessarily how many site visits they've conducted, but they do provide some data about the workings of the FDNS. And there is a there is some fraud in the H1B program. There are some unscrupulous employers that want to take advantage of the H1B program, that exploit workers and do not pay them as they should, or do not comply with the LCA requirements. And that is the goal of the site visit, to identify such unscrupulous players, such unscrupulous employers, and take them out and shut down their programs so that it doesn't impact the integrity of the broader H1B program and everyone can stay compliant.
Absolutely, and I think that's how, anyone. I mean, I don't think that there should be anything that people should be scared of site visit, because if you have proper documents and if you are fully aware with all the updates, then I think it will be safe and there's nothing to be worried about. And sooner or later, it's very important, friends, to stay updated. So yeah, that's what I would like to share. And here's another question, that is, does the new rules regarding end client documents also apply for assignments started and petition approved before 17 January as well, or only for new petitions?
Thank you for asking that question. It's a great question. And yes, these new rules go into effect on January 17th and will only apply to any petitions that are filed on or after this date. So if anything is initiated or approved before this date, these new rules will not apply. But to be very clear, these are just codifications, and some of this USCIS is already doing and already requesting proactively. And all the new rules do is codify and request that an employer is mandated to provide these. Up until now, the government would issue a request for evidence asking for this information if they felt that the employer did not provide sufficient information.
All right. Also, Poonam, as we have crossed 1 hour, so I would just like to know it from you. Is it okay if we could extend for 5 more minutes our session?
Sure,
Oh,
we can.
that's
I know there's a lot of questions, and there will be a lot of questions if people become aware of this.
absolutely.
And happy to answer as many questions. So please keep those questions coming. We have posts on LinkedIn and all the other platforms. Please continue commenting. We will continue to address those questions even after this event is over, and if needed, maybe come back another time. But for now, please continue to comment and post your questions.
Absolutely. That's so sweet of you, Poonam. And also to our viewers, as Poonam said, that please go on commenting and posting your questions. And even after the show, even after the event ends, we will definitely take them up in our upcoming shows as well. So here's another, here's a comment that we received. Thanks a lot, team. This is really insightful to be prepared proactively. Thank you so much, Jigger. I hope I'm pronouncing your name correct. If not, then please write your name properly so that I can greet you well with your name. But also, Poonam, I would like to ask another question regarding the topic, that are there any potential challenges or drawbacks, that employers and workers might face under this new H1B rule, despite its pro immigration and tech friendly aspects?
Um, the challenges, the biggest challenge may be the compliance piece, and for as you've seen, the questions that have been coming from staffing agencies and companies that face employees that and clients, the biggest concern is the additional documentation. That I think will be the biggest burden under these new rules. Other than that, it's just codification. The benefit will be far more than the drawback. I think the only drawback will be additional documentation.
All right. Okay, so I think we can see very less challenges here and more pro immigration and tech friendly aspects in this new rule. And that's absolutely perfect, and that's lovely to know about it. Also, I would like to now come back to the comments that we received from our last episode, because that is also very important to cover. So, Control, I would like to let us know about the comments that we got to know from our last episode. That is, I am currently on J1 visa and my visa expires in 2025. My spouse, who is a J2, his company is offering him L1 from India to the company here in US. I am not on government funded program as I am directly working for public school. Will he be able to transfer from J2 to L1 with recent changes to the skill list?
I'm assuming this person is from India, Sam. Assuming this person is from India,
Right.
then yes, they will be able to transfer because India was removed from the skills list and there is no 2-year home residency requirement applicable for this individual. To be 100% sure, my recommendation would be that they request an advisory opinion from the Department of State to avoid any surprises, because while the J1 skills list has been updated, the officer's knowledge and comprehension of those rules may take some time to catch up. So, to that end, I would urge everyone that is in a situation where they think they will not be subject to the 2-year home residency requirement to please request an advisory opinion from the Department of State to benefit and to get clarity, have something to show when you go for that counselor appointment or when you apply to USCIS to support your not being subject to the 2-year home residency.
Absolutely. And here we have another comment too. That is, hello, I'm an Indian citizen. I was in J1 visa during the year 2021 as an exchange student. My program was self funded and I was subjected to 212E clause. I'm currently in US in my F1 visa. I didn't complete my 2 year in India. I'm in the process of preparing for applying to get my waiver. Based on the new updates, do I still need to apply for the waiver?
Great. Thanks, Sam, for bringing that up. So 212E clause, to clarify, is the regulation or the that requires the 2-year home residency requirement. So when this person says, I was subjected to the 212E clause, it means that they were subject to the 2-year home residency requirement. And that's what they say, that they haven't completed it and were applying for a waiver. As an Indian, they are no longer required to apply for a waiver. They say their program was self-funded, so I think it is fairly clear that they do not need to apply for a waiver. They are not subject to that. Again, if they have any doubt and to avoid any confusion on any agency's part, it may be worth requesting an advisory opinion to have a government document that confirms your understanding. So that is the best way to confirm and to avoid any doubt for anyone at any point.
All right. So yeah, I think these two comments were from that we received from our last episode, and I think Poonam, we have covered all the comments, all the viewers' question that we have received regarding our today's episode. So I think, yeah, that's lovely. And we also have come across 1 hour and we didn't even realize. And it's been more than an hour because it's obviously a very new topic. And thanks to you, Poonam, for, letting us know, for suggesting this topic. It's really amazing and it was so insightful. I enjoyed a lot this session and I hope you too. But meanwhile, also, Poonam, any last tip or any last message that you would like to share with our so many viewers today?
Sure. One of the things that everyone is concerned about, that we didn't get to talk about, is whether this new rule can be um, turned upside down or retracted when the Trump administration comes into office. The new rule goes into effect January 17th. The new administration comes into play on January 20th. What can they do to retract this new rule? So there are a few ways that things can change. One is obviously they can go to court and prevent something from going into effect or any of that. If that happens, obviously we will keep you posted. But barring that, all the other pieces, all the other actions that they could take are not immediate. If they want to modify the rule or change the rule drastically, they have to go through the notice and comment period that this rule went through. So, as I mentioned, this proposed rule was first issued in October of 2023. Comments were open until December of 2023, or November, 60 days. And then after that, the government issued a limited portion of that rule to implement the changes to the H1B lottery. And again, it's taken them almost a year to address all the other comments that were raised with regards to this new rule, and they've issued this rule to go into effect. So any changes to this rule will have to go through the whole notice and comment period again, which will require some time. And even the best case scenario, it is at least a few months, potentially longer, before any changes can be implemented on a regulatory side. The Congress can always enact a new law, which, knowing what we know, I mean, with the government, I don't know, I haven't looked at the news this morning, but as of late last night, the government was going to shut down because the Congress couldn't come to an agreement on the budget. So how well and how quickly that will pass is anyone's guess. So to the extent that gives anyone any comfort, this rule is here to stay, at least in the near term. There are plenty of enforcement provisions within this that align with the incoming administration. So I'm hoping that, given the enforcement bent of this new rule will be left alone, and the new incoming administration also has different priorities, and this may not be as high on their priority list to tackle as other things, and mass deportation seem to be the top matter, and this is far from it. So I think we may be okay, but only time will tell.
Absolutely. And with Trump's administration, it's so unpredictable. We can't even predict what's going to happen. But
But we'll deal
let's,
with it.
yeah, absolutely. Let's see and what happens. And I would say, with that, Poonam, we have successfully done with our today's episode. And friends, we talk about the new H1B rule, where we covered everything about, like, how is it a game changer, what are the key changes, and how is it impacting both the workers and the employers, and also what you need to do to stay ahead. So I think, these were some of the very important topics that we talked about. And also, I would like to say, Poonam, that your expertise and your clarity on this topic, made everything so much easier to understand. And I'm sure, that our audience learned a lot from you. They loved your insights. And it's been a really pleasure having you on the show. And we are super excited to have more shows with you.
Likewise. Thank you, Sam, for having me. And it's great to be able to address the questions and, calm some of the people, the immigrants, get riled and get upset and anxious very quickly for good reason. And I'm happy to do my part to help whatever I can to help the immigrants in their journey. So good luck to everyone and happy to be here.
Wow. That's lovely and that's amazing. And thanks to our viewers also for joining us and participating in today's episode. I hope you found this session helpful. In case if you have any doubt, then go ahead and post them in the comment section. And also, if anyone is navigating the intricacies of visa applications or facing legal challenges or simply need guidance on immigration policies, then please feel free to contact Attorney Poonam Gupta on the given contact details. You can email her on info@summit-legal.com, and you can also visit her website, that is www.summit-legal.com. So this is the contact detail that has been displayed on the screen. You can go ahead and mail her, or you can also visit her website. All right. So thank you so much to everyone, to our attorney, to our viewers for joining us and making this session a great one. As always, stay informed, friends, by liking, sharing, and subscribing to the Immigration and Jobs Talk Show for more updates. I'm Sam, signing off for now. Bye bye and take care.
Hello, everyone, and welcome to another episode on Immigration and Jobs Talk Show. I'm your host, Nipasa Pradhan, and I'm very excited to have you join us today. But before we move ahead, I have this important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. And today is going to be another exciting session today, friends. Thank you so much for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook, and on X, also known as Twitter earlier. So thank you so much for joining us. And let me tell you that you can also participate on this session by commenting, and not only commenting, because I have this number where you can dial in to call us, to participate and have a direct conversation with our attorney, and that is the number is 425-436-6335. And when they ask for the access code, all you have to do is dial in 988-888 and just say hello. We'll be able to hear you. So thank you so much, friends, for joining us. And yes, as many of you know, that H1B visa is a very critical pathway, for foreign professionals seeking to work in the United States. And it's been subject to various updates and changes over the years, and even in this year itself, when we look back. So in today's webinar, we will be diving into these new requests for evidence, or RFEs, that are expected in H1Bs in the year 2025. And these RFEs can be quite challenging, and understanding what to expect is key to ensuring a smooth application process. And of course, to help us understand and explore these better, especially this topic better, I'm really thrilled to have with us none other than a very experienced and knowledgeable immigration attorney who has been with us for a long time. And yes, it's very nice to have attorney Chand Parvathaneni from Dallas, Texas, SPB law firm. Chand has been a trusted expert in business immigration, and he's here to shed light on the potential RFEs how they may affect H1B petitions, and most importantly, how to prepare to avoid them. So, thank you so much, Chand, for joining us today. I'm really excited for today's session.
Sure, Nipasa. Thank you so much. And in general, I mean, we're entering a new year, 2025. And what's different this year is we're going to have a new president. We're going to have a new administration. So a lot of things, more than likely, are going to be done a little bit differently. Nothing is going to change drastically because there are rules out there. There is a process out there. But the way the things are handled could always change. The priorities of the new administration could be different. So what that means is the way things are done are slightly going to be different. Will they completely stop H1B? No, it's not going to happen. So things will still continue. The only thing is the parameters, the way the regulations are interpreted. So those kind of things might change. And what that also means is in the last 4 years, we had a Democratic administration. And prior to that, we had a Republican government under President Trump. And we have seen how things happened between 2016, 2020 time period. We have seen a lot of memos, USC has memos being released during those 4 years, also during last 4 years, and so on. And what that means is every time you have a new administration, they're always looking at how things were done in the past. They're trying to look for ways to refine the process. And every administration has a different way of doing things in a format where they think they're going to get things more refined. And from that perspective, and from the priorities that the new administration is coming out with, we do anticipate maybe some challenges, maybe some refinement. Some things will get a lot better, some things will get a lot worse, and so on. And we're going to use this time today to discuss the upcoming challenges and what kind of RFEs, especially as it pertains to the H1B world, what kind of RFEs employees can expect and how they can try to be ahead of the curve and be proactive in making sure they're not completely caught off guard and doing things the right way, complying with the law. Because as long as people comply with the law and they meet all those requirements, in general, nothing majorly should change.
Mhm. Right, right. Thank you so much, Chand, for giving us an overview, kind of, for what we will be covering today, and we are looking forward, definitely. And well, we have Mayan, who has a comment already on Facebook. I would say just stay with us, Mayan. We are going to address your questions, and all you folks out there, yes, you can comment, and remember, you can also dial in. You can call us to have a conversation with us, and especially with Attorney Chand today. So the number is on the screen, and we are here. And I think without further ado, Chand, let's move on with our questions that we have for today. And my first question to you is, what new trends are emerging in the types of RFEs being issued for H1B petitions in 2025?
So the trends in request for evidence issuance for H1B petitions, they keep on evolving. And as we approach 2025, I think we're already seeing some emerging patterns that could shape the process. And I think what's going to happen in the last 4 years. So prior to 2020, when we had the old President Trump's administration, and also when we had President Obama in the office, there was a lot of focus on employer-employee relationship. So pretty much majority of the RFEs were about employer-employee relationship, looking for client letters, looking for vendor letters, looking for contracts, and so on. And starting 2021, the focus on employer-employee relationship decreased a lot, at least in the terms of the RFEs that we are seeing. The reason is there was a lawsuit in 2020, and then USCIS went back and rescinded a couple of the old memos. So the focus changed from employer-employee relationship to a lot of other things. And what we have been seeing in the last 4 years, uh, a lot of focus on the beneficiary qualifications, a lot of focus on the degree requirements, the educational qualifications of employees, the work experience, the nature of work experience of the employees, sometimes specialty occupation. So these are the kind of things that we have been seeing in the last 4 years. Starting 2025, I do expect more focus again on employer-employee relationship, and especially when you have jobs involving a third-party work site. So a third-party work site is where you have an IT services company or an IT consulting company. They place their employees at a third party, so at a client location. Those kind of cases, I do expect renewed focus again on employer-employee relationship. How that will happen, we don't know. Whether we'll have some memos or whether the government is going to follow the Administrative Procedure Act and change a couple of things. How they will do it, we don't know. But I can definitely expect some additional RFEs on employers' supervision, their control, and how the control happens, especially when you're on a third-party work site. So definitely renewed focus on employer-employee relationship more than likely will come back again. And also the specialty occupation scrutiny. So we are slowly seeing trends where we are seeing more and more RFEs again slowly increase on the specialty occupation side. So the specialty occupation RFEs, their entire focus is this job even a complex job that you really require a H1B? That is what is typically what a specialty occupation RFE says. They are targeting the nature of the job, that they're trying to see if the job is really a complex job that really requires a bachelor's degree in a specific field. So these kind of RFs tend to ask for more detailed job descriptions, look at what exactly is happening in the industry, look at the industry standards on the entry level job requirements, and so on. I definitely think that seeing the recent trends, recent kind of RFEs on specialty occupation, I do suspect that that will again come back in 2025. In 2017, 2018, we saw the same problem. So back then, they used to argue that computer programmer, for example, is not specialty occupation anymore. So we saw a whole bunch of RFPs, a whole bunch of denials back in 2017 for computer programmers. So if there is renewed scrutiny on specialty occupation, what is going to happen is we will have to wait and watch and see what kind of occupations will be challenging, because USCIS can come back and change a few things around specialty occupation and argue a few occupations are not specialized. And going back to the historical evidences that we have, the computer programmer is a good example, because in 2017, we had a huge problem with computer programmer specialty occupation issues. And then the wage levels. 2017, when President Trump first took the office, all of a sudden, we suddenly started seeing wage level RFEs, wage level 1. So until then, we have never seen wage level 1 RFEs. And all of a sudden, USCIS was arguing that wage level 1 is probably not appropriate for specialty occupation. We still see it, but on a very, very reduced level. So more than likely, I think we might see a renewed focus on wage level 1 cases. It will not be a blanket denial, but I can expect more RFEs on the wage levels. And the usual things that normally happen, the degree requirements, beneficiary qualifications, experience of the employees. So those kind of things, I think, will still happen with renewed scrutiny. So that's pretty much what I think we definitely can anticipate in 2025.
Yes, definitely. And we are looking ahead, like you have mentioned earlier, Trump's second rule, and we can expect many things to come back. And well, he may make it a little more difficult for, immigrants out there, if possible, maybe making it harder with RFEs. But let's see what can we expect, and
Yeah.
we will unfold this further as we keep on discussing today in this episode. And we also have Balakrishnan, who has another question. And Balakrishnan, thank you so much for joining us on YouTube. Please stay with us. We will address your questions. But yes, for now, Chand, another question, is that in cases where an employer is a startup or a small company, what specific documentation might USCIS request in an RFE to prove the viability of the H1B position?
So so on the I-129 form, the form that is used for filing for H1B, there is a question that talks about the number of employees that the company has and also the income of the company. So upfront, USCIS will be looking at the nature of the company, whether it's a small startup, or whether it is a big company, or the revenues are low, and so on. Apart from that, USGS also does a vibe check. So they do a check where they do a background check to see the nature of the company. Things like what's coming up on various reports, the DNB report, and so on. They typically will be analyzed. And if USCIS, they feel that the company is a very small company, or the company is a small startup, it is pretty normal to question whether the position is even viable, because the salaries on H1B, they are very high salaries. It's very common to see a six-figure salary for a IT professional on H1B. The average salary nowadays is around like 95,000 to $100,000 on an average for IT professions. So when you are required to pay such a high salary to your employee, and the company's financials or the nature of the company doesn't look like it has the money to pay for such a high tech employment, it's only normal that USCIS will question the startup. So when that happens, so what you are supposed to do is you're supposed to submit a detailed business plan. Sometimes USCIS may just come back and ask for a comprehensive business plan. Lately, we have not been seeing those RFEs, but in the past, it was very common where USCIS came back and put a lot of emphasis on marketing analysis, cost analysis, financial projections, the nature of funding for the in-house projects, if it is an in-house project, the nature of the contract, if it is a third-party contract, the duration of the contract, whether it is a short-term duration, whether it's a long-term duration. So all the things are possible, and USCIS, it these kind of documents help USCIS to understand the company's operations, and it also helps to prove to USCIS that the position offered is legitimate and bona fide. And not only that, it is also essential, and it is a position that is in the regular course of the company's business. So that is very important. And what that means is small and startup companies, they should always ensure that their financial documents are readily available and logically prove that they have the resources to support the H1B employment. So things like bank statements, profit and loss statements, tax returns, and sometimes if the company is a very, very brand new company, maybe things like investor funding or capital funding, because sometimes it's a startup. The people who are starting the business, they're actually investing into the company. So evidences of investor funding. So these are all good evidences because we do want to show that the company is financially stable or financially able to support this H1B position. So that's very important. And for small companies, another important thing is the detailed job description. So the detailed job description specifying what exactly the employee is doing and how that is relevant to the company's line of business. Sometimes a small company could even be an IT consulting company. Sometimes it is a product company. Sometimes it could be an implementation partner. It could be anything. And it has to be, this job description has to be relevant to the regular course of business. It should also show how the employee can supervise, I mean, how the employer is supervising the employee. Because if it's a very small startup, sometimes USCIS will question on the specialty occupation. Because if the company is so small, USCIS wants to know who's doing the other non-specialized tasks, such as payroll, such as other non-technical functions that are required in the company. So sometimes you have to have an org chart to show how you're splitting up the specialized duties and non-specialized duties and who's doing the non-specialized duties. Because a small company sometimes tend to put all kinds of duties to the employee because they're like only like 2 3 people shop. So USCIS, we need a very good demarcation of the duties, and only specialized duties have to be assigned to the employee. So these are the kind of things that USCIS is very interested, because their goal is to make sure the position is legitimate, the position is bona fide, and apart from that, they also want to make sure that the employee is not given all the tasks, such as HR, marketing, all those non-technical tasks to the employee because the company is a small company and they're trying to get everything done by this employee. So the bottom line is the job description should be very, very unique, specialized, and should focus on the technical part. Employee can only be assigned those duties that are a part of that occupation. So these are the kind of challenges that a small startup company could have, and the best way is document the nature of the company, provide various financial documents. Doing so, normally we typically don't have a problem. I've seen a lot of companies who have like 1 2 3 employees and look for H1Bs, file for H1Bs. As long as the company is legitimate, the position is a bona fide job offer. Even if it's a small startup, yes, you can get an RFE, but in general, USCIS is pretty okay as long as there is a logical reason, logical answer to the need for that position.
Absolutely. Thank you so much, Chant, for highlighting that and very important things to keep in mind. Thank you so much. And moving on, Chand, I have another question. And now this is, how has USCIS's scrutiny of the employer employee relationship changed in the recent RFEs for H1B petitions? And what should employers be mindful of?
Yeah. So 2010 to 2020. So during President Obama's administration and President Trump's initial administration, those 10 years, USCIS had a lot of scrutiny on employer-employer relationship, especially for any IT consulting or IT services company that had a third-party work assignment. So anytime you have an IT consulting company where they had a full-time employee, their full-time employee was providing services at a client location. So that's a third-party work site. So for any of those cases, 2010, 2020, the scrutiny was very, very high. When I say the scrutiny was high, USCIS was asking for client letters and letters from every vendor that was involved in that chain. And if the client did not give a letter, denials were common. This used to happen. And the reason for that was they wanted to know what was the role of the client, what was the role of the vendor in that whole chain. And they wanted to look at all their letters to see how that supervision happened. So that was what used to happen. And in 2020, so there was this lawsuit by IT Serve against USCIS, the government, and IT Serve prevailed in that lawsuit. And what happened was, because of that lawsuit, USCIS went back and rescinded two of the prior USCIS memos. And that changed the entire definition of the employer-employer relationship. And because of that court case, what happened is USCIS said, as long as you can show at least one of the factors, such as like right to pay or something, you are good to prove the employer-employer relationship. So if a company pays the employee, treating him as a full-time employee, that is enough to show employer-employer relationship. We don't need client letters, we don't need vendor letters, etc., to prove the employer-employer relationship. So what that meant is, starting from 2021 to 2000 right now to current timeline, the focus is very low on employer-employer relationship. The reason is, we don't need client letters to prove employer-employer relationship anymore. If the employer is just attesting to paying the salary, and employer is actually paying the salary, that is more than enough to prove the employer-employer relationship in the current format. So what that means is, the burden of proving employer-employer relationship has come down drastically in the last 4 years. That being said, we don't know what's going to happen in the next 4 years, because there are already proposals out there to change a few things, to change the definition of bona fide job offer, to change the definition of specialty occupation. So these were draft proposals that were published during Biden administration. And if President Trump's administration decides to make those rules finalized, the drafts finalized, things could change. So we don't know, but at this point of time, employer-employer relationship is not a huge factor like it used to be in the past. But starting next year, more than likely, it could again come back, where we might again have to submit client letters, vendor letters, clearly stating what is the role of each and every party in the chain of relationship.
All right. At least we know now what can we be ready for. So thank you so much, Chant, for highlighting that as well. And we also have Charwak with comments on YouTube. Charwak, please stay with us. We are going to address your questions in a little bit. Okay. For now, some more questions from my end, Chant. So this is if an applicant has held multiple roles with different employers under the H1B visa. How can they prepare for an RFE questioning the job's specialty occupation status?
So again, we have this question a lot. The employee is working for one employer. He has a particular role, and he's transferring to a new employer. And when he transfers to a new employer, um, the role might not be the same. Sometimes the role could be different. For example, the employee is working as a software developer in the prior company. When he's transferring, he's changing his role. Maybe he has to work as a network administrator. Maybe he has to work as a data scientist or something different. Or sometimes what happens is, the wages might be different. Maybe he's working in a very, very senior level role in another company with a wage level 4. And when he's doing a transfer and is coming to this new company, maybe he is not getting the same salary. Maybe it's a junior level role. So the role is different. And a lot of people get concerned and ask us, will that cause a problem, that the role is different because it's a different employer, the role is different, and he has so many different roles in the past, and now the role is not similar to what they had in the past. Will that cause a problem? So per se, every role is different, every filing is different. And what that means is, USCIS, I've never seen USCIS come back and say, In the past, in a different company, you worked in this role, your role is now different, explain. USCIS does not do that. But what USCIS does is they treat every petition independently. So if they have a petition in the past where the employee got an approval, and now you have another petition where a new employer is filing for a H1B, they treat this new petition independent, and they don't really use the old petition and say, because we approved that, we'll approve this. This new petition is independent. They will still look at the job duties. They will still look at the wage levels. They will still look at the nature of the company. And when you talk about specialty occupation, if the job description is not clear, USCIS routinely comes back and says, "Hey, you're this new employer, whoever has filed the job." They will argue that this is probably not a specialty occupation job. And at that point of time, what the company has to do, or if you want to even avoid that kind of an RFE, the new employer will have to provide clear, detailed job description that aligns with the specialty occupation requirements, that aligns with the work experience or the education of the employee. The new employer has to explain why the employee has the relevant skills, either through an academic program or through a combination of academic program and work experience, why he is qualified to do this job. And by doing so, normally what happens is the specialty occupation RFE risk is minimized. So if the employer is not able to clearly define the job duties, clearly expand the job duties, and clearly able to articulate how the employee is qualified based on his education or work experience, we're going to see these kind of RFEs. So the bottom line is every job is different, every petition is different, but every time the company goes and applies for a H1B, give very, very detailed job description and explain the relevant fields of study that are relevant for the job. So if the employer goes and says, we just require a bachelor's degree in any engineering field, that is probably not specialty occupation. So the employer has to go back and specify a bachelor's degree in a specific field. For example, computer science, information technology, etc. is required. The fields have to be very, very closely related. So you cannot say this job requires mechanical engineering, civil engineering, and computer science, because then the fields are not specialized. They're like very diverse. So the way the employers should be attacking the whole H1B filing is clear and nice job descriptions. Be very specific on what kind of degrees you require, and make sure that the degrees that they require are actually what are normal as per the industry standards. So you cannot go and say, for a software developer, I require a civil engineering degree, because that is not what the industry standard is. The employers also have to align their degree requirement to the industry standard. So by doing so, they can minimize these kind of RFEs.
Right, right. Thank you so much, Chand. Those were very, very important points, and thank you so much for highlighting them. It's very important to address these issues correctly and in detail so that they work. I mean, why are they asking for an RFE? They just need more explanation on what you're stating there, and being more specific is more important, right, Chand?
That is that is correct. And again, whenever you get an RFE does not mean it's a bad thing or you're going to get a denial. Majority of the cases still get approved. So RFE is where the officer has a couple more questions and he's trying to get more answers and more evidence back from the petitioner. So RFE is not bad. Whenever somebody gets an RFE, you have to carefully look and see what's going on, and then try to explain and provide more information. And the best way is try not to even go to that situation, be in that situation. So try to be as detailed as possible. That being said, sometimes even if everything is perfect in a case, sometimes the officer might just issue an RFE because he might have some other additional questions. So RFE always does not mean that the petition filing had some issue. Sometimes it also means that the officer probably has some additional questions, and sometimes it might be just a mistake in the filing. But RFE is one good way, because people typically don't get a direct denial. RFE is one way where you're getting another chance from USCIS to explain your stand. So the beauty of H1B is you always get an RFE, you always get a second chance. That being said, everybody's goal should be to minimize the RFE. So more detailed explanation, more clear filing is the best way to minimize an RFE. But if you do get an RFE, you're in that unfortunate situation, try to explain as clearly as possible. Majority of the cases, I see them getting approved after an RFE.
All right, that is good then. So, Chand, we should address some of our questions from our viewers, and we should take up Dheeraj's question. He says, "Hi, Chand, I have a question regarding my H1B transfer." Hi, Dheeraj. Thank you so much for joining us on YouTube. So, currently, Dheeraj is on H1B and he got a new opportunity in new company, and he says he would like to transfer. But initially, when he was filing the H1B in June, he filed the H1B as future employment starting from
Mhm.
October 2024. But due to few reasons, he could not join the current company on October 1st, but joined on November 1st. So during the transfer process, will he be having any issues or will he be facing any RFEs for this reason?
Uh, so again, this is a very common situation because when you have people on H1B, they're working for a company, and then sometimes they get a better offer. And when they get a better offer, and the company applies for a H1B transfer, what happens is an employee is working at this company, a new company files for a transfer, and once the new company files for a transfer, the common question that I get is, when do you have to start working for this new company, company B that has filed your transfer? And the answer for that is you can file immediately after the company gets files the case, and the receipt is receipted. So you can start immediately once the case is filed, or you can wait until you get an approval. Number two. Number three, even after you get an approval, you can join them down the line if you're continuing to work for the company A, the first company. So as long as you're working for the company A, you can continue to work under the terms of company A's H1B, and down the line you can go and join company B. So from a USCIS perspective, as long as you're maintaining your status, you're good, which means you can continue to work with company A and join company B down the line. Only thing is, the day you join them, you have to stop working for company A, and the day you join company B, you have to make sure that H1B is still valid. If you do it, the timeline is probably not a big issue. So you don't really have to start on the day you get the receipt or the day you get the approval. You can join them later on, assuming that you're still maintaining status with the first employer.
All right. Well, Dheeraj, best thing is, I hope you got your answer, by the way. And if you still have any more questions or you want to have a conversation with Attorney Chand right now, you have this opportunity. You can dial this number on the screen, which you can see on top. The number is 425-436-6335, and they'll ask for an access code. And when they do, you just have to dial in 988-888 and just say hello. We'll be able to hear you. Thank you, Dheeraj, for your questions. Thank you, Chant, for taking that up. And let's go on to this next one. This is on Facebook from Mia Abu. I received the RFE on the November 2nd, 2024 about educational background. I think we will need more information on this, but anything you want to say on this, Chant?
Sure. I think Abu, I think what has happened is he probably got an RFE for beneficiary qualifications. This is one of the most common RFEs that we see nowadays. RFEs asking for beneficiaries qualifications and asking us to prove that the beneficiary has a US equivalent of a bachelor's degree in the required field. Uh, so the way you answer it is in two ways. One, you have to look at the education of the employee. So if your education is in the right field, is in exact, say for example, you have a degree, for example, from India in computer science, for example, and your job is in a computer profession, say for example as a software developer. If that is the case, all you have to do is you have to do an evaluation of your education. So you send it to an evaluations company, a credentials evaluation company. You get an education evaluation done, and that's all you require to answer your RFE. If your education is in the right field, if that is the case, it's a very simple RFE. Simply get an evaluation done, evaluation of your foreign degrees, send it back. One way. The other thing is, what if your education is not in the right field? Say, for example, you have a degree that's not in a relevant field. Say, for example, you have a degree in mechanical engineering and your job is as a software developer. When your education is not relevant to the job in question, if that is the case, what you're supposed to do is you are supposed to gather all your experience letters. So gather each and every experience letter where you had worked in the past, and gather your educational documents, and then have your employer send them to a university professor. So university professor in US. So there are a lot of companies that will help with professor evaluations. And what you're supposed to do is do something called a combined evaluation of both your academics, your education, plus your work experience. So when you do a combined evaluation of your academics and work experience, the US professor will be able to do an evaluation and see if it is equivalent to a US degree in computer science or a relevant field. And if that is the case, when they add up your experience, if they see that you have an equivalent degree, then you can use that to send it to USCIS, and USCIS typically will agree to a professor evaluation. So your RFE is not a very complex RFE. You just have to see if you have the right education, and if you don't have the right education, do you have the relevant experience? And based on that, get an evaluation done, provide the evaluation copy back to USCIS, and that is the way to um, tackle this RFE.
Thank you so much, Chand. Thank you so much. And thank you, Mia, Abu. I hope you got your answer. But if you have any further details about your case, you can keep commenting. And better even, you can just call us on this number, which is displayed on the screen above.
Yeah, I think
Not-
yeah, I think
Yeah.
he's added a comment. He said education is not relevant to the job. So if education is
Okay.
not relevant to the job, what you will do is you will gather all your work experience letters. So do a evaluation with education and work experience together. So together, when you combine the experience, the professor might be able to see if you're qualified or not. And if you have the right experience in the past, definitely you should not have a problem.
All right. There you go, Mia. Thank you so much, Chand, for taking it up. Now, moving on, let's take up Balakrishnan's comment. This is also on YouTube. He's asking, do you think USCIS will focus more on RFEs about the employer employee relationship in 2025? We've already touched on this a bit. His next part of the question is, what steps should employers take to avoid these kinds of RFEs?
Sure. Because right now, if USCIS gives an RFE on employer-employer relationship, we can just use the right to pay to prove that there is an employer-employer relationship. So right now, it is like very easy to prove. So what could happen is if you see what has happened in 2010. In 2010, there was this USCIS memo called Newfield memo. So they issued a memo, and once the memo was issued, they started issuing RFEs on employer-employer relationship. Same thing happened again in 2017-18. They again issued another memo, and based on that they used to issue RFEs. So right now, before USCIS can again issue RFEs on employer-employer relationship, when I say RFEs, complex RFEs, they more than likely will have to do some rule changes. So if the rule changes happen, then yes, we might see these kind of RFEs. Will rule changes happen? It is a possibility. But what happened in the past is USCIS came out with these memos without following the proper APA, Administrative Procedure Act. So without following the proper APA procedure, they came with memos, which is why they lost in the court. So there was a court battle, and in the court they did not prevail. So next time, I think if at all they want to renew focus on employer-employer relationship, especially for the third-party worksite kind of companies, they will have to basically do a lot of things. A lot of things, as in follow the proper procedure. They have to basically tell what their proposed rule is, let the public comment. Once that is over, publish what is the final rule, and again give some time, and then finalize the rule. So if they follow the entire procedure, yes, it is possible. So I don't think it is something that is going to happen very quickly like it happened in the past, because in the past they just came out with a memo and all of a sudden they started issuing RFEs. And because the court said no, that is a violation of APA, more than likely they probably will not take a hasty decision this time, but probably do sequentially follow all the procedure and do it. If they do it, then definitely I think we will see RFEs. And to see what kind of steps employers should take to avoid these kind of RFEs, that is where we see before they make the rule changes, there is a big process. They will publish the draft. They will let all everybody that is impacted comment on the rules. So USCIS looks at comments. They try to kind of reason and do things the proper way, which is why we even have this entire APA, this Administrative Procedure Act. Uh, and by doing so, I think we will know what kind of steps we have to take before the rule gets finalized. But at least as of now, it is not something that will happen overnight. So we have time, because we will have to wait and watch and see how the rule making process will happen, to see how to basically legally show that we maintain employer-employee relationship if something is going to change in the future.
All right. Thank you so much, Chand, for taking that up. And we are going to address Balakrishna's next question, but we have a caller right now, so I'm very excited about this. Hi, hello, can you hear us?
Yeah, I can hear you. Can you hear me?
Yes, we can. So, may I know where are you speaking from and what is your name? And please tell us what is your question.
Sure. This is Dheeraj here, and I'm from Dallas. I'm in year 2 intern. And I think I have posted a comment before, but I need few more clarification on that. So that's the reason for calling you. Hi, Chand. So I have Sorry.
Yeah, thank you so much, Dheeraj. Yes, very, very lovely to have you. And Chand is also from Dallas itself. So, yes, please go ahead.
Hi, Chand. Good afternoon. Nice to speak to you. And
Hey,
I have
Dheeraj.
a question regarding my H1B transfer, Chand. So basically, I'll say a whole scenario so that you can get a better understanding of what I'm facing, and you can answer on that. So currently, I'm on H1B, and I got H1B this year in October. So in my I-797A, the effective date is from October 1st. But I did not join the company, filed my H1B on October 1st, but I joined from November 1st. So basically, now I got a new offer from another company, one of the top company. So I just want to transfer my H1B to the other company. So I just have a question, because in I-797A, the effective date is from October 1st, but I could not join on October 1st, but I joined on November 1st. So during this transfer process, will there be any issues? Because I should join on October 1st, but due to the reasons I could not join. So if I transfer to the new company, will they be asking any documents, or they'll be asking any kind of information about why there is gap between October 1st to October 31st? So I just want to know so will there be any issues in the future?
Sure.
Or anything like that?
I think it makes sense to me now, and I'll explain. I think what you're asking. I think you had a new cap filing, and the cap filing, the approval start date is from October 1st. I'm assuming you have a change of status approval. So when you have a change of status approval that starts from October 1st, what needs to happen is you're supposed to start on October 1st. And in your case, you started on November 1st. And when you apply for a transfer, one of the primary things that USCIS is looking for is, did you maintain status in the past H1B period? And the way they see that is they ask for your pay stubs. So when they ask for your pay stubs, and if they see that there is a major issue, sometimes what they do is they cause a problem, and they can still approve the case. And more than likely, that is what will happen in your case. They can still approve the case because you are eligible for transferring, and the case will get approved. The place where you might have an issue is getting the I-94. So USCIS can deny the I-94 and ask you to go for stamping. So USCIS will not deny the H1B for the reason that you mentioned, but USCIS could ask you to go for stamping if they find that for a certain amount of time you did not maintain status. In your case, it is less than 30 days, so you might get lucky. But again, the worst that could happen is USCIS will say, because you failed to maintain status, we will approve the case without an I-94. And that is what I see happen when there are major violations with maintaining status. And what that means is you go out of the country and then come back. Even last year, I had some cases where people did not join on time. And again, if it's a major issue, USCIS will say go out for stamping and come back. They will not issue the I-94. And sometimes if the violation is not big, in their discretion, they might let it go. So the summary is your transfer will not have a problem. They will approve the H1, but whether they will issue the I-94 where you don't have to leave the country, or they will not issue the I-94 but make you go out for stamping, that is where the issue could be. But again, from a transfer perspective, because you crossed October 1st, the transfer by itself will not be a problem. You are cap exempt. Okay, so Whether you have to go out for stamping or not is probably the only question that USIS might come back with because of the issue you mentioned.
Okay. So, what are the remedies should I follow to avoid that, or will there be any
I mean, what I would do is just document what happened for that 1 month. I mean, again, there is no remedy. You did not work, you did not work. But again, if there is any logical reason, I mean, try to basically just document that part. Since it's only 30 days, I mean, I don't think long term you'll have very severe repercussion. But again, document your reasons to minimize the damage, because the reason that you said is not a reason to deny your H1. So they will not deny your H1 for that reason. Okay. So, but again, because one of the things that the attorney for your transfer company, they will more than likely ask for your pay statements, and they will let you know what to do. At this point of time, I think you should probably, I mean, continue with your transfer. I don't think it's a fatal mistake.
Okay, sure, Chan. So, I mean, I'll be getting the pay stub for November month in 4 to 5 days. Like from November 1st to November 31st, like which I have worked, I'll be getting that pay stub in 2 to 3 days. So that would be fine, to submit to the USCIS. I mean, I have the previous 3 pay
Well, I think your attorney will tell you more. There's a little bit more than that. I mean, your case is a little bit more complex. From your side, I think what I will tell you is it is not. I mean, your transfer probably will not get denied, but your attorney is probably going to work with you. Okay, because the pay statement is missing, so you'll probably have some documentation to do with your other attorney, the company that's filing the transfer. But on a high level, I think you're still eligible to do a transfer. It is not that you're ineligible for this reason.
All right. So thank you so much, Dheeraj. And I think if you have any further questions, you can also contact Attorney Chand directly, have a one-on-one discussion. And his phone number is 817-523-8247. It's on the screen. You can also email Chand. You can tell him that you contacted him on Immigration and Jobs Talk Show, and let him know that you're the same Dheeraj. So his email address is law@spblawfirm.com, and you can also go visit www.spblawfirm.com to get to know more about Attorney Chand Parvathaneni. And thank you so much, Dheeraj, for calling in. And
Thank you so much. Yeah, thank you so much, Shan, and thank you so much.
Thank you, Dheeraj. Yeah.
Thank you.
Thank you, Dheeraj. So thank you, Chand, and for addressing that and taking, giving us what we needed, especially Dheeraj. So moving on now, Chand, we have Charwak's question. Oh, sorry. I was saying about Balakrishnan's another question. It's very interesting, actually. It's about AI. So for tech jobs like AI, will USCIS make it tougher in 2025? Sorry about that. 2025 to prove the role qualifies as a specialty occupation, and how can we handle RFEs if the job is in a rapidly changing field?
Right. And I think that is what, I mean, I think only time will tell. But again, in the past, we have seen where all of a sudden USCIS will change an occupation, and all of a sudden an occupation which was very specialized, all of a sudden becomes an occupation that is not that specialized. And to give an example, just recently in last 2-3 months, there is this occupation called computer systems engineers. There is an ONET code for it. And the entry level requirement was a bachelor's degree till 2-3 months back. And all of a sudden that got changed to something where it does not require a bachelor's degree on entry level. So things like that could happen. And because the IT profession is so dynamic, so within IT profession, there are some fields like web developers. Web developers, USCIS stand, the occupational outlook handbook stand is that it is not, I mean, at entry level, it does not require a bachelor's degree. So the yardstick for USCIS currently is they go and look at the occupational outlook handbook. They will look at that occupation and they will see what the OOH is talking about the occupation. For example, if you go to this occupational outlook handbook, you look for software developer, or you look for data scientist, or you look for a computer programmer right now. The entry level requires a bachelor's degree. So upfront, it says that it requires a bachelor's degree. So USCIS more than likely will not question about specialty occupation. But again, there are some occupations in IT industry which are pretty popular, but OOH on an entry level does not require a bachelor's degree. So those kind of challenges are possible. And since AI or the tech industry is so dynamic, what is a specialty occupation today might not be a specialty occupation down the line. So this is going to be a challenge. And normally, as a lawyer or as a legal professional, what we do is we look at the industry standards. We look at the same set of standards that USCIS sees. And normally, when I see a job that comes in an occupation that could be challenged, we let the employers know that this is an occupation that could be challenging. And sometimes maybe it's a very senior level role, not an entry level role. So even though at entry level it does not require a bachelor's degree, maybe at a higher level it requires higher wage level, it requires a bachelor's degree. So there are so many things that could go on. And there are rules on what USCIS should look for. So there are ways to prove an occupation is a specialty occupation. And I definitely think in 2025, we will at least see some challenges with some of these occupations. And to give an exact equivalent, in 2017, we had a challenge with computer programmers. Computer programmers, which we thought all along was a specialized field. Back in 2017, we had a challenge. And 2017 to 2020, we had so many challenges with computer programmer occupation. After 2020, computer programmers, again, I think was accepted. So when I say computer programmer, this is different from software developer. Software developer never had a challenge. Computer programmer had a challenge in those years. So hopefully all of us will keep up with what's going on in terms of rule changes next year. And we just have to look out. And employers have to be careful, because if it's an occupation that USCIS does not treat as specialized occupation, they have to think twice before filing a petition in that occupation.
Right, right. Thank you so much, Shant, for addressing that and for also giving us a few examples. And at this moment, I would like to address few questions from our Facebook group. So I'm sharing my screen. And we have this first one. This is from an anonymous member saying, I just want to share my experience on my AOS process as a B2 holder who married USC. Came here last year on a B2 visa, married my long time BF after 30 days since I got here. Filed all the forms after 90 days since we got married, and finally I got my approval. God is so good. Just waiting for my green card to arrive. Thank you to this. Okay. I did my DIY, no lawyer, compiled all the RFEs asked. Okay, I think there's not much here. Let me take this next question. This is from Joseph. Hello, I got laid off from Intel Corporation and I'm almost at the end of my H1B grace period. I have to transfer my H1B to a new employer by December 20th to legally stay in the US. Other visa options like B2, F1 are not applicable for my case. Please let me know if you know. Okay. My background is mechanical engineering and manufacturing engineering. There are ITCS consultancies out there to do my H1B transfers. Well, the question is, well, if you have anything, anything to say to Joseph Chand.
Yeah. So I think what he's trying to do is he's trying to find a IT, just a consulting company just to transfer his H1B. And he's talking about I can run my own payroll. Upfront, that is illegal. I mean, if they're trying to do something where he's running his own payroll, what that means is he's paying somebody to stay in status. That is more than, I mean, that is upfront illegal. And you cannot transfer to a company and start paying your own payroll taxes, because that is fraud. It's fraud and misrepresentation. There is no bona fide job offer. So you have to be cautious. And then uh, again, like if your background is in one field and an IT company is filing for an IT job, US is going to question on the nature of your qualifications. So overall, I mean, again, the rule is you have 60 days. Within 60 days, you have to find a bona fide job offer, not like any H1B transfer, because you get a H1B transfer filed and it is not a bona fide job, and USCIS tomorrow finds out about it, or at the consulate, the consular officer digs into your petition. Tomorrow, you could have a lifetime ban. For any misrepresentation or fraud, you can run into issues. So don't just go to any random companies because you want to stay in status, pay them money, or tell them to run your payroll. Running payroll, that is illegal. I mean, when you say I'm paying my taxes to run the payroll, that is illegal. If the company is filing a H1B, you're working for them, they're supposed to pay you. Benching is illegal. So a company cannot bench you and say you pay the payroll taxes, we'll run the payroll. So that is illegal. So just be cautious and stay away from any kind of things that could get you in trouble. And misrepresentation will get you in trouble with a permanent bar to US down the line.
All right. Thank you so much, Chant, for taking that up for Joseph. All right, moving on, we have another one. This is from an anonymous member. I need help. My case status for all family members, four of them, shows that an RFE has been issued on 4th November. Though I received only one kid RFE and never received other three RFEs. Called chatted agents, okay. They said they don't have digital copy of other three RFEs, so can't send on email. It's been almost 1 month, and no one in USCIS knows that what is RFE about. And they said office that has file has been notified. What should I do?
Yeah, I think when he's like trying to like call or chat with the agents, they're probably like I think they're just the front end staff, so they're not able to see what's going on. But what he should do is go to USCIS website, and under USCIS website there is an option to create service requests. So create a service request, and one of the things is lost or not received notices. So you'll see that option clearly. Click on that option, create a service ticket, because that is your evidence. Once you create the ticket, you should get an email back saying that they've received your ticket, and within a certain timeline, USCIS should respond back. Because when you create a ticket, it goes into the ticketing system, and somebody will research on what exactly is going on. So give the receipt number, create a ticket with that information, and then internally they will check and they'll have to investigate what's going on. And USCIS always will respond before 30 days most of the time. So instead of chatting with the agents, where tomorrow you might not even have any proper log or proof, go to the USCIS website and look for this option that says the creating a ticket, and create a service request. And there is a clear service request option for lost or not received notices. So make sure you create the ticket. That's also your proof. Down the line, if something happens, you have notified USCIS that you have not received the notice. And normally, if you create that kind of a ticket, they usually respond back, and they usually will resend the notice back to you.
Right. So thank you so much, Chant, for taking that up. And I think we can have the next one from Control. Um, Thank you so much, Chant, for taking that up. So we have this next one. If it's been almost 4 months since USCIS received my application, but they haven't sent my RFEs, does that, sorry, Control, can I have it back on the screen, please? All right, so let me just read it out from my screen. It's been almost 4 months since USCIS received my application, but they haven't sent any RFEs. Does that mean everything we sent is enough? Or could they still ask for more? PD 8/8/2024 biometrics are done. So far, my interview is waived. I know this can change. I'm just curious. Okay.
Yeah, since I think the post is talking about priority date and biometrics are done, my guess is this is for more than likely a green card filing, adjustment of status filing. And for an adjustment of status filing, 4 months is probably just, I mean, it's just recent application. And right now, it does not mean everything is enough, or it does not mean something is wrong. They're still processing the application, and hopefully in the next couple of months you will hear something about it. But 4 months is too early for these kind of applications, and in the next couple of months hopefully you'll find something. And again, if you get an RFE, you get 87 days in general. Respond back quickly. If you don't get an RFE, you get a direct approval. That is also very good. And I think, like you mentioned, that more than likely your interview got waived. That is a very, very big possibility, because nowadays not many people get interviews because of the interview waivers for AOS applications. So hopefully your interview is waived, and you get a very speedy approval. But again, 4 months I think is like too early. So next couple of months you should have an answer.
All right. Thank you so much, Chant, for taking that up. Now, moving on to my next one. This is um, okay. I think I have to do it from my screen. So let me just. So this one is, what are probable RFEs for EB1C on H1B?
Uh, so when we talk about EB1C, what it means is somebody has worked as a manager in a foreign office, and they're coming over to US office to work as a manager. So even if somebody's on H1B, they don't have to be on L1A. Even if somebody's on H1B, and if they are qualified, you can always do a EB1C I-140. So the most common things that we see on EB1C is whether the foreign office and the US office, are they properly connected? Because there is a specific way in which the companies have to be connected to qualify for EB1C. So the relationship between the foreign entity and the US entity. So this is one of the common RFEs that we see. And another common RFE that we normally see is the managerial duties. What kind of managerial duties did you have in the back in the foreign office? What kind of managerial duties do you have in the US office? So it's typically on the managerial aspects we see RFEs, or on the company to company relationship, how the companies are related. Are they affiliates? Are they subsidiaries? Is it like a parent company owning a child company? So these are typically the most common RFEs that we see. And if, most of the time, it's also with the duties, because it is a managerial intra-company managerial transfer. So they want to make sure somebody worked as a manager, somebody's going to work as a manager in the foreign, is coming to work in US office from a foreign office to work as a manager. So that's where most of the scrutiny is going to be.
Thank you so much, Chand, for taking that up. And let's go on to this next one. This is from an anonymous member. Help. I just got married end of last month. We want to get in line ASAP for AOS before Trump sits in. We trying our best to complete the I-130 and I-485 package, and my husband is cooperative, but we wanted to avoid RFEs too. Does it even matter at this point if we submit it this year versus next year?
Um, so what will happen is even if they apply this month or next month, I don't think the package will be opened, and the officer is going to be like reviewing that application immediately. And that's why there is a processing time. The I-130s and I-485s take a couple of months to be approved or even issued an RFE. So whether they apply today or tomorrow, say for example, come February or March, there are some rule changes. I mean, again, the new rule changes probably will not be retroactive, but the scrutiny will always be there. So again, if in the future, if you don't apply now, the rules could change, and it could complicate your process. To give an example, what happened during the last President Trump's administration was they changed the I-485 application. They added a lot more public charge questions. So doing that public charge, they even added a form. So it became a very complex process. And right now in the I-485, the public charge part is pretty simple. So if you ask me whether if you wait, things will change, they can definitely change the process. They can pretty much change the forms and ask for more information, and it could complicate the form. So from that perspective, yes, do it as quickly as possible. But even if you do it today, you're not going to get an approval in like a month. It's going to take a couple of months, and it all depends on what kind of rule changes we'll get in the future, what kind of additional things they might ask in the future, and so on. But I definitely would file it as soon as you can, because at least now we know that the forms are not changing anytime soon. And if the forms change, you have to redo all the forms, and the forms are complex. So again, whether you get an approval in a month or not, it doesn't matter. I think go ahead and finish it off. So that way it's one thing out of the way.
All right. Thank you so much, Chand, for addressing that. And if you have a couple more minutes, I think we can go on. Yes, so we'll take this one from Mona
Sure, sure.
Lisha. Hi, I recently received a request for evidence from USCIS requesting details about my employer and the e-verify number. I'm feeling a bit unsure about how to structure my response and would appreciate any advice or guidance. If you have experience with responding RFEs, navigating USCIS process, I would be grateful if you could share and help me with any tips, insights, or examples of successful responses.
This RFE is I mean, I've seen this RFE a lot of times for STEM OPT extensions. So when somebody who's on OPT is trying to apply for a STEM OPT, that E-Verify number is pretty important. And if sometimes some employer accidentally puts a number wrong and USCIS is not able to see a result for that, they issue these kind of RFEs. So the easiest thing is like just show that RFE to your employer, check with them on the e-verify number, make sure they're able to re-verify, give you the documentation, and attach the documentation as a part of your RFE response and respond back. So I mean, it's probably a simple RFE where they got some digits wrong. Confirm with the employer, send them the right e-verify number, and more than likely should not have an issue.
Okay, great. Thank you for taking that up for Mona Lisa. Now, this last one, this is from, yeah, let's have it on screen control. Trivikram. Hi all, I am on H1B and working as a contractor. My spouse is on H4 EAD and she is working for another client as FTE. My current client has offered me the FTE role. If I switch to a new employer, will it impact my spouse's visa status? Please let me know.
So anytime somebody is on H1 and then doing a transfer, the transfer from one employer to another employer, if the spouse is on H4 and H4 EAD, you don't have to really again apply for H4 and H4 EAD. If the H4 and H4 EAD is still valid, uh, when the principal H1B spouse transfers his employment, the H4 EAD automatically transfers over. So the H4 EAD is still valid till the end date on the H4 EAD. So you can just, if you get a better offer, you can move your employment to this new employer. Your spouse who's having a current H4 and H4 EAD, they are still valid to use that H4 EAD till whatever time that H4 EAD permits them. Only thing is look at the H4 EAD closely, H4 closely. Make sure you file for an extension before they expire. You don't have to file for a transfer right away. They are good to go. So the H4 EAD spouse should not have any problem at all.
Awesome. Thank you so much, Chand. That was great. You patiently took up so many of our questions, addressed so many of our viewers' questions, and it was so exciting to have Dheeraj on call, our first caller. So thank you so much, Dheeraj, for joining us. And please contact Attorney Chand Parvathaneni for further consultation and to get to know more on your case. Thank you so much, Chand. And maybe, we can cover this topic again in the coming week if you want to, Chand. But for now, I
Definitely.
think we'll have
Yeah.
to wrap up. And whatever you have to say as an end note to all our viewers who are watching us right now, it would be great to know.
Sure. And I mean, I think the big thing is, I think, again, compliance, we talk about compliance a lot of times. Everybody has to comply with the regulations, the government regulations. So, I mean, again, a lot of people, I think there's a lot of scaremongering going around all around. And President Trump, we have seen President Trump in 2016 to 2020. He definitely appreciates the value of H1B program. He's not going to abolish that program. He is more about refining the program because I think in some ways, they're correct. There is fraud in H1B program. We always see issues. We see this RFEs talk about fraud, misrepresentation. So the administration is more concerned about the fraud, misrepresentation, those kind of issues. They want to refine the program. And what that means is they keep changing rules. And sometimes the rule changes because they come all of a sudden. People are taken aback. And in short term, it causes a lot of issues. But I think nobody's trying to abolish this program or nobody's trying to completely cut this program because H1B program adds a lot of value to US economy. It adds a lot of value to the tech industry. US tech industry will not survive without the H1B program. There's a lot of value addition that happens because these employees who are highly educated, highly specialized, bring a lot to the technological innovations that are happening in US. So H1B program will always be a valued program. I think they might try to cut the fraud that is happening in the program. They want to strengthen this program. And I think the administration, the rule changes that you see will all be towards refining the program. What that means to all the employees is work for a reliable company. Don't work for any random company which you think is probably not a reliable company. As long as you're working for a reliable company, even if it's a small company, even if it's a consulting company, even if it's a full-time startup or a big company, it doesn't matter. It has to be a legitimate company. As long as it's a legitimate company that is doing business and it's been in business, you know that they have other employees, you are good. But again, if a company is a fraudulent company, you will know the way they talk to you, the way they're paying you. So don't work with any company that is not following the regulations. If a company is following the regulations, it doesn't matter. Small company, big company, doesn't matter. You'll be okay. So the bottom line is try to work within the framework of the regulations, work for a legitimate employer, and more than likely you should not have any issue.
Absolutely. Thank you so much, Chand, for joining us today. It was really great having you in this discussion. Very, very insightful discussion, and so much we got to learn from you today. And I'm excited to have you back. I hope you can join us again in the coming week.
Sure, Nipasa. See you again next week.
See you, Chand. Have a great day ahead. Thank you once again.
You, you too.
So, folks out there, thank you so much for joining us, and really great to have you all. If you want to contact Attorney Chand Parvathaneni and have a one-on-one consultation regarding your case, you can call him up on this number, 817-523-8247. And you can also email Chand. His email address is law@spblawfirm.com. And you can also go visit his website, www.spblawfirm.com. And thank you, each one of you, for joining us. You can also contact me, by the way. My phone number is 408-335-6444. And you can also email me. My email address is nipa@staffingly.com. And another very exciting thing is that we have daily immigration dose from Monday to Friday at 4 p.m. Eastern Time. So in, say, about 15 minutes or so, we are going to join in again. So stay tuned to Immigration and Jobs Talk Show. Thank you, each one of you, for joining us once again. And yeah, bye-bye for now.
Sense to use a wage survey company, have them survey the wage, and use that wage as the appropriate wage. And sometimes when USCIS sees that the basis for that wage survey is not very good, we do see these RFEs. So the most common RFEs that we see are typically either the wage level is inappropriate, or sometimes somebody is utilizing an own it code, the occupational code, that has a lower salary. Suppose somebody is working as a software developer, and the duties are all software developer job duties, but somebody goes and claims that he's a software programmer, computer programmer, own it code. USCIS, they will dig into the job duties, and sometimes we see RFEs where they say you used the own it code that is not appropriate. The own it code that you used has a lower salary. That is not appropriate. So that is also very important. And to avoid these kind of RFEs, what needs to happen is make sure you're using the right occupation, you're using the right wage level, and using the right wage source. So if you don't ensure that the right own it code is used, the right wage level is used, and the right uh, appropriate job duties are used, more than likely you're going to be hit with this kind of an RFE. And wage level RFEs are typically pretty complex. The way to avoid it is be very thorough in the initial time of your filing. Ensure that USCIS does not even question your occupational code or the wage level.
There you go, friends. Thank you so much, Chand, for taking that up and for the detailed explanation. I'm sure folks have questions as well, so keep commenting, I would say. And uh, yes, moving on, Chand, let's go on to our next one. So, what kind of documentation will USCIS require, if in an RFE to confirm the location of the H1B work site, if the beneficiary is working remotely or in multiple locations?
Sure. I mean, the good thing that we have been seeing in the last couple of years is USCIS has been pretty liberal if people want to work remotely from their home. And USCIS has also been liberal if people want to work at multiple locations. And the reason for that is ever since COVID, a lot of companies want people to work in their home. They also want them to come and work at their location as a hybrid model. So, full remote, 100% remote, where they're working from home, or hybrid model where you go to your location, your work location, like maybe once a week, twice a week from your home. So these kind of this kind of work pretty common in the recent few years. The good thing is USCIS has been pretty liberal. they don't have a problem if people want to work remotely or work from multiple locations. However, from a USCIS perspective, they are very particular about the prevailing wage requirement. They're also very particular about employer-employee relationship. And in terms of when we see the RFEs, we do see RFEs where they talk about the worksite address. The address that you have as your worksite address, USCIS will definitely want to see what that address is. We have seen a number of RFAs where they come back and say sometimes this address looks like a residential address. This address looks like it is a virtual office. And they do come back with those kind of RFAs. And what we need to prove is we need to prove that employee has the right resources to work at that location. If somebody is working remotely, that is okay. We do need to show that the worker, the H1B worker, does have enough resources to work from that location. And what that means is when somebody is working from a remote location, remote home location, things like showing that somebody has a lease, somebody has proper internet, proper workspace. Sometimes you have to show photographs of workspace, even if it is remote. So we use these kind of documents to prove that there is enough workspace at the location, even if it is remote. And sometimes USCIS, they ask for clarification of the work site. Maybe when USCIS Googled that location, it showed up as a virtual office. Maybe they felt that this might not even be a right location. So they come back and hit us with an RFE and say, our public search indicated that this could be a virtual office where multiple offices are located. Give us some more clarity. So these kind of RFEs are common. So what we do is whenever those kind of questions get asked, we try to show through a lease that you do have dedicated space. And a big part of the H1B is the employee needs to have dedicated workspace at the location they're supposed to work. So this is pretty important. And another big thing is detailed job duties at each work site. So if you have multiple locations and if the employee is working at multiple work sites, we do need to provide the detailed breakdown at the job of the job duties. For example, if somebody is going to the client location to gather requirements, to do a bunch of meetings and do the software development work from their home, for example. So we have to break it down and give a clear clarity on how do you break up multiple work sites? Because a lot of people do work from multiple work sites. Sometimes they have to go to the client location. Sometimes they have to go to their employer location, sometimes from their home. So you might have 3, 4 locations sometimes. And a part of the H1B filing is to give that clarity. And if you don't give that clarity, sometimes we're hit with that RFE where they say, what are the percentage of job duties that you do at each location. So to avoid these kind of RFEs, explain how do you have supervision, how do you have control at these multiple work sites, how the employees are supervised, who retains the control, who gives the instrumentalities for their work, and so on. Explain it more clearly, because USAS wants to know that employees are only being assigned specialized job duties. They're not being assigned non-specialized job duties. So as long as as this clarity is given, clarity based on the work site, clarity based on the location, the job duties, etc., it should typically not be a problem. And the client letters for third-party work sites. Lately, we are not seeing any RFEs for client letters when somebody is working at a third-party work site. In the future, we don't know. But at least as of today, we don't really see letters asking for verification from clients about the work arrangements. Lately, it has not been happening. And in general, like for the work arrangement for remote work, because remote work is so famous nowadays, I've seen cases where USCIS could also ask about the company policies or procedures regarding remote work. Sometimes it's also a site visit where they ask about the company policies or procedures for remote work. So always it is a good idea for the companies to document how the worker will be integrated into the company's operations while the employee is still working from a distance. It's also a good idea for all the employees to document how they're working remotely, things such as whose laptop are you using, and when do you connect, what kind of tools do you use to connect, do you use some kind of a VPN, some kind of a company tool to connect to your office, and so on. Keep all this documented. The reason is sometimes you get an RFE and you might need to show all these evidences. Sometimes there's a site visit, you might need to show all these evidences. And the last important thing is the prevailing wages when you have multiple locations. So the big thing is USCIS requires every worksite to have its own prevailing wage uh, uh, properly done on the LCA. So the LCA should list all the work locations, all the multiple sites. The LCA has to list all the offered salaries, because uh, uh, the salary might be different if somebody has two locations. If somebody has their client location, say in Austin, and their home location in Dallas. So what the LCA is supposed to do is the LCA is supposed to have both the work locations. The LCA is also supposed to prevailing wages for both the locations, and then be processed. So USCIS will ensure that the LCA does allow the employees to work from multiple work sites. So the proper prevailing wage on the LCA, the proper work location on the LCA, this is highly important. And as long as this is done, there is evidence of ongoing work. There is evidence of employers' ability to supervise remote workers, where either through a company policy, companies org chart, various policies, communication tools that they give the employees, and so on. As long as there is ability to supervise the remote workers, in general, it should not be a problem. We do see RFAs time to time, but the good thing is lately USCIS has been very liberal about work from home kind of options. In the future, I don't think anything will change majorly because USCIS tends to agree to whatever are the industry standards. So unless something changes, decide where everybody is supposed to come back and work from their office, more than likely, I don't think we will see a lot of RFEs on remote work options in the future.
Okay, that's very interesting. Thank you, Chand, for taking that up. And by the way, do you know of any cases who have never received an RFE? Or is it like very common? Every case gets an RFE?
On the H1B side, lately, most of the cases get approved directly. It used to be so bad a couple of years back where pretty much every case which had a third party work arrangement. Third party work arrangement is like one of the most famous ways of filing for H1B. What that means is you have one company who's your employer, maybe an IT services company, IT consultancy, or some other company such as a vendor. Then you have an assignment where you're working for the end client. So a third party work arrangement is where you're working for an employer, but the employer is not where you're actually working. You're actually working for some other ultimate end client. So those kind of cases, every other case used to get an RFE a couple of years back. Those cases used to be so hard a couple of years back. But in the most recent 2 3 years, we are not seeing a lot of challenges with whether it's a full time offer where your end client and your employer both are the same, or whether you're working for a third party agent. Both are equally, I think, getting approved pretty easily, at least lately. And if you ask me what is happening right now on the H1B side, I would say most of the cases do get approved without an RFE. And the reason for that is the salaries are very high. The employees are qualified. They have master's degrees. They have bachelor's degrees, at least a bachelor's degree or an equivalent. So from a USCIS perspective, when you show all that evidence that the employee is qualified, you're paying such a high salary, and you do have an assignment. In general, the RFEs are low. That being said, every case is different. Sometimes USCIS is Googling about the company. Maybe they did not find the right information about the company, so they're issuing an RFE. Maybe they're looking at the employee. The employee has a lot of unemployment time during his OPT. So we are doing a change of status, for example, from OPT to H1. USCIS might issue an RFE. So depending on what exactly is going on, you still see a lot of RFEs. That being said, I would say majority of the cases do get approved without an RFE, at least lately. And hopefully that continues, because giving an RFE, and again, it's a lot of time wastage, both for USCIS, both for the company and everybody involved. So at least the clean cases, I think they will still continue to give direct approvals. So not every case gets an RFE. And again, if somebody gets an RFE, there is nothing to panic. So most of the RFEs get resolved. If you look at the H1B side, the approval rate is in high 90s. So even if you get an RFE, more than likely the case will get approved. That being said, it's nothing to panic if you get an RFE. Look closely at what is in the RFE and try to respond back on time. The deadline is very important. For H1B RFEs, you get 87 days to respond. As long as you send the response back, send all the documents back on time, you should not have an issue.
There you go. Remember, 87 days is your deadline, folks. So, yes, keep that in mind. And a delay may cause or will definitely cause a denial, right, Chand?
Again, if if you don't meet the deadline, if the RFE, the 87 days pass and you don't respond back to the RFE on time, more than likely the case will get denied. So USCIS will
Okay.
say you have abandoned your petition, and they will issue a denial for abandonment.
Okay. Okay. Thank you, Chand, for the detailed explanation. Now, moving on, for H1B applicants applying for a change of employer, what specific evidence is USCIS seeking, to validate the continuation of the same job duties?
Um, so when somebody is applying for change of employer, which is commonly called as a transfer. So if you're applying for a transfer, USCIS does not expect somebody to be in the same job as the current job. The reason is somebody might be working as a software developer, say in Microsoft, and they say they lose their job in Microsoft. They're supposed to go and find another job in 60 days. So in 60 days, somebody might not find a same kind of a job. Sometimes maybe they will find a job that pays same or higher. Sometimes they might have to take a demotion, go to a lower level job, because in the industry there is no guarantee that you'll always find the same job that you have been working on when you move to another employer. And what that means from a USCIS perspective is, as long as the transfer, the change of employers petition qualifies for H1B, even if the job duties are different. For example, somebody worked as a software developer. Now you might go and work as a software tester, a software quality assurance engineer, for example, in the new job. Maybe your salary is low. It is still okay as long as you still meet the requirements for specialty occupation, as long as the new employer is bona fide employer and they're willing to pay as per the LCA requirement, the case will get approved. So there is no requirement that it does have to be the same or similar to the previous H1B. So USCIS normally does not go back and check and see what kind of a role they have worked in the past. They don't do that. However, what they do is they can always go back and make sure in the previous petition the employee did work as required. And what that means is looking at the pay statements. So it is very common they go back sometimes and say, produce all the pay statements of your previous employer. We want to check and make sure you maintained your status. That's a possibility. Normally, what you do is you send 2 or 3 most recent pay stubs. But sometimes, if USCIS feels that something is not right, they might go back and say, in your previous job, we want to see all your pay stubs, produce all the pay stubs. It's a possibility. That being said, what kind of role somebody had in the previous job might not matter much. That being said, in the current job, always document very, very detailed job duties. And the job duties should demonstrate that the duties align with the specialty occupation. It should also be consistent with the worker's qualifications. And so if you say my employee is going to work as a software quality assurance engineer, we also have to prove that the employee who's going for a transfer, change of employer, is also qualified. What that means is, if they have, for example, like a civil engineering background, and you're applying for a software quality assurance job, there is no nexus on a high level when you look at civil engineering and software quality assurance. But maybe the person has a lot of experience, IT experience. So you have to show the connection between the worker's quality and your role. Maybe it is through education alone. Maybe it is through a combination of education and experience. So you have to show that nexus, and you have to show that this job is indeed a specialty occupation job. So that is very important, and you don't really have to do any kind of a comparative analysis between your old role and new role. It is not even required. All you do is give a very detailed explanation of your current role, the role with the new employer who you are filing for a change of employer. Give a very good, solid evidence about your educational background, about your experience background, about your prior experience. And that is what they look for. And make sure the prevailing wage is right, the wage level is right, the LCA is right. And if you do it, more than likely you should not have any problem with change of employer. So anybody who's filing for a transfer or change of employer, don't worry about the role being totally different. It is okay for the role to be different. There is no requirement that your wage level has to match in the new job. There is no requirement that the job duties have to match. Everything can be different. As long as the new job qualifies for specialty occupation, you should be good.
That's great. That's great news. Thank you so much, Chant, for highlighting that and for giving us a detailed explanation. I'd quickly like to say hello to our viewers who have commented and they have questions. We are going to address them very soon. Nidhi, thank you so much for joining us. Raghav and also Santosh. Hi to all three of you. Thank you for your questions. Please stay with us. Now, to go on, Chand, I have another question, and that is if an H1B petitioner is receiving an RFE about the qualifications of the beneficiary, what additional proof can be provided beyond educational transcripts to ensure a favorable outcome? I mean, you already touched upon this a little bit, but if you could just add on a little more.
Yeah, sure. So nowadays, if you ask me what is the most common RFE, a few years back, like about 4 years back, every RFE was about third party work arrangements. It was about services in specialty occupation. And RFEs were like so different. Very commonly asking about right to control, employer employee relationship, and so on. Nowadays, in the recent times, most common H1B RFEs are about beneficiary qualifications. So if an H1B petitioner receives some kind of an RFE regarding the qualifications of the beneficiary, the H1B applicant. So what USCIS is saying is USCIS is saying prove that your beneficiary actually meets the specialty occupation requirement and actually has that necessary qualifications. So what we are trying to show is it is not just your educational transcripts, but show how your employee qualifies. And whenever we see that RFE talking about beneficiary qualifications, the first thing that we do is evaluation. So we have to evaluate the degree. And most of the time, if somebody has a foreign degree, somebody has a degree that is relevant to the job. Say, for example, somebody is applying for a software developer position, and somebody has a degree from India, a computer science degree from India. We know that it's the right major, it's the right degree because it's a computer science degree. So if you see an RFE for somebody that qualifies, but they just have a foreign degree, it's a very simple RFE. All you have to do is go to a reliable credentials evaluations agency. Simply ask the credentials evaluations agency to determine the US equivalency of the foreign degree. And these evaluation companies, they will evaluate the equivalency and they'll give a equivalency from a US standard. So for example, if somebody has a computer science degree from, say, Usmania University in Hyderabad, for example, you can get an evaluation done where that degree is equivalent to a US degree, a Bachelor of Science degree in computer science. So, so these evaluation companies know how to do it. So you have to go to a reliable credentials evaluations agency and get a simple education evaluation done. And that's it. You submit this evaluation copy to USCIS, it takes care of the RFE. And this is a very simple RFE if you have the right degree. When I say the right degree, your degree actually is in the relevant field of your occupation. But again, there are a lot of cases where you get this RFE for beneficiary qualifications, they don't have the right degree. So for example, somebody has a mechanical engineering degree, they have a civil engineering degree, or they have sometimes even like an electrical engineering degree. And the job is, for example, a software developer. So from occupational outlook handbook standards, the common degrees are either computer science or information technology. So anytime your degree does not match the degree that is relevant from an industry standard, what you're supposed to do is you're not only supposed to do an education evaluation, but you're also supposed to gather all your experience letters. So every experience that you have that is relevant to your job, you're supposed to gather it and submit it for a professor evaluation. And again, getting a professor evaluation is not difficult. If you have the right experience letters, you have all the educational documents, you submit it to the professor, a professor in the United States. You submit it to them and ask them to evaluate your degree. So there are a lot of professors who will evaluate your combination of experience and education. And you can submit that expert opinion. And USCIS will accept that expert opinion if that expert states that you have an equivalent degree in the relevant field when they combine your experience. It is a very common thing. And if you do have the right experience, most of the time, this is not a problem at all. So what we say is whenever you get this RFE, always that verification letter from your employer is very, very important. The challenge that we have is sometimes people come back and say, hey, this company in India will not give me an experience letter with the job duties, because it's a very common problem where a lot of companies will not put the job duties. They will verify the experience. They will not verify the job duties. USCIS requires the job duties. They want to know what did you do in your prior experience. So without the job duties, the experience letter is not valid. So in that case, what we ask the beneficiaries to do is we ask for affidavits. So you can go to a coworker. Even if your employer will not give you an experience letter, go to your coworkers or your team leads or your managers. Ask them to give an affidavit in their individual capacity simply verifying what did you do at the company. So an affidavit is also good enough. So sometimes it is affidavits, sometimes it is company experience letters. But as long as you have something to prove your experience, your job duties, that is enough. You can use those to go back to the professor and get an evaluation done. And by doing so, you should be able to overcome these RFEs for beneficiary qualifications.
That's great news. Thank you so much, Chand, for taking that up. And I think we should address some of our viewer questions now. So let's start with
Mhm.
Karthik Reddy B. If a person did bachelor's into 3 years degree into hotel management into OU, and he did MBA in business analyst in there, is there any RFE that will occur when H1B filing?
So a 3-year degree is not enough because for H1B, you require a bachelor's equivalency from a US standard. So a 4-year degree or higher is what qualifies you for a H1B. However, the good thing is you have an MBA. And when you have an MBA, MBA will be equivalent to at least a 4-year degree or higher in US. So what you have to do is you have to get an equivalency done. You get an equivalency done from a US standpoint. And in your case, what I would also suggest is if you have work experience, also try to get a work experience evaluation done. Because a lot of times we see challenges with MBA because MBA is a business degree. And unless you have a concentration, like an MBA with concentration in like IT or marketing or sales, a general MBA sometimes is considered as a generic degree. And we have seen issues because of that reason. So one thing for sure is definitely get an evaluation done for your case. And if you're able to gather all your experience letters, get a work experience evaluation done. And doing so, you should be able to overcome as long as you have the right, either the courses taken in your MBA or the right experience that is relevant to your H1B filing. And if you do so, you should be fine.
Great. All the best, Karthik. And thank you so much, Chan, for taking that up. Now let's go to Nidhi's question on YouTube. I'm planning to file an H1B or an EB2 NIW petition next year. With all the talk about RFEs increasing, how should I prepare differently? Are there any specific things people tend to overlook? And as an employer filing an H1B for a highly skilled worker, what can I do upfront to avoid an RFE? Are there specific job descriptions or salary levels that draw more attention?
Sure. Again, I think the reason why people say that RFS could increase is because we have historical precedents. We had 2016 to 2020 time period where President Trump came into office and things changed. So back then, what happened was there were some USCIS memos. And after USCIS came out with some memos, what happened is they changed their adjudicating standards. So back in 2017, 2018, we had these memos talk about employer-employee relationships, especially services in specialty occupation back then. We also had these memos which talked about some professions not being specialty occupation, for example, like a computer programmer and so on. So those when those memos came out in 2017, 2018, what happened is the officers are supposed to follow the rules. And because there was an official memo, they changed their adjudication standards. And what that meant is an increased number of RFPs. We saw so many RFPs talking about and so many RFPs talking about employer-employee relationship because back then those memos required contracts, required client letters, required contracts from each and every party that was involved and so on. And that was a lot of burden and a lot of companies cannot give those documents. So that caused a lot of uptick in RFAs back then. And because of those historical reasons, people feel that if the adjudication standards change again because of some rule changes, we might see a lot of RFEs. So it's a possibility. And in terms of what do you do and how do you prepare differently, some cases are always going to be high triggers, and the reason for that is in the end, whether it is Biden's administration or whether it is President Trump's administration, I mean, the officers, what they're trying to do is they're trying to follow the rules. And the immigration rules, there is something called burden of proof. So, for example, for H1B classification. So, for H1B classification, we have to meet the burden of proof that is required for H1B. And what that means is we have to prove that this particular job is a specialty occupation job. And there are ways USCIS does it. They look at the Own It online. they look at occupational outlook handbook. So for example, if you look at something like a web developer occupation, for example, in occupational outlook handbook or own it, or then you compare it with software developer, you will see that some occupations will require bachelor's at entry level. And then, for example, like web developer, if you look at some occupations, for example, if you look at developer occupation on Own It Online, you will see that at entry level, you don't require a bachelor's degree. So some occupations inherently, because of the nature of that occupation, inherently because there are standards, government standards that say at entry level, you don't require a bachelor's degree, the scrutiny is very high. And there are some occupations where inherently it is accepted that they require a bachelor's degree. For example, a doctor or some professions, a dentist, some professions. You know that without a bachelor's degree, somebody cannot even enter that occupation. So USCIS will not even bother about issuing RFPs on specialty occupation for those RFPs. So lot does depend on your salary, does depend on the nature of that occupation and so on, because you do have to meet the burden of proof. And if you don't meet the burden of proof, they'll upfront issue an RFP. And when it comes to ways to reduce the chances of an RFP, what you're supposed to do is, for example, you're looking at NIW I-140. There are requirements in the USCIS website. It will clearly say out what are the requirements for NIW. And you do have to meet the burden of proof. So as long as you ensure that you do produce all the documents that they request, your chances are minimized. Same thing with H1B. So for H1B, you do have to show that you have an US equivalency of a right degree. So upfront, if you want to reduce your RFE, one thing we suggest is upfront go ahead and put the education evaluation if your employee has a non-US degree. So a lot of times our clients will come back and say, no, let's go with the degree because it costs money to get an evaluation done. And sometimes we just go ahead. Sometimes we don't get an RFE. Sometimes we get an RFE. So if you're talking about how to reduce the risk of an RFE, there are some things that proactively you can do. Maybe get an evaluation done upfront. Maybe look at your occupation. If it is like a weaker occupation, maybe don't even file your H1B, because sometimes USCIS could come and raise a major issue saying that it is not specialty occupation. So there are ways to reduce the risks of an RFE. And what you do is you look at the burden of proof for that particular classification, produce everything upfront as much as possible. And will that guarantee 100% no RFE? No. Sometimes even if you do everything right, you produce everything upfront, sometimes USCIS still comes up with something because maybe they're doing some background check. Maybe they're doing something on their back end and the officer had some question. So they issue an RFE because RFE is not bad. All it is saying is the officer has some additional questions for you. So yes, there are ways to minimize the risk, but you can never say that doing so is like 100% going to take my RFE chances away.
Thank you so much, Chand, for taking that up for Nidhi. And Nidhi, thank you for your questions. I hope you've got your answer. If you have more questions, please feel free to also join us on call. We are here, and this phone line is, available for you to join us. You can have a discussion with Chand, maybe a question. You can hear it from him directly. So why not call us up on this number, 425-436-6335, and the access code they will ask is, and that's when you dial in 988-888. Just say hello after that. We will be able to hear you. Now let's take up Raghav's question. He's on YouTube asking, as an employer filing an H1B for a highly skilled worker, what can I do upfront to avoid an RFE? Are there specific job descriptions or salary levels that draw more attention?
Yes, definitely. I think job description and the salary level, the wage level, definitely the officers, the first thing they do is they look at those things because that will determine a lot of things. So the first thing is to avoid an RFE on the H1B side. Always look at your occupation. Okay, look at your job duties and look at what the Own It Online says. So if your job description is fitting that Own It code, fitting that the standard job description, you are probably on a good side. If your company is using an Own It code, but that job description, it does not really match that Own It, you definitely could have an issue. So what we always say is always look at the Own It codes, look at Own It Online. And you have to be in sync. You cannot just randomly use any Own It code for any job description. The Own It code has to match the job description that you are going to be doing, and that job description also should be a part of that occupation as defined in occupational outlook handbook or own it. So it is a pretty easy thing to do. You can go online, you can google own it online, or you can google occupational outlook handbook, OOH, and you can type in your occupation and it will show you the job description. For example, if you say you're a computer systems analyst, just put in own it online computer systems analyst, or put in own it online database administrator. You will see the job description, and so that will tell you what is the industry standard, and then you look at what your company is saying is your job description. If they are in sync on a high level, if it is fitting that occupation, your chances are reduced. If not, USCIS could complain. That is one part. The second part is that own it code even a specialty occupation own it code or not? And again, that's another check that we do as a part of the filing. And own it online or even OOH, Occupation Outlook Handbook, they tell you what the job's entry level requirement. That particular occupation on a entry level does require a bachelor's degree, then yes, it is a specialty occupation. If not, probably have to go and see why exactly do you require a bachelor's degree. So there is more in-depth analysis to be done. More than likely, you might be hit with an RFE. So there are something called job zones, job zone 3, 4, etc. Job zone 4 or above typically are considered as specialty occupation jobs. Job zone 3 or lower are typically not specialty occupation jobs. So you can find this if you go to Own It Online. So if you go to Own It Online website, you will see it. And these are the websites that the officers also use. So that is one way. The next thing is wage levels. Wage levels will definitely draw attention. The reason is in 2017, when President Trump first took office, the first kind of RFEs that we saw things change were wage level RFEs. Lot of RFEs were issued about wage level 1, even like big companies. I'm talking about big companies like huge, the Fortune 10 companies. They saw RFEs talking about wage level. Why are you using wage level 1? Justify wage level 1. So if your wage level is low, definitely USCIS officer could talk about the wage level. Recently, I've seen RFEs where they even said wage level 2 is not appropriate, probably wage level 3. In some cases, I've seen cases where USCIS came back and said, no, it should be wage level 4. So definitely, if the wage levels are not appropriate to the job description, to the requirement of the job, RFEs will be hit. You will get an RFE. So one way to minimize these RFEs is make sure your job description, whatever you are, it is in sync with the industry standard, Own It and OOH. It is also a specialty occupation Own It code, and then your wage level is calculated appropriately. So your employer, as a part of the LCA filing, a part of what they're doing is they're looking at the LCA wage levels very closely and ensuring that the wage level is what is the right wage level. If not, you can get an RFE. And I definitely think that we might see some some new RFEs about wage levels in the future. The reason is we did see them in 2017-18 time period. They stopped in 2021, 22, 23. But more than likely, I do expect some RFEs on wage levels in the future. So every company that is filing for H1Bs, a very important thing that you are supposed to do is look at your wage levels. On the lower wage levels, especially wage level 1, you have a lot of burden to prove that it is indeed an entry level wage level, because what everybody wants is nobody wants the H1B program to drive the wages of US employees down. So if the wage levels are not properly checked by USCIS, this program could severely impact the US workers' salaries. So for that reason, like the salary levels, the wage levels are highly important, which is why we always work very closely with the employers. And even the employers, they're typically very careful about the wage levels. They make sure they're paying the right wage level. If you do a mistake in that wage level, you file a H1B, the H1B will be denied. Sometimes you can't even fix it in an RFE. So you have to be careful. Even before filing the H1B, your wage level has to be appropriate.
Thank you so much, Chand, for taking that up for Raghav. And we have Karthik Reddy back again with a follow up, so I think we should take that up. One of the beneficiaries received an RFE regarding experience letters. Consequently, they reached out to their former employers to obtain these letters, including details of their job responsibilities. However, the employers indicated that they were unable to provide this information. Additionally, the beneficiary lacks a point of contact for a co worker affidavit. So, what do we do?
Sure. This is one of the most, a common problem that I see. The beneficiary qualifications RFE, it's a very simple RFE. And a lot of times I have people, they come back and say, I did work for a long time. I have a lot of experience and I can show you my relieving letter. A relieving letter that says that so and so is my title and I worked for so long in this company. The problem is, the challenge is the company will not attest to the job duties, like Karthik has mentioned. And sometimes you might not even find a coworker because maybe back then you were in India, now you are in US, so you lost touch with your coworkers. So it is even hard to get a coworker affidavit. It's a very common and a genuine problem. Unfortunately, the way USCIS works is they need evidence. So our claim is not enough. Our resume is not enough. So I cannot just put it in my resume and provide a simple letter with no job duties, and we cannot use it. Uh, but again, the good thing is if you have a 4 year degree with at least 3 or more years of experience, that should be enough. So sometimes what we see is somebody has 10 years of experience, 4 or 5 years of experience, they're good because they're getting the experience letters. Maybe for like 1 2 years they're not able to get those experience letters. So what we do is with whatever experience letters we have, we send it for evaluation and we ask the professor to see if that is enough. And most of the time what we hear is if you at least have 3 years or more, you should be able to get an equivalency in computer science, information systems, and that is enough. So, but if you don't at least provide those letters for at least 3 years, you might have an issue. 3 or more. So, if you have a 4 year degree in civil engineering and then you have at least 3 years of work experience, you probably are okay, even if you're missing a couple of experience letters. But if you're completely missing all the experience letters, then it is a challenge because the burden of proof rests on the petitioner. So if you don't show that evidence, your case will not get approved. And the good thing is, even if the company does not give, the employer might give. So on your side, try to document whatever you can. In the worst case, at least the offer letters and relieving letters and so on. Worst case, but as much as possible, try to get an experience letter from your employer, or at least try to find some coworker that you worked with and have them attest to it. If not, if you have less than 3 years of experience, it could be a challenge. If you have more than 3 years of experience, then it is always okay to maybe leave that 1 year or 2 years of experience and move ahead without it.
All right. Thank you so much for taking that up for Karthik. And Karthik, I hope that you've gotten all your answers. And if you still have more questions, please feel free to join us on call. And the phone number is up there on the screen, 425-436-6335. And the access code is 988-888. And as of now, Chand, we have some more questions from our Facebook group. So I would ask Control to please display them and let's take them up. So this first one is saying, "Hi, I received requests for additional evidence on my H1B petition on the 27th of August this year, and documents were sent as response on the 10th of September. It has been 91 days since the RFE received. Still, the status is showing request for additional evidence as of now. Any idea on how much time it will take to update the status in the portal, and how will it get updated? Petition receipt date is 29th June 2024 for Texas Processing Center."
So, in general, looks like the RFE has already been responded in September. And what we see is anywhere between 1 to, I would say, 2 weeks. At least the status online should change and say the response has been received. So, if you see the status response has been received, then once the status changes, you're looking at about, say, 2 weeks to a couple of months. Some cases are fast, some cases take a couple of months. That is normal. In your case, however, what I understand is the status has not even changed and it still is saying that RFE has been issued. If it says RFE has been issued, contact USCIS to make sure they do have the RFE. But if the status has changed and says RFE has been, the response has been received, then more than likely you're probably okay. And so I think, but again, this is what you can do. Either way, because it has been a couple of months, try to ask your employer or the attorney on record to create a service ticket. You can do it very easily. You can go and create this ticket with USCIS, create a service ticket, let them know that you have sent the response on 10th September. And that way USCIS will at least get back to you and confirm that at least the case is in process.
Thank you so much, Chant, for taking that up. Let's go on to our next. And this is saying, hi, can anyone say what is the approval rate for 221G administrative processing?
Sure. So whenever somebody gets a 221G for H1B, what happens is more than likely Department of State is contacting the employer initially. Sometimes they contact a client if a client is involved. And the way these things work is if the employer is responding back properly with information about the definitive assignment. So they cannot say that their assignment is speculative. They have to provide proof that they have a definitive assignment for the employee. If the employers are answering back, replying back to Department of State, normally what we see is majority of the cases do get approved. The challenges that where I see is sometimes the employers don't respond to Department of State's verification requests. Almost all of the cases that go through 221G, most of the time, we see Department of State reach out to the employer directly, ask them a bunch of questions. If that is being answered on time, I would say majority of the cases will get approved. The challenges that we see are when the employer decides not to answer back quickly, or they take too long, or they are not able to answer with proof of a definitive assignment. That is when I see challenges. But most of the employers, whoever are responding back, it might take some time. Sometimes it could take a few weeks, sometimes a couple of months. But as long as the employer is proactively responding back, we do see 221G, and sometimes I see 221Gs take even close to up to a year. Up to a year, sometimes it does take, and it is not uncommon. But what I suggest is wait for 60 days. So once you get it 221G and 60 days have passed, they have not taken any action. That is when you start reaching out to the consulate. And sometimes it means that every week you're reaching out to the consulate if they've not taken a decision. But the main thing is give them at least 60 days. Once you cross 60 days, then start chasing them and see what is going on. Again, the employer is probably the best person to chase the consulate. And normally what employers do is they start initially, they also ask the attorneys to get involved. But again, if they are doing it, most of the cases do get approved.
All right. So, Chand, I'm very happy to tell you that we have a caller now. So, I think we should. Hi. May I know your name, please, and where are you joining us from?
Hi, Adil. This is Adil. I'm joining here from Houston, Texas.
All right. Please ask your question.
Sure. I'm on H1B with H1B stamped on passport, and my passport expiry date is 3rd of 2025. And now I have applied for a new passport, and also I have a new H1B transfer petition approved with I-94 ending on January 2027. My question here is, do I need to visit CBP office to correct my I-94, or does the new I-94 with the H1B transfer petition is good to say that I'm not here illegally?
Hello, Adil. Thank you for your question. So I think in your case, what happened is you have an I-94, current I-94 from CBP that has a very immediate expiration date. But the good thing is you also applied for a transfer. And there is something called a last action rule. And according to the last action rule, what happens is whatever is the most latest I-94, that counts. And in your case, you have a transfer petition filed before your I-94 expires. So tomorrow when your H1B gets approved, you will get a new I-94 on your H1B approval copy. So on the bottom left, you will see a new I-94. And that I-94, because it is the most latest I-94, that will count. So you don't really have to go back to CBP as long as you make sure that you get a new I-94 on your transfer. So as long as your transfer approval on the bottom has a new I-94, you are completely okay. And in your case, more than likely, that is what will happen. You will get an approval. And when you get that approval, just confirm with your employer that you're able to see the I-94 on the bottom. If so, you're good to stay back. You don't have to go back to CBP.
Thanks, Chan. I already have my transfer petition approved, and I could see my I-94 date. The latest I-94 date has updated until 2027.
Yeah. In that case, because that is the most latest I-94, that is the one that holds. and because of that reason, you're good to stay back in the country till 2027.
Okay. Thanks, Chand. Thanks a lot. Thanks a lot, the anchor, and thanks a lot, Chand.
Thank you.
Thank you so much, Adil. It's really good
Thank
to hear from you, and I'm glad that you got your answers. I just want to ask, did you also comment as budding learner on our channel?
Yes.
All right, all right. Thank you so much. Thank you so much for joining us.
Thank you.
Great. So Chand, I'm really happy about Adil joining in, and now let's go on to our next question from our Facebook group. So,
Hmm?
Control, if you could please display that. So I got issue 221G with yellow slip on September 20 this year, Toronto, Canada. Initially, no documents were asked, and in interview informed need more time to check the details. My project is for state client working for more than 5 years. Last updated date for changed for 7 times under 40 days. Ask the employment letter. Same is submitted date updated seventh time. Then it's been 20 days. Neither date is getting updated nor status is changing. It's really frustrating. Anyone have any clue what the processing time it takes? I moved country of nationality, waiting for the case status update. No update after document is submitted, and it's been a month and 2 days past.
I think what you can do is immediately have your employer mail out to the consulate. And simultaneously, what you can also do is maybe talk to your local congressman and ask them to get involved. Sometimes congressmen write letters to the consulate and ask them to see what's going on. And involving the congressman is probably also a good idea. So the first thing what I would suggest is have your employer reach out to the consulate right away, and simultaneously also start working with the local congressmen and seek their help. A lot of congressmen are very helpful. They at least reach out to the consulate and ask them what's going on. And that is one way of getting some help. If you have submitted everything and they're not taking a decision, definitely involve local congressmen. And that a lot of times at least gets you at least an answer on what's going on.
All right. Thank you so much, Chand, for taking that up. And I think for now, this is it for our Facebook questions. I think I have a couple more questions, Chand, before we leave our show today. So, reflecting
Sure.
on this year, 2024, how would you summarize, the key developments and challenges in the US immigration landscape? Just highlight a few, it would be great.
Sure. So the biggest major change that we saw in 2024 from an immigration standpoint, from a USCIS standpoint, is they increased the fees for everything. The fees went up drastically. And we're talking about huge increases for H1B, H1B amendments, premium processing. So premium processing right now is $2,800. And so they increased the fees a lot. This went into effect in April. After a long time, the fees was increased at USCIS. And unfortunately, the fees increase was drastic. The green card processing, that fees went up. We're talking about the government filing fee, the filing fee for I-140, the filing fee for 485, and the filing fee for EAD card. Everything went up. That was a very major change that did impact a lot of people. And another thing that a positive impact was the H1B lottery. So last year and the year before that, we had huge challenges with multiple registration fraud, where people were trying to get unfair advantage in the lottery process. So USCIS, I think they were late, but they realized that it was a major problem. This year, they solved it. So what they did this year is they said, it doesn't matter how many companies file for you, we will just go with the passport. So it was a very welcoming change. It was one of those changes that I think really was a very positive change, because now that whole multiple registration issue was resolved. So that was a very positive change. And what that also meant is the number of filings, the registrations, they came down. That being said, there is still a very huge demand for H1B registrations. We still saw about 400,000 registrations this year in the lottery. So what that meant is still there is a huge demand for new H1Bs. And but USCIS coming back and fixing that lottery process was a very positive thing. Another positive thing that happened in 2024 for a lot of H1B folks is Dropbox. So USCIS, so Department of State, the consulate, they have been continuing the Dropbox process. So everybody that had a visa in the past, either an F1 visa or a B1 or any kind of a visa, they're able to really utilize the Dropbox feature. Dropbox is definitely a lot more faster and a lot more convenient than going for an interview, visa interview, and all that extra hassle. So that has been a positive change. So overall, I think the main challenge we did see was the fee increase. The fee increase was substantial. Other than that, I think other things were probably on the positive side.
Thank you so much, Chand, for highlighting those positive changes we had this year. And I'm very happy to tell you that Karthik Reddy has actually joined us on call. So, Karthik, where are you joining us from?
Yeah, hi, Napasa. Hi, Chand. This is Karthik from Hyderabad.
Hi.
Please ask your question.
Yeah. So my question here, one of my beneficiary got in a 221G, we file, from H1B in the control process from India. And he received a 221G and we got a mail from visa officer and we responded them in a shortly manner within the 2 days, to the visa officer. My question is here, what are the answers we given or we responses to the visa officer? If visa officer, she or he, not satisfied with my answers, what will be happens? And then the next.
Yeah. So two things will happen. One, they're satisfied and they will say, okay, submit the passport and the visa is issued. The other thing that will happen is down the line, they will say that visa has been refused. And what they'll do is they will send a recommendation to USCIS to revoke the H1B. So after a few months, if they're not taking any action, at some point of time, they will definitely change the status and say that the petition has been sent back to USCIS with a recommendation for revocation. So that's what happens. The worst case is it goes back to USCIS with a recommendation for revocation. And then what happens is USCIS will issue a NOIR, notice of intent to revoke. They will talk about what the consulate has found as an issue. You will get a chance to respond back. So you will get another 33 days, respond back to that NOIR. And if you're able to satisfy USCIS, they give something called reaffirmation. And if you get that reaffirmation letter, what you do is you again send the employee back to the consulate with that reaffirmation letter. And normally when they see that reaffirmation letter, they typically don't cause a problem. They will issue the visa. So the worst case is it goes back to USCIS. USCIS issues you a notice, you answer, you get a reaffirmation, and then send him back for stamping with reaffirmation document.
Okay, got it. So here my question, if the notice of revoke was done for my employer, if the candidate wants to go with a transfer with the other employer before traveling to US, is that possible?
So right now, because the approval is not revoked, so right now the transfer is possible. If if USCIS issues you a notice of intent to revoke and then eventually revoke that approval, then they will not be eligible. So right now, because he just has a 221G hold, so if he thinks that he has a better offer from another employer, he can always transfer and he will be cap exempt at this point of time.
Okay. I mean, you are saying that before, unless or until revoke had happened, we can transfer. If the revoke happens, we can't.
Yeah.
That's it, right? The short answer.
I mean, theoretically, unless there is some fraud or misrepresentation in the current approval, he should not have any issue with the transfer. So just because he got a 221G does not mean anything, because I did see a lot of cases where somebody got a 221G and they were not patient enough to stay with that employer. They simply go to another employer and transfer. And we don't see any issues unless there is some kind of a fraud or misrepresentation happening on that first approval, where after you do a transfer, USCIS will come back and say that first petition had some misrepresentation issue, so you can't transfer. If not, he should not have a problem, because we did see a lot of cases where you have a 221G and they simply transfer to another employer.
Okay, yeah, got it. Thank you, Chand, and thank you, Napasa, for the
Thank you, Karthik.
Thank you so much, Karthik, for joining us. It was really great having you join us. And yes, have a great day ahead. So thank you so much, Chand, also, for taking that up for Karthik. And, to wrap up our session for today, last but not the least, looking ahead at the coming year, 2025, what significant changes or trends, can we anticipate in the US immigration policies and, especially with the transition to the new administration under President Trump, though we've been talking about this over and over. Maybe you could just summarize a little bit.
Yeah. Yeah. So I think the main thing is I think people don't have to be very worried because the H1B program will not go anywhere. I mean, President Trump, he's still in favor of H1Bs, as we saw from a lot of his talks. He does want specialized people to come to US. The only thing is compliance. So I think everybody, make sure you're getting paid. H1B employees, the companies need to make sure they're paying their employees because you might have site visits, this audits and checks, but as long as you're paying the employees on time, extensions, I don't think you'll have a lot of challenges. The only thing I think you have to make sure is you apply for the right occupations, because if you're trying to apply for an occupation just because the salary is low, or you're applying for a low level wage, those kind of cases I might see a problem. But in general, if somebody is highly qualified, they have a decent salary, I don't think those cases will have a problem. The challenges that we saw even in 2016 to 2020 were a lot with the wage level ones, low level wages, and those occupations that probably were not specialty occupation. Those I think were like the first targets. So I think the lessons learned is always make sure you're doing your prevailing wages right, you're paying the employees the right wage, and employees are not on the bench. So if those are done, I think things will be smooth. So I think because we have lessons from the past denials, people are going to be careful about wage levels, because people now understand that wage levels are super important. The right occupation is super important. So as long as that is done, I think people will be good. Just make sure everybody's in compliance with their LCAs. Every H1B will have an LCA. As long as jobs are in compliance with the LCA, I don't think we will see a lot of surprises. Things might get a little bit more stricter. There might be more site visits, but anybody that is actually working, getting paid, I don't anticipate a lot of issues for those folks.
Thank you so much, Sean, for doing this. And we spoke about this topic. We H1B RFEs for 2 episodes, and it was such a great discussion, so enlightening. Thank you so much. And folks out there, I'm sure you also want to consult with Attorney Chant Parvathaneni. So why not call him up? You can call him in his number, 817-523-8247. And you can even email him. And that is his email address is law@spblawfirm.com, and go visit www.spblawfirm.com to get to know more about Attorney Chand Parvathaneni all the way from Dallas, Texas, and also his law firm. Thank you, Chand. It was really great having you. I'm here wishing you a very happy end of the year and happy holidays ahead.
Thank you, Nipasa, and thank you everyone for joining us.
Thank you so much. Thank you, folks, for joining us, especially callers Karthik, and we also had. Sorry, Adil. Yes, almost forgot. But thank you so much for joining us on call, and also all you folks out there who participated in this conversation by commenting your questions. If you have resonated, please do not forget to like, share, and also subscribe to our channel. And we are Immigration and Jobs Talk Show on YouTube, LinkedIn, Facebook, and also on X. Connect with us, subscribe to us, hit that bell icon so that whenever we have discussions like these, you are also notified. And another best thing is that we are coming up in a short while, with a daily immigration dose here itself on Immigration and Jobs Talk Show, where you can join us on conversation with me and my co-host Sam. So yes, stay tuned on Immigration and Jobs Talk Show. This is Nipasa saying bye for now.
Hello and welcome to today's episode of Immigration and Jobs Talk Show. I'm your host, Sam, and I'm back again with a very exciting episode that is lined up for you today. So, before diving into today's topic and announcing the name of our very special guest, here's a very important disclaimer. That is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So, use of information is at your own risk. So, folks, once again, welcome back to Immigration and Jobs Talk Show. I'm your host, Sam. And today we are diving into a very critical and timely discussion. That is, how will the Trump's administration impact EB2 and IW, EB1A, and asylum applications? So, as we all know, folks, that immigration policies have been a very significant, we have seen a very significant changes in recent years, and also understanding how these changes affect highly skilled workers, individuals of extraordinary ability, and those seeking asylum is more important than ever. So, to explain and clear all your doubts and to guide you on the right path, we have an expert with us today. Please join me in welcoming attorney Amin Yacoub, an expert in immigration law with an impressive track record, with a strong background in litigation. And before his current role at Bogan Months and Months, Mr. Yacoub ran his own solo practice, helping clients navigate complex immigration and litigation challenges. As an EB2 exceptional ability and NIW immigrant himself, Amin understands firsthand the complexities of the immigration process. His personal experience drives his passion for delivering top notch legal representation to his clients, ensuring not only quality but also efficiency. With a nearly 99% approval rate in securing EB2 and IW and EB1 visas for his clients, Mr. Yacoub is a true leader in the field. So, Amin, first of all, welcome to Immigration and Jobs Talk Show, and it's an honor to have a show with you. How are you doing?
Good, and thank you for the kind introduction. It's a pleasure to be here.
Absolutely, and it's an honor, to have a show with you, and we are really grateful that you are here with us. So, thank you so much for joining us. And also, I would like to ask that before diving into today's topic and going to talk about today's episode, I would like to know that were you expecting Trump to be back in White House?
Yes, I did actually. I would say I did expect him to be back when Musk, especially, joined forces with Trump, because Musk hasn't failed yet in any of his endeavors. So it meant a lot when he joined forces. And he was like giving $1 million a day to people and stuff like that. So it's just I felt like he's going to come back to office to correct the economy as well. So people are feeling it here in the U.S. and feel like they need to have a better economy, and that is usually the number one drive for the presidential election in the U.S.
All right. So, I would also like to ask that how do you think that under Trump's era, how do you see the future of US? Do you think it will be a new era or a nightmare for US?
Yeah, I think we've seen Trump before, so it's not like we're just exploring a new candidate here. So we've seen him from 2017 up to 2021, and it was, 2016 up to 2020, and it was not a bad year at all. Was the economy went up and everything was, in terms of immigration, nothing actually changed during his era. I would say Americans were, at least according to polls, were feeling satisfied with the economy. Were feeling satisfied with the low mortgage rates, interest rates, and everyone had kind of a chance in applying for jobs and having employment in Trump's era. But of course, people blame the COVID-19 2020 on what happened during Biden's administration. But my point is, it's just the last period that we actually witnessed Trump doing work as a president of the U.S. He was not as bad as the media might actually show. And it's all like a political fight in the U.S. Media is trying to show a picture of Trump he's like anti-immigration and anti people who are willing to actually help the U.S. be a better country. And that's not true. And that's why I'm interested in talking about immigration under Trump, because it's a completely unpopular opinion if compared to whatever is going on the media or whatever is going on the newspapers. So that's how you. So the other party here is the Democratic Party. Everyone tries to influence the public somehow so that they vote for them, so that they actually get them to the seats of power. So we just have to be neutral and watch closely and wisely in order to see what is true and what's not true.
Absolutely. And also, I mean, as you mentioned, that media has portrayed Trump in a little different way. And we can see that, even when Trump was serving food to in McD, then also that, that social media post just spread like fire. And it was also giving a different opinion that he's serving because he wants vote, or there was some kind of other opinion, that people were portraying in a different, actually in a little negative way. And
Yeah,
on the other side, if we look upon the Democrats, then I would say that for Democrats, the media was a bit lenient. They were more supportive, right?
yeah,
So
yeah.
I think that's why. But also, I would like to know from your side that can you be a little specific about that why Trump won in this election? Instead of, as media plays a huge role, and what media was portraying, that what people believe, but out of that also, people supported Trump and made him choose him the leader. So can you please go ahead and share the reasons behind it?
Yeah, so you're asking about my personal reasons why Trump is coming back, not the objective reasons here, or
That's
not.
okay, you can give your reason.
Yeah. So again, Trump is a businessman. He has more knowledge about the economy and how it works, and we have seen. So that's kind of objective and subjective at the same time. We've seen Trump before doing his job as a president from 2017 up to 2021. And we have seen the vice president, Kamala Harris, doing her job as a vice president from 2021 up until now. So when we compare both, candidates, we basically see two people who are not new people to us. They have been in power. They have been doing things. So we can just observe and see, was the economy better under the first or the second one? Was every aspect. So what was immigration better and faster for under the first presidential candidate or under the second vice president who's currently still in office? And by doing that, just a simple analysis to me, it seems kind of obvious that we can see that actually Trump, even asylum, nobody would actually wonder that. It's like asylum was much faster under Trump, and I'm talking about affirmative asylum. So that's an immigration issue, and of course, this is one of the biggest uh, portions of the policy of Trump. So he's not anti-immigration; he's anti-illegal immigration. So he's what he wants to do is to vet people coming in so that he focuses all the efforts, all the efficiency of USCIS on legal immigrants and basically move things faster. In 2017 up to 2021, what we usually had happened was they actually accepted people in asylum in 5 6 months. They scheduled an interview in 5 6 months. Now an interview would be scheduled in 6 years. So we are seeing a completely different era in immigration under Biden's administration. And everyone is so panicking about Trump. Everyone is so panicking about Trump and immigration. Again, because of the media here. So that's why, I feel like it's important to actually show what is true and what's not. And my opinion, may convince you or not, but I'm relying on data here and I'm relying on statistics as well. Approval rates of EB2 and EB1A under Trump's administration and under Biden's administration. So hopefully that will be useful, and hopefully that will actually make immigrants relax a little bit when they think about applying for EB2NAW or EB1A under Trump, not under Biden, because everyone is so panicking right now. And I want to say, do not panic. This is not going to be worse. I think it's going to be much better actually for you.
Wow, that's great. I think this is really insightful, and this conversation, I'm loving it from my side. And also, I mean, before delving into the questions that we have prepared for today's topic, there's one more question that's intriguing in my mind. That do you think, as Trump says, that there will be a mass deportation from the very first day that he'll be joining the office in 2025? So, do you think that that will happen because there are millions of people and practically that's not possible? So,
Yeah.
what do you call on that?
So is it possible? Yes, it is possible. Is it practically possible? Possible? I don't think so. He tried to do the same thing in the first year he actually took office in 2017, and he couldn't. And when he's saying mass deportation, again, we have to be very specific about what kind of population he's actually trying to deport. So anyone who has legal papers is not subject to this mass deportation. But anyone who has entered the country without any legal papers, without a visa, and they entered through the borders and they came to the US unvetted, probably he will do his best to deport these people. Now, there is a status in between, which is people would actually come through the borders and try to obtain a legal status. So the question becomes, what happens to those in between people? So they would be in a safer condition than those who actually came to the US and remained without papers. And you would be surprised. We actually have many unvetted people coming through the borders. And I don't think that's wrong to actually, make a legal move regarding undocumented immigrants or people who have never respected a rule in the immigration law. I think that happens normally in all countries around the world. So no country actually allows anyone to come in. You have to have a visa. So it's not like something out of the ordinary here. But if you do have papers, no one is going to be able to touch you because you have to be before a court, which we call procedural due process, before an administration, whether Trump or anyone else, actually has any decision over you or deporting you. So if he decided to deport someone with legal papers, let's say a CO8 pending asylum status, then he would actually advise USCIS to refer them or defer them to court. And once they're referred to the immigration court, then they would have what we call a day at the court. So they can represent themselves, they can have an attorney. And if they won the case, they're going to be remaining here in the US legally. If they lost the case, then they will be deported back to their home countries. So that's important to clear some, again, complexities regarding the mass deportation and the media, hyperbole statements that's like, just people are leaving, people are going to be, Trump is going to basically take people, arrest them, and remove them from the US, all immigrants. So generalization is not accurate here. And it's important to distinguish between all these strata of people and immigrants in the US.
All right, that's great. So thank you so much, Amin, for explaining that and taking that question up. Now I would like to shift our topic, shift our eyes on this topic, that how will the Trump administration impact EB2 NIW, EB1A, and asylum applications? So, I mean, my first question to you is that how might the Trump administration focus on merit-based immigration affect the adjudication process for EB2 NIW and EB1A applications?
Yeah, so that's one of the most important questions that we actually get on a daily basis right now. So how would he impact those kind of policies? So first we have to distinguish between what he can do and what he cannot do. So, as a president, he is having very specific authorities that he actually allowed to do. So, for example, we have the matter of Bansal right now, which is the landmark decision behind the EB2 national interest waiver. Is he allowed or is he authorized under law to basically reverse a court decision? That's a no here. So the answer is no. Is he allowed to change immigration law, the ENA Act of 1990, which actually put forward the national interest waiver, the EB2, and most employment-based immigration visas? The answer is no, because Congress has the authority to actually put it, reverse it or change it, amend it with a majority of votes, which is very, very difficult to do because we have, again, even if we have right now a Republican Congress, we still have people who are believing in the immigration under Republicans and under Democrats. So people would be rejecting any kind of change or radical change, I would say, to the ENA Act itself, which has been existing since 1990. So, what kind of impact would Trump be able to do to immigration? Would be direct impact. So, even though he has control over the borders, he can actually advise Homeland Security to not allow people in. He doesn't have much control over USAS except as directive opinion. So he would be giving a directive statement to USAS saying, well, please try your best to do better when it comes to evaluating the national interest waiver or whatever. And my idea, again, would be that he would actually broaden the scope, not as people think, that he would actually make it exclusive to scholars or scientists. And I believe so because he even suggested to give a green card to everyone who's graduating college from the US. So what we're seeing right now is Trump is probably pro legal immigration for the talented, for the people who are actually making a difference to the US. And people who are making a difference would be called, the EB2 NIW applicants and EB1A extraordinary ability applicants. So probably I would actually expect some broadness, and that is going to be broadening this kind of categories. And I'm not the only one who thinks so. I'm not the only immigration attorney who thinks so. So people who are versed in the field actually agree with me. I believe he is going to be giving directives to USCIS to accept more applications under EB2 NIW and EB1A if really the person is going to be making a difference. And that question remains a question to be answered in the case itself, in the petition and the exhibits. So whether a person is going to be making a difference or not is basically proved in a case, which is usually like 200 up to 400, 600 pages of documentation. So it's a completely objective way of evaluating what Trump is about to do here regarding the EB2 NIW and EB1A applications. And I think they're going to be much better than right now, even though we do have a direction from Biden's administration when he took office to try to grant as many EB2 NIWs to people who are working on AI, for example. But from the statistics posted by USCIS, what we're seeing is a drop in the acceptance rate down to 65%. So that direction didn't help much, which shows the nature of the direction. It's not binding. It's just suggestive to the president.
Much, Amin, for your answer. And also, I would like to ask, and being a little specific about what specific changes to evidentiary requirements for EB2 and IW petitions can we expect under a Trump's administration based on past policies?
Yeah, so that takes us back to the matter of Dinosaur. So the matter of Dinosaur as a landmark case actually places all the evidentiary requirements that are required for EB2NIW, and basically, if we complied with the case law, which is matter of Danasar, and the ENA Act, we complete the case correctly. So there is no say of a president here. It's all legal work. It's all decided by a court. We cannot bypass a court. President cannot bypass a court. The court itself may revisit the decision if it wants, but at the moment, it has been existing since 2016. The matter of Damasar. Before then, we had a case called New York State Department of Transportation. So we have multiple case law that basically a body of case law precedents that actually put forward the evidentiary requirements for EB2NIW petitions. We never rely on what the president says or what the president did not say. We rely on case law, we rely on the law itself, for regulations, and we have to comply, us and USCIS officers. If a USCIS officer might be subjective somehow, he or she might actually make a decision that is not relying on the regulations. And in that situation, the correct action is usually an appeal. Or a motion to reopen, of course. So it's just a matter of complying with regulations. I do not believe.
Amin, can you hear us? I think due to some reason he might got disconnected, but there's no problem, friends. Still you can continue posting your questions, and we are definitely going to take them for an hour as Amin Yacoub is with us for an hour. So till the time Amin will come back, we will try to have him back again with this episode. But you don't go anywhere. We'll be coming back with another short break. So don't forget to join us here. We'll be right back.
Yeah, I don't know what happened, but I'm back now.
No worries, no worries. I mean, not to worry anything about it. So, yeah, I was saying, everyone, that we'll be back again with a very insightful discussion as we were going on. So, please go ahead and continue with your insightful information. We would love to
Yeah.
hear.
So where did it go off so that I can continue from where I stopped?
That's okay. You can give a brief about it.
Okay.
Yeah.
So I think the last question was, would Trump be able to actually influence the? Okay, now I see. So
Yeah.
what specific changes to evidentiary requirements for EB2NIW petitions? Again, I said briefly, based on past policies, he only can give directions, but for specifically EB2NIW applications and EB1A. For EB2NIW applications, we have to rely on the matter of Banasar, which is produced by a court. So only a court can revisit that landmark case. No one else can actually change it. A president cannot interfere with the court decision and produce another decision. So that's regarding the evidentiary requirements for EB2NIW, and also the regulations in place. They're actually an extract from the ENA Act, which was passed in 1990. Again, it's not expected from the president under the Constitution to have the authority, which he doesn't have, obviously, to actually change something in the ENA Act itself by direct will. So if that needs to change, the Congress has to change it. Now, what remains is the EB1A, which is not a part of the question, but I can cover it. EB1A is also placed by the ENA Act. So again, Congress will have to change the law for us to actually change the evidentiary requirements. Now, what the USCIS officers might actually have from Trump's side is, please broaden your interpretation of the law a little bit, or narrow it. And I believe what we're going to be seeing, according to what he said multiple times regarding legal immigration, and that he is pro-legal immigration, and also because now we would have Elon Musk, who's an immigrant himself in his administration, we will be seeing broadening of that interpretation of those evidentiary requirements that are put forward by the law itself, the ENA Act, and the matter of Danasar court decision.
Amin, I would like to ask from you that you are saying that we are going to see a broader aspect. We will be seeing more opportunities, for EB1 or for everyone. So I would like to know it from you that how can you explain it in a bit that how we can see a broader opportunities, because most of the time we are seeing that Trump is trying to implement this and trying to reduce or making the immigration process a little lengthy. Yeah.
Yeah. So now I will use some data, but I don't think I can share the screen here, but it's accessible. You can just type in Google USCIS statistics based on EB2 and AW. So you're going to find the graph going up in 2017, 2018, 2019 of the number of petitions, EB2 and AW petitions, and EB2 and AW approvals.
I'm so sorry to interrupt, but if you want to share your screen, you can also do that. Or you want us to share, then you can share the link in this private chat and we can share it from our side.
Yeah, okay, sure. Just give me
Yeah.
1 second.
Yeah, sure.
So here's the link.
Yeah,
this is just one statistics, but we have multiple statistics as well. Mm-hmm. We can go through this one and
yeah, I think control, if you could please show this data. Yeah, I think
yeah, can I control it? Can you scroll down a little bit? So yes, zoom in. So we have here 2017 as well was up. If we looked at here, it's going to be 2017, 2018, 2019 under Trump. And then 2020 was the COVID. And then 2021, Biden's administration. And then 2023, we're still in Biden's administration. Now we're going to see that the blue line, which is the receipt, EB2 and AW, or EB2 category in general, receipts, is still going up. But the green line, which reflects the approvals, is starting to go down under Biden's administration of 2023. In 2024, it went down even below. So what we're seeing here, except of course in 2020, which is an exception, is a rise in the petitions and a rise in approvals under Trump in 2018 and 2019, and in 2017 as well, based on another statistics. And if we can you go down a little bit? I want to show you something else. Yeah, next page, please. The one below this. The one below this. Yes, here. So here we're looking at the 01 petitions, for example, STEM and non-STEM related. So they kept going forward and upwards since Trump, again, had a hiccup in 2021, went bad a little bit, and then it went up again. So 01 is not as influenced as EB2 and AW and EB1A because they're non-immigrant visas. So we're not going to be seeing the same difference on E2s, O1s, and L1s as we're going to be seeing a difference on EB2 and AW and EB1A because they allow people to get green cards, basically. Can you go to the next page, please? Next page. Yes, here. So here we actually see approval rates. If you could zoom in a little bit, it's towards the right right end of the table. So 2018, that was under Trump, that was 97%. In 2019, that was 97%. That's for EB2 in general, but it's included. The NIW is included in there. You would actually see the petitions included in all of this. In 2020, we have a high percentage rate, but then it dropped down towards the end of the table to in 2023 down to 90%. Again, that's including the EB2 petitions that are sponsored by an employer, not only the national interest waiver. And that was published by USAS. It's not like something that I drafted for this live stream. So if we just took a look at the data, we're not going to be finding a source that would actually collaborate the statement that Trump's era was bad for EB2NIW and EB1A. Especially, maybe it was a little bit stricter when it comes to the H1Bs, which I agree with, but it's not the same for EB2NIW and EB1A. And I do not believe there is any reason to actually think that Trump's coming back would actually make things worse, because they haven't. So why would I be convinced that Trump would actually come and say, well, let's change it to 40%? So why didn't he do the same thing in the past administration if he wanted to do it? So it's kind of unconvincing to me. And based on what I said, again, the court has to change its decision. And I don't believe that's going to be happening anytime soon. Congress has to change the law. And I don't think that will be happening anytime soon either.
All right. I think that's great and that's very well explained. And thank you so much, Amin, for the data also, because that's pretty much very clear from our side also. And we can see the stats. So with this, we can have a clear picture about it. So again, thank you so much, Amin, for that. And meanwhile, I would also like to, greet our viewers, Ram, Jitendra, and Maishaw. I mean, these are lovely viewers who has joined us for today's episode. So I think welcome to everyone. And here we have a question from our viewer from LinkedIn. That is, at the moment, how long average time to process EB1A and EB2 NIW?
Yeah, so regular processing usually takes 8 months up to 12 months for both EB1A and EB2 NIW. If someone would like to have a premium process, they have to pay an additional $2,805 to USAS, and that would actually allow them to receive a decision in 15 days for EB1A and in 45 business days for EB2 national interest waiver. So a decision means an RFE, an approval, or a denial. So it does not mean that they're going to get an approval faster or like they're going to get so a decision can be very general. What usually happens is a premium process, especially for EB2 and IW, would actually, and EB1A as well, would actually influence USCIS officers to produce RFEs. And it has been the case since, I would say, last year, middle of last year. And that's because the applications went up. Again, we have to consider that everyone who came through the borders, illegal immigrants, they stood in the same line before USCIS, but from the asylum side, because we have two types of asylum: the affirmative asylum for people coming through the borders in a port of entry, like an airport, using their passports and a U.S. visa, and people coming through the borders without passing through any CBP officers, without having a visa, and basically, getting their way into the U.S. borders through Mexico or anywhere else. So all these people combined, which is unfair for affirmative asylum applicants, of course, they're all in the same line before USCIS. So people are asking me and asking multiple attorneys, what's happening? Why are applications being late? And what's happening in all of this? What's really happening is whoever came into the U.S. through the borders, they're standing in the same line as everyone else. So now I-140 applicants, they're paying a fee called an asylum program fee, which is an additional $300. So the USCIS started charging the additional $300 fee, so that they actually try to do whatever it takes to hire more officers to get the process going, because we have more than 4 million people who came into the U.S. through the borders undocumented. So what I'm saying here, or what I'm trying to get at, is if Trump really stopped whoever coming through the borders undocumented and only allowed legal immigration, things are expected to go faster in 2 years or 3 years, because we already have millions of people before USCIS. So it takes some time to actually finish the cases, that the extra cases that they have, the frivolous asylum cases, and so on. So right now, as I said, just to summarize briefly, it's just 8 months up to 12 months regular process, and 45 days premium process for EB2 national waiver, 15 days premium process for EB1A.
All right. So thank you so much, Amin, for answering this question, and thank you so much, my Chaw, also for participating in today's session. In case if you still have any follow-up question or would like to know about any other topic related to immigration, then please go ahead and dial on this number, and you can also give a call on this number and can also participate in today's session. And you can also comment us with any other different topic or any other follow up question that you would like to ask from today's attorney. All right, so now I would like to take Jitendra's question, and he's saying that I'm a physician applying for an EB2 NIW based on serving underserved communities. Could changes to the program's national interest definition under Trump affect how these cases are judged?
U.S. will always welcome physicians, especially if you're focused on underrepresented people or underdeserved communities. And there is always, of course, I have to note here, a shortage is not a reason for the EB2 and IW eligibility, because it's covered under the PERM process regulations. So if you are sponsored and you have a full-time job offer and you're basically before the Department of Labor doing the labor certification, what we call the PERM process, there is an exception for having a shortage in your field. So the argument, the same argument does not apply for a waiver. But what I'm saying is a waiver is actually not relying on the shortage, but it's relying on you serving those kind of communities. So that's different. But what I'm here, if you want to apply as a physician, your chances of approval would be really high, because USCIS really appreciates doctors and physicians, especially if you're really about to serve, or you have a proposal to serve the underdeserved communities or people who are being basically without doctors. But again, even though it sounds the same, we're not going to be arguing the shortage. We're going to be arguing that you're going to be serving those kind of communities, which is kind of different.
Absolutely. I think healthcare is the most important sector in any nation. And, that's like a backbone of any country.
Yeah.
So I think that's very well explained, from your end. And to Jitendra also, if you want to know any other topic or if you have a follow-up question, then please go ahead and feel free to comment us on this session. All right. So, I would also like to ask about, are there any specific fields or professions that may be favored or disadvantaged under a Trump administration concerning EB2 NIW and EB1A applications?
I wouldn't say fields or professions. I would actually say how the case is prepared. So if someone is trying to argue that basically they're going to be a management consultant, but they're not going to be contributing to any specific field. They're just going to be a management consultant. That's not good enough. The proposal has to be, the proposed endeavor, of course, has to be very, very specific. It has to highlight how it would actually bring the difference in the U.S. To what sector or sectors, and technically, how would that happen? How would it cause that kind of difference and impact on that sector? So anything that is not specific enough would probably be denied. It's not really about the field itself, it's about the specific proposed endeavor. And if you do have a specific proposed endeavor in even arts, that would be accepted, as opposed to having a very general proposed endeavor in being a physician or in being an engineer. So it's not about STEM versus non-STEM. It's not about being an engineer or a doctor or an artist or a theater production, company or whatever. It's about the specificity of the proposed endeavor and how can we convince a USAS officer that you have already had some success in the past, which we should have prove in the petition, of course, and all the documents, and that you're aligning your education and professional experience and past contributions to your proposed endeavor in the future, which will bring in that difference, which is going to make America a better country in the future, or even a sector in the U.S. a better sector in the future through business or scholarship.
Right. And we really hope that America becomes great again, as Trump says, and that's how America feels. So, all right. We also have another viewer, Knife here, and Knife is saying hi. Hi, Knife. And the question that Knife has is, do you think that Trump government can be doing all what he talking, and if not, what are the challenges?
I don't think Trump will be able to do so because we have laws here. The Constitution, you have to understand that the U.S. is a democracy, right? So its rule of law is dominant here. So Trump cannot be a one man who's doing everything. So we have the judiciary, and we have the Congress, and we have the president. So three branches of the government. They have checks and balances, of course. The Constitution says, or documents basically the relationships between all of them. So Trump does not have any authority to actually reverse a law that was enacted in 1990, which is the ENA Act that provides most of the immigration visas. Trump does not have the authority to reverse a court decision, which is a landmark case. It's a precedent. So a court can only revisit and reverse that decision. Trump cannot do so. He cannot basically interfere with the court judgment and say, well, I'm going to reverse it tomorrow because I feel like it. What Trump can do is give directions to USAS and CBP officers. Now, all these directions binding? The answer is not really. They're suggestive, and they are not binding. So USAS, and based on what I showed on the statistics, has been doing favorably, basically approving many petitions for EB2NIW and EB1A under past Trump's administration. So there's no reason to believe that in the next Trump's administration, he's going to be doing something different. What I think is he's going to be actually broadening the visas, EB2NIW and EB1A, to some extent, so that they accept more talented people. Because now he is having Musk in his administration as well, who is, I believe, is an EB1A or EB2 nationalist waiver himself. I would say probably he is either EB1A or EB2 NAWs, although some people argue that he's EB5. But why would he choose EB5 if there is a higher category? So, we should ask him this probably.
All right. So I would like to say, Kinfi, thank you so much, and my apologies for mispronouncing your name. But Kinfi, if you still have any questions that you would like to ask from our attorney, then feel free to post them, and we are definitely going to take them up. All right. So I mean, you are explaining fantastically about all the questions that we are taking up. Here's another thing that I would like to know from you, as you also mentioned about the border and about the security. So we all know that Tom Homan being appointed as border czar under Trump's administration. So how do you think that his approach will affect the border security, asylum policies, and immigration in the future?
So the question here is about asylum as opposed to EB2 and IW, or
I think, okay, let's take about asylum EB2 and IW because we are taking that as a topic. So, yeah, please go ahead and talk about it.
Yeah. So again, the affirmative asylum wouldn't face many challenges in the future, in my opinion, because these people enter the U.S. legally using a visa, and they are documented. We basically, USAS can easily, in connection with the FBI, can figure out if someone is or has been a criminal or not in their home country. So they vet people, and vetting is important to get people in. Affirmative asylum, in my opinion, would actually go faster. People would have interviews scheduled faster than 6 years, in 2-3 years from now, because we have to, again, the USAS has to decide millions of cases so that it actually creates that faster process in the future after people, undocumented people, came in through the borders. So that's number one regarding affirmative asylum. Affirmative asylum people who actually applied and got the CO8 legal status, which is a pending asylum interview, and they're waiting in the U.S. legally for the interview. They shouldn't be fearing anything, again, because they are documented. And the first sentence in the USCIS receipt that they have received actually says you may remain in the U.S. lawfully until you are scheduled an interview. So right now, they shouldn't be fearing any changes in anything. Also, you have to understand that from a legal standpoint, laws cannot be applied retroactively. It's unconstitutional. So even if Trump, let's say, which is, I would say it's an 0.01% chance. Let's say he said, well, now I believe that I want to get rid of affirmative asylees who are living in the U.S. legally with a CO8 pending asylum interview. That cannot apply to you because you are already here. You're already having the CO8 legal status. You already have the documentation. So that probably will stop people in the future from getting the same card as you, the CO8 employment-based, not employment-based, it's called the EAD, Employment Authorization Card. And that will prevent that for the future, not apply to the past or the present. So that's important to note because status quo will remain the same it is right now.
All right. So,
Yeah, I think there is an interesting question here, if I may reply to it. It's by Caveat.
is saying that for EB2 NIW applicants, there's a speculation that USCIS could enforce higher education or professional thresholds. So, do you think that applicants with advanced degrees but limited publications could be at risk?
Yeah. So I wanted to reply to that question because there is a misconception that is going around that you have to have publications and citations to have an approved EB2 NIW petition. And that's not true. So we have three kinds of applicants. We have the scholar applicant for EB2 NIW. We have the entrepreneur applicant for EB2 NIW. And the entrepreneur is not expected to have any publications or citations. And we have the professional path, which is a third unexplored path somehow, which is basically someone working somewhere in the US saying, through my employment in that institution, let's say nonprofit, I will be doing some novel technique, and that novel technique will bring in the difference on the US nationally and on the field itself, and therefore will have substantial merit and national importance to the US. So for the second and third paths for immigration under EB2 NIW, you wouldn't expect to have publications and citations. Only as a scholar, we would expect you to have publications and citations. So it's not going to affect you in any way right now or even in the past, since I would say the matter of Donosar, which actually reversed the New York State Department of Transportation. And the matter of Donosar said You can have a proposed endeavor that is important for the business, for entrepreneurship, for arts. So it broadened the criteria for EB2 and AW to actually cover multiple non-STEM fields and STEM fields that are not scientific or scholarly based. So that's regarding this question. Regarding the advanced degree question too, the ENA Act itself, which belongs to 1990, so it has been enacted for some time and never changed, is the one that actually states that you have to have a master's degree or a bachelor's plus 5 years of experience. No one can change the ENA Act except the Congress itself. Now, if the Congress decided to change it, that Congress needs the majority of votes, which is very, very, very difficult to get when it comes to immigration. So my answer is there is not going to be a change to the advanced degrees requirements for EB2 and AW, and there's not going to be a change or a possible change for the criteria itself for non-STEM, STEM professionals, entrepreneurs, and scholars. All paths would be the same probably for the next 4 years. It would be interesting to see if he would really broaden the EB2 category or not, show his directions to USCIS officers. But otherwise, I don't believe that there's going to be much change in this practice.
Wow, that's so insightful. And okay, so thank you, Kavya, for your participation and for your question too. So here's another question, I mean, that I would like to ask: that how might the reinstatement of policies like remain in Mexico affect the asylum seekers' chances of success in their application?
Yeah, that's a very interesting question. So if that person is Mexican, for example, and he or she has a visa and they can come into the U.S. Through a legal way, then probably they wouldn't face much challenges. Now, if that person wants to come illegally into the U.S., probably that statement will apply to them. Now, if that person is not Mexican, and let's say he or she is from Argentina and they traveled to Mexico and they wanted to come through the borders, Mexican US borders, then USCIS will actually try to stop them by, again, building a wall or whatever, and that will be through the CBP officers at the borders. So if Trump changed the policy again and tried to spend a lot on building that wall, that would be number one. Number two would actually be, and he tried to do that before. Actually, he tried to sign an agreement with Mexico, which we call in immigration a third safe country agreement. If you are an Argentinian living in Mexico, do asylum over there. Do not come to U.S. To do asylum, to seek asylum. And that's crazy because Mexico may not be safe for Argentinians or for even Mexicans. So he tried before to pass this kind of international agreement, and he failed. It's very difficult to do, and because Mexico is also in the NAFTA agreement, which changed to the USMCA agreement between Canada, US, and Mexico. It's very, very difficult to try to build a different agreement, especially for a safe third country, saying, well, anyone who is in Mexico on a Mexican land will have to apply for asylum in Mexico, and he or she would not be allowed entry into the U.S. So it's very, very unexpected. I hope that covers all types of people who might actually come from Mexico, whether Mexicans or non-Mexicans coming to the U.S. legally and versus, of course, illegally.
Absolutely, and I think that's very well explained. So, to our viewers, also, friends, if you are navigating, your immigration journey, or have any doubts, or need any type of guidance related to immigration, then please feel free to contact Attorney Amin at the number that is provided, that is 407-578-1334. So this is the contact number that you can call him and ask your doubt. And with this, you can also email him on yacoub@boganmonths.com. And you can also visit his website, that is www.boganmonths.com. So these were the contact details that I would like to share. And now moving ahead with my one more question, I mean that I would like to know about family-based immigration, right? So
Yeah.
now I want to know that how do you anticipate Trump's approach to family-based immigration will impact the individuals who are applying for visas or seeking asylum?
Um, Applying for visas or seeking asylum.
Mm-hmm.
So, if someone is marrying a U.S. spouse, they are allowed to adjust status based on their marriage if it's a bona fide marriage. So, if it's a good faith marriage, of course, and we could prove that, that you can actually skip all the asylum process, you can skip all the visa process, and completely go ahead and apply for the I-130 and the I-485, I-765, I-130 and one, and basically get all the cards you can get in the least period of time possible under USCIS. So family-based immigration is highly recommended if you do have an American spouse, or if for example you have a father or a mother who is a U.S. citizen. Now it differs from, again, it's just the categories are different. So you would have a first preference for the spouses, father and mother, and first preference is actually for the spouse. Second preference is for the mother and father. Third preference would go towards sons and daughters, and fourth would be the brothers and sisters. So the lower the preference, the more years you would have to wait. Otherwise, there is no interrelation between visas or seeking asylum and family-based immigration. We can see some cases where basically a person who is applying for asylum in the middle, having a CO8 card, for example, pending asylum, waiting for the interview, he may actually marry someone in the process. And just by marrying an American citizen, that will completely change matters into getting the green card through marriage, not through the asylum process. And later on, after they have the green card, they can basically send a letter to USCIS and ask USCIS to withdraw their asylum case and basically go ahead and do the green card through the marriage-based immigration, which is family-based. Otherwise, there is no foreseeable impact on these types of visas.
Absolutely. And I mean, I would like to know from your side that it's almost 1 hour that we have reached. But I have some more questions from my Facebook group. So if you have some time, is it okay for you to give 5 to 10 more minutes to our audience?
Yeah, sure. 10 minutes are okay.
All right, that's pleasure. Okay, so I mean, we can see here. I hope you can see my screen, right?
Yeah, I see it.
Yes.
So, would a
Yeah.
pending EB1A affect you in getting H1B visa? Waiting time can acquire H1B while there is a pending EB2 G1 holder. Thanks, Burden. Yeah. So that's an interesting question. So the H1B especially is a different breed of visa. So we call it a double or a dual intent visa. It's an immigrant and non-immigrant at the same time. And that basically means there is no contradiction whatsoever between the H1B and EB2NIW, because EB2 is an immigrant visa. So applying for a double intent visa like the H1B at the same time was applying for EB2 national interest waiver, which is an immigrant visa, that does not show any contradiction in any intent. So you can go ahead and apply for the H1B and also apply for the EB2NIW. But the trick here is to maintain your legal status through the H1B, because otherwise you may actually fall out of legal status since the dates are not current yet for the EB2NIW. Meaning that if you got an I-140 approved, you would have to wait some time before you can apply for a green card and a combo card. So that means between the approval and applying for a green card, you would need to maintain legal status through the H1B. So it would be highly recommended to actually go ahead and secure an H1B before you apply for the EB2A national interest waiver.
All right, that's wonderfully explained. And here's another question that is do we need to submit ETA 9089 and related for EB2 and IW self petition?
Yes, it's a part of the regulations. So even though it sounds and it reads like it shouldn't be submitted, because it's basically a labor certification application for the firm process, you must submit it. You have to complete specific sections in the 9089 form. Right now, they have produced a new one, so you would have to download the new version and use it. And once you comply with the regulations and fill it out and sign properly, you have to include it in the submission. Otherwise, you will probably get an RFE requesting you to do so.
All right. So, moving ahead, here's another question that before submitting or mailing the petition, do we need to create an online account on USCIS?
No, you don't need to create an online account on USCIS. I would say it would be helpful to do so, but you don't have to. You're not required to establish an online account on USCIS. Now, it's helpful because it allows you to track the case, to actually get notifications whenever something is going on. If they updated your case, for example, into decided or approved or issued an RFE, you will get notified if you do have a USCIS account. Now, if you're doing this through an attorney, your attorney would actually have access to your case and would actually get the notification from USCIS on your behalf. So you don't have to do it if you have an attorney. I would recommend doing it if you're doing this on your own and would like to stay updated regarding any changes that may happen to your case.
Absolutely. I think taking expert advice is mandatory in immigration process. So, friends, if you still, need any guidance or need any help, then here's the contact details of our attorney that is mentioned, and you can see the contact details like phone number, email ID, and also the website that is being provided on the screen. So, please go ahead and share your, any information or any doubts that you have, and I'm sure that attorney Amin Yacoub is definitely going to take them up and he's going to solve them. All right. So, I would like to ask a few more questions, if you allow. That is,
Yeah, go ahead.
yeah, that's great. And I don't know why. Yeah, that's great. My screen is visible now. So, which part of the ETA 9089 need to be filled for EB2 and IW? I have already filled in the Appendix A and final determination forms.
Yeah, that's all what you need to actually provide for the new version. So it's just final determination and the Appendix A. So basically, education, experience, certification, skills, which is Appendix A, and then the 2 pages where you have to sign basically as the beneficiary, and that's all. And the preparer, of course. So you would have to sign. If you prepared your own 9089, you would have to sign twice on the 2 page towards the end.
All right. So I think that's all from my end because I have covered a few questions that I wanted to ask from you. And yeah, I think, it's almost time for our very insightful session. And it's just 1 hour we passed and we didn't even realize. So from my side, it was a very, amazing, a wonderful experience and obviously an honor to have a show with you. And you were outstanding. You were clear. You made up a very great points that that was very insightful and that was very eye-opening too with the datas and with all the facts and stats that you brought up. That was great. So how was your experience in today's episode? How it was?
It was amazing. I really enjoyed my experience, and I actually really enjoyed the questions as well. They're very, very interesting questions from your side and from the audience side as well. It was really a pleasure being here, and thank you for the invitation.
Absolutely. And I think the questions, those were, interesting, but even the answers, those two were very much interesting. So I like that too. And there's another comment from Freelance Mastery also.
Yeah,
So,
let's do that as the last question and move
all
on.
right, that's
Yeah.
great. So it's that what if my case was submitted under Biden's administration and got adjudicated when Trump's administration? Which administration am I entitled to?
Yeah. So probably that question has to do with the importance of the proposed endeavor than which administration would actually adjudicate the case, because they're the same USCIS officers. People think that, again, Trump is going to remove all USCIS officers and replace them with other USCIS officers. So they're just the same officers deciding the same cases under the same legal framework, whether under Biden or Trump. But your question might have a hidden question, which is there is a difference in the importance of policies between Biden's administration and Trump's administration. For example, solar energy is very, very important for Democrats and for Biden's administration, but it may not be as important under Trump's administration. So, since you have filed your case under Biden's administration, your case should be aligned with Biden's administration's importance when it comes to policies regarding solar, etc. Again, these are not black and white, so you have to understand that Trump is not like he's not going to dismantle the solar energy when he arrives. Again, like the biggest producer of electric cars is by his side right now. So we actually that's why.
I think due to some reason, Amin, can you hear us?
Yeah, yeah. I'm just saying, last thing I wanted to say is um, there is not going to be a huge difference in policies and the importance of those policies, because right now Trump is more convinced of not solar, but basically clean energy and stuff like that. But he's not willing to sacrifice oil and gas either. So we're going to be seeing a new Trump administration basically focusing on all energies, probably nitrogen as well. He talked about nitrogen cars, but he said, well, they're risky. So now that Musk is on his side, probably we'll be seeing a different approach towards electric cars, towards solar energy, and towards policies that Trump was in the past kind of reluctant to accept as important. Otherwise, to answer your question directly, your application will be decided based on the policies that are considered important at the time your application was received. So when you have received your USCIS receipt under Biden's administration, that's the time limit, that's the time estimate where actually the officer has to look around and say, you have complied, you're actually contributing to an important policy under Biden, not Trump.
Wonderful, wonderful. So, yeah, I think, Eamon, we also took the last question of today's episode, and that too very well explained. So, again, to our viewers, also, guys, if you are navigating any immigration journey or having any doubts, then please go ahead and contact our attorney, and he's definitely going to help you out. And I mean, from my side, as I also said, that it was a wonderful experience to have a show with you. And you were also saying that you also enjoyed the questions that we prepared, the audience they were asking. So big thank you to attorney Amin Yacoub for making this session a brilliant one and bringing a very insightful and a very eye-opening stats and facts about today's topic. And I think, yeah, that's all, and to our lovely viewers also who participated in today's webinar, thank you so much to everyone. Keep on posting your question, friends, and we are definitely going to keep them on asking and try our level best to provide a best solution to you. So thank you so much, everyone, for this amazing session. Don't forget to like, share, and subscribe to Immigration and Jobs Talk Show. I'm Sam, signing off for now.
Thank you.
Thank you so
Have a good
much.
day. Bye-bye.
Hi everyone, welcome to Immigration and Jobs Talk Show. I'm your host Rivera, and before I move ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our attorneys and guests, including comments and replies from users, is not legal advice. Use of information is at your own risk. Welcome back, everyone, to Immigration and Jobs Talk Show. Like I said, I'm your host, Rajni Bharara, and today we are here to discuss the latest trends and insights in immigration law and employment opportunities. Well, I'm thrilled to have you all join us with us today, and I want to again extend a heartfelt welcome to all of our viewers today. Thank you for joining us. Your interest in these important topics is what makes this show very, very special. So thank you again. And today we have a very special guest joining us. Erin Green, an esteemed immigration attorney and an H1B visa expert. Erin brings over 20 years of corporate management experience, working with clients ranging from venture startups to large multinational corporations. He is the founder of EEG Immigration Law Group, where he provides exceptional legal services and strategic solutions for complex corporate immigration issues. Erin has a remarkable track record, having overseen thousands of immigration petitions for high tech, defense, and biotech companies. He has served as the exclusive U.S. immigration advisor to the American Israeli Chamber of Commerce and has extensive relationships with Department of State officials representing corporate clients at the U.S. Embassy in Tel Aviv. In addition to his legal practice, Erin is a passionate educator, frequently delivering presentations on immigration processes and compliance to large audience across the country. His commitment to transparent service and dedication to his clients truly sets him apart in this field. Today, we'll be diving into an important topic: H1B visas, current trends, fraud crackdowns, and what to expect next with none other than Erin Green. We'll explore the latest developments in H1B visa sponsorship, discuss the recent crackdowns on fraud within the system, and look ahead to what applicants can expect in the upcoming year 2025. So, without any further ado, let's welcome Erin Green to the show, everyone. Erin, welcome to Immigration and Jobs Talk Show. How are you doing?
Hey, good to be here. Doing good. Thank you.
Thank you so much. It's a pleasure having you on the show, Erin. Thank you for agreeing to be a part of the show. And guys, we have Erin's details displayed on screen in case you want to write it down. So you can write down his phone number, his email, and his website in case you want to get in touch with him. So make sure you do that. Now, Erin, without any further ado, I know we are here to talk about H1B, but before I do that, I actually want to talk to you about, the picks of Trump's administration. I mean, the picks that Trump has had in past few days of in the last 1 month for his administration. So, Erin, how do you anticipate these appointments are going to influence immigration policy, and particularly regarding H1B visa?
I think the new administration will be very strong on the border, on preventing the mass illegal waves of immigrants coming in. That's the focus. That's what he ran on. That's the people he's putting in place. Mr. Holman and all these others are going to be focused on that. what we have right now is a free open border on our Mexican side where anyone can just walk in. I'm completely against the asylum scam that is going on and the ways that the last or the current administration has ignored immigration law to levels that are just unexplainable. For those of you who don't know, asylum means you're in a country, but you have to get out, you have to flee, you're in fear of your life, the government's going to come and kill you or cause harm to you. And if you can get to the next closest country, you're supposed to file an asylum claim and be there until your case is heard. Unfortunately, while we do have a lot of poor people coming from these countries that just want to work, they do not qualify for asylum. And asylum was not created for someone who just happens to need a job or to be poor or maybe lower class. But what they've done the last 4 years, and even before that, they've allowed these folks to come in illegally using this asylum. It's a big scam, and the government's perpetrating it. So to get back to your point, I think most of the efforts will be on securing a border, like every country needs, allowing people to come in legally, allowing real asylum claims to be heard, and hopefully not allowing millions and millions of these phony asylum claims to be perpetuated. Mm-hmm. With regard to the H1B and the business community, I happen to think that Trump is a businessman. People working with him are looking to increase the economy. The economy has been down the last 4 years. We've had inflation. We've had a lot of problems. So on the business side, I expect things to get better, get smoother. Hopefully wait times will go down. And we'll see better processing and intakes of cases. And those are some of the things I'm looking forward to. There's a lot of fear mongering out there done by whether it's law firms or just particular political interests who always want to fear monger and hope for the worst. But we don't see any evidence of that. For what we see so far is a business-friendly administration like we saw last time.
Okay. But Erin, a lot of people are also saying that it's not only going to, Trump and his administration are not only going to go after the legal ones, the illegal ones, but also it's going to be bad for the legal ones and strict scrutiny. And, basically, it's not going to be good, not just for the illegal ones, but also for the legal ones too. So what do you have to say about this? Do you think it's going to be hard or bad for the legal immigrants too?
I don't think so. I don't think. We've seen 4 years of this administration. In my firm, we processed thousands of H1Bs. Certainly, where they're stricter on, for example, third-party client-side cases, and then it goes back. We've seen trends where there's more RFEs, and then less RFEs, and then more RFEs, and then RFEs targeted. We see them coming in trends. But the trends don't really correlate with the administration that's in power. It doesn't matter. It seems like they are more internal, and they just seem to adjudicate in different ways in trends. So if you're talking about H1B adjudications, it's hard to predict what the next trend will be. For example, I can tell you 20 years ago when we used to do L1s, L1As, and L1Bs, L1As would never get an RFE. They were so straightforward. For example, if you flash forward 12 to 15 years, you have them starting to RFE L1s as a trend, and L1As particularly. And so there's nothing correlating with the law or changes in law or changes in administration. It just seems to be internal trends that seem to come up and down, with what we see in our data. But I don't predict any stiff change where they're going to say, oh, we're not accepting H1Bs. They can't do that. I don't see how they would do that or why they would do that. That would just harm the business community.
Okay. But do you expect any changes in the H1B lottery process with the new administration?
So to give you a little bit about background about the H1B lottery, as you know, before they went to this electronic system the last couple of years, they had just the lotteries where you prepared the entire case, mm-hmm. and you sent it in with your filing fees, which were a lot. Mm-hmm. Then they would do the lottery, and then they'd send the ones back that didn't have the paper, that didn't get accepted in the lottery. Then they went to an electronic system, which they forego all that paper being produced and sent in and all that mail, which is smart. However, it kind of opened up the door a little bit for easier methods of fraud. But I don't know if you're going to ask me about fraud, but before we get to that, I don't see it. And are you asking about how the process has changed this year's particularly from the years prior?
No, yeah.
Well, okay. So let's talk about the fraud, for example. So when they announced that they were going to electronic, I said in my head, I said it right away. It just popped in my head. I said, this is going to be a catalyst, and we're going to see hundreds and hundreds of thousands of more applications. Not necessarily because the economy is better or they're needed, but because it's going to be easier to do fraud. Because think about it. When fraudsters come together and they put these ploys in just to get H1B approvals or lottery applications, the law is that you can't. So if you have a related company, you can't submit multiple applications for the same H1B applicant. But if the companies are not related, you can do that. When they went to an electronic, now, of course, there was fraud existing before. Companies could do that, and they were willing to submit these huge applications with all the fees. And I guess if they got more than one applicant accepted, they would lose a little bit on the fees, right? When you go to an electronic system and you don't have to send any fees in, you're just entering names and maybe their birth dates and passports, etc. Then you have less overhead. The fraud scams have less overhead in terms of having to put all those fees up front. So what happened is they got a little bit smart, and I predicted it. If to get around the law, if you think about it legally, if let's say 20 people came together and opened 20 different companies, okay? But none of those people were related or had any other ownership interest or relationship with any of the other 20 companies, right? So you have 20 different companies. However, now let's say they have 100 people and they want to get them H1Bs, right? So let's say each one of those 20 companies enters those 100 people into the system, and they could do that because technically they're not related, although it is technically a fraud scheme because let's say they're colluding to do that. That's where it can become so much easier to perpetuate fraud with the new electronic system. But now we see a lot of crackdowns going on, so they're getting a lot smarter. I think this year what they've done differently is they're starting to, they're asking for the passport number of the individuals now. So this year what they've done is they're looking at the individual. So if they're accepted, supposedly they're not accepting them again. If that makes sense, if that same individual has, and they announced that in their bulletin in January, and they've done that supposedly. So that's one way that they're cutting back on the fraud schemes. And then the other way is they're doing a lot more investigations into the filers when they see that. Right. For example, I have a company now, and we were doing an H1B, and then we got an RFE or a NOID, a notice of intent to deny, which is similar to an RFE. And it talked about the past filing from the CAP, which I've never seen one of those before. And it was talking about, so the person we were filing for our company, but they had been accepted in the CAP for another company. And they were looking into the companies and asking questions about the companies prior. So you can see that they're on to these companies now who are doing that, which is a good thing, which will make it more fair for everyone who needs H1Bs.
Okay. So hopefully it's going to be all good for the H1Bs at least, and also for the immigrants.
Yeah, I think so. The only changes for next year, I think, is they're going to probably implement instead of $10 to enter someone, I think it's going to be $200. And they wanted to do it this year, but at the last minute, they decided to keep the $10 fee in place. So it'll be a little bit more. I think it'll be $200 per person you want to register. Which is interesting. But other than that, I don't know if they're going to change much from this year's fiscal year cap to next year. We don't have the announcements yet, but they usually start announcing them around this time. And then in January, they start coming out with announcements and changes if they want to make any. But I can tell you 780,000 caps last year was not a result of the economy. It was, I mean, if you look at versus the previous years, it's several 100,000 more. It's that was because it was easier, and I predicted it. It was easier because you don't have to file all the, and they've gotten smarter in how they're doing it and set up these fake phony H1B we used to call them job shops when I worked at Infosys. And they're out there. They crack down on them, but they're out there.
Mm-hmm.
I can explain what that is if you want, or we can move on.
Yeah, please go ahead. We would like to know more about it. Yeah.
So when you're looking at an H1B, a job shop, so technical staffing companies like yourself can have legitimate jobs and legitimate clients. And the requirement is technically that you're supposed to have a bona fide offer of employment for the employee that you're submitting the H1B for. What the job shops do, and your H1B employees or applicants or people who want to get H1Bs have to be very wary of them, is they come along and they try and they say they can get you H1Bs. They don't really have jobs lined up that are ready to go, bona fide job offers. They just try, and some of the other things they do is they try to take money from the employees. So anybody out there who's looking to get an H1B, be very wary of these job shops. What they're doing is they're making a profit by trying to get H1B lottery numbers in high volume and then utilizing those by placing people in the U.S. after the fact. Mm-hmm. Whereas a legitimate staffing company or a legitimate IT consulting company will obviously have clients and have jobs ready and available and file based on those jobs. And even when they're entering the lottery, should have that those jobs in place. There's a little bit of a difference there you can see.
Okay. But hopefully now that Trump is going to be back with this strict administration, it's going to, if not completely go away, at least it's going to be slowed down, right?
I really don't know. In terms of enforcement and investigations and audits, I mean, even during the Trump administration, we saw times when there were more audits and more and less audits. For example, FDNS audits are random site visits, which they do on H1Bs and L1s, where they're supposed to come to the office or the place of work. A lot of the officers are lazy and they'll just email you. But so I can tell you the last 4 years, we hadn't seen a lot of them. I've seen very, very few. I just even got one recently. But so I can tell you just within the last 4 years, there was like virtually none. And then maybe now lately a little bit of ramping up, but it's very sporadic. So it's hard to say that just because this administration comes in, there's going to be more FDNS visits and we're going to do a lot of them or but in any case, a legitimate H1B should not be worried about an FDNS site visit. They're very straightforward. They want some documentation. We did tons of those when I worked at Infosys. And so it's not something that should alarm anyone. And even if you get an FDNS site visit, they're looking just to make sure that what's in the application matches what's on the ground. That's basically all they are.
Okay. Thank you for answering the question, Erin. Now, I would also like to know about, because in Trump's last administration, this Buy American, Hire American was his initiative, right? So how do you foresee this policy actually being reinforced or maybe altered in this new term, especially, concerning H1B visa holders?
Yeah. So the H1B argument on are H1Bs good for America and the economy versus are H1Bs taking American jobs has been going on for a long time now, at least the debate back and forth. Mm-hmm. I can probably argue both sides. But more likely for starters, let's look at it this way. We have the most IT jobs in the world here. I think that's a fact. Statistically, anyone will know that. We have universities and our Americans who go to study, and they don't really go into the computer engineering or these IT fields. A lot of the STEM fields, they're very weak on that. Mm-hmm. We have such a high demand, and those jobs are here and plentiful, and they need to be filled by foreign workers, for example, H1Bs, whether they're studying here or whether they're coming abroad to work. So the argument is that the American kids just simply don't go into this field. And I think there's a lot of statistics to back that up. I don't have them on me, but I've lectured about this and I've talked about this in different places. So there's a great need for IT workers specifically. And when you're talking about H1Bs, as you know, the vast majority of H1Bs are IT fields and certainly STEM fields. So you can make the argument that this is a much needed, our economy needs these workers to come in, these H1Bs to come in and do this work. Mm-hmm. The flip side is sometimes what happens is these companies, whether it's, Wipro or Tata or Infosys, mm-hmm. they come in and they do an efficient job. They have clients who have, at least in the past, have had their own legacy IT departments. And what happens sometimes is that these vendors will come in, these companies, and do a great job. They'll hire him and they'll completely replace the IT department. So let's say there were 200 Americans working there, or mostly Americans, and then you bring in someone like a Wipro or a Capgemini or an Infosys. They mm-hmm. come in and they just basically take over the whole function for the company. And this is where you can see a lot of American workers being laid off, and then it becomes a political issue, and then it gets into the press. And even though it might not be that many workers at the end of the day, it could be a whole IT department of a company, a major company. Sometimes they're replaced or rehauled, and then you can see the political drama that unfolds. Well, here you can see people are talking about losing their jobs or mm-hmm. Having to train the replacements in many of the situations, and I've seen that. I would tend to think that if there is a robust IT hiring here where there's just so many jobs, that if those folks are really talented, they will find jobs, number one. But I can see the argument where you have specific cases, and they're more emotional cases because they're more like one-on-ones, but you can get a lot of sense of when a whole IT department is replaced and the new folks coming in, they had to transfer knowledge. I can see that argument. So I can see both sides, but I really tend to think that if those folks were really talented folks or needed, that they could find jobs when those kinds of, changes happen.
Right. So now everything will boil down to the talent and the skill that the person possesses.
Yeah. Now, as far as Trump, he's business friendly. I mean, he's coming in to make the economy grow again, and we want to be the best in the world. I think he knows and he realizes, and I have seen interviews with him in the past, from the last time, where he's acknowledging that fact about the H1B. So when you read all these articles coming out about Trump's going to do and Trump's going to do, a lot of it is fear mongering. A lot of these people just don't like Trump because that's the fashionable thing to do on one side of our country, but you got to read it and look if there's any facts to it. And yes, definitely on the border with the illegals, I think that will be a boost. That will be a boost to business immigration because you need law and order. I mean, I have clients waiting years and years. I have all my clients, none of them want to overstay their I-94. None of them want to do anything, even remotely illegal or looking illegal or something that could get them in trouble. And these are the folks that need the services of the USCIS, which is, you're talking about wait times for EAD cards and people have to come off payroll. I mean, these are people too, and they've come here legally. They've paid thousands of dollars. Their companies have filed the right way. Right. And they've taken a back seat to allowing millions and millions of people to come in for what purpose. So that's my opinion on it.
But Erin, do you really believe that it has now become fashionable or cool to say that we are anti-government, especially anti-Trump? We don't believe in his policies or what he says, even though everything that he has said or done has always favored the country.
Well, when I'm talking about, if we're going to talk politics now,
let's just take immigration. I mean, because mostly that whatever policies or actions that he has taken so that so that illegal immigrants cannot get in, and so that the borders are the border policy is strict, so that illegals can't get into the country. But then people don't really favor that idea also and say that he has always been against immigrants. So what do you have to say about that?
Well, his whole platform is that he wants people to come in legally. He wants people to respect the laws of our country. And if you can utilize those laws to come in, then you should. He doesn't want and there should be borders, and there should be places where you enter, and there shouldn't be drug cartels running in people. Leave the crime and the drugs alone. There shouldn't be drug cartels organizing people to come in illegally and finding loopholes because there's no boundaries or no wall or this or that. Mm-hmm. I mean, no country in the world would ever put up with this. So when he's talking about that, he's not talking about, well, we shouldn't also allow legal immigrants because they're bad. He's never said that. And so the perception that will flow over into business immigration is just completely false. And there's 4 years of evidence of that. And when I try to argue with some of my immigration colleagues who are very, let's just say, anti-Trump or pro-open borders, as I call it, I say, well, why don't you point to something in 4 years, which he's done? And then they talk about, if you remember during COVID, when they kind of shut down visa processing and a lot of embassies. Well, that was shut down because of COVID. I mean, and that slowed the entire world for traveling. And I come back and I tell them, that's not a good example, because that was a few months, yes, and it was hard maybe to get an H1B visa, and maybe a few people got stuck abroad here and there. But that was really due to the disease, the COVID that was killing people. And yes, movement was stopped everywhere by every country. So if you want to argue this, I'll argue with any immigration lawyer who wants to come on here and tell me that these asylum cases are actually legitimate and can show me how. But they won't, because they don't have the facts on their side, and as usual. But anyway, not to get into the other side of immigration. We're here for business immigration, and I don't see the fear. People who are reading all these articles should just read them with a grain of salt. That's what I'm saying, because nobody knows what's going to happen, number one. And number two, if you look at the track record, those 4 years, L's and H's, which is mostly what your audience is interested in, not killed or hampered, or there may have been delays here and there, but that was due to COVID. So just be careful when the fear mongering starts, because the new administration's coming in and one side has simply lost the election. So just be careful. That's all I'm saying.
All right. Thank you so much for that insightful answer, Erin. And a lot of people have joined us and have also posted their questions. So we are definitely going to take their questions. Or maybe let's just start with Hosam's question. So Hosam said he has posted this on YouTube, and he says, I'm a medical laboratory scientist certified ASCP. How can I apply with you?
With me. So as you know, most, whether it's a green card or simply, petitions, O1s, and you need a sponsor company. So if this person is a scientist and he's working in the or I guess he's not in the US, I don't know. I always tell him, like, I don't find job. I guess that's your job, but we're a law firm. Our clients are companies, and we can certainly file, extraordinary ability or outstanding researcher green cards. There's an O1 category if he meets that. But like I say, most folks outside the US who really don't know much about how the process works, maybe they didn't go to school here, really, you need to find that company that wants to hire you. You have to look either in your home country, or here, find your field, apply to jobs online. And then at some point, when someone is interested in you and your services, the question will come up if they need sponsorship. That's where I come in. So I'm not going to find jobs for people. We're a law firm. I think you do that. If you're a staffing company, that's probably what you would do. But after they have a job and they're like, okay, now how do I get the person into the US? We want to hire them. Then they come talk to me and we strategize and we find what solution they can have, to work in the US legally. I think the person's probably outside the US, I guess.
Right. So Hosa, maybe you can write to me. My email is rajni@staffingly.com. And yes, maybe you can share your profile with us. If we have anything else, anything for you, we are definitely going to get in touch. But thank you so much for your question. If you have a follow-up or a question for Erin, make sure that you post it in the comments below. Meanwhile, let me quickly take Kavya's question, which she has posted on LinkedIn. So Kavya says, Erin, she says, can we expect more jobs for students with H1B sponsorship? Currently, companies are not ready to take students because they need H1B sponsorship. Is there an increase in H1B sponsorship of IT jobs for immigrants?
Okay, so it's hard. Okay, so look, when you're talking about, are there going to be more H1B opportunities? Are there going to be less H1B opportunities. That usually goes with the economy. I think now that we're going to have a business savvy administration coming in, we saw the last few years companies like Amazon and Meta, which was Facebook, we saw them lay off. I can tell you, Meta laid off like over 22,000 employees, or one of them in like a 2-year period. Large layoffs, and yes, a lot of them affected H1Bs. They were in STEM fields, they were in IT fields. I can tell you, we had some of my companies. They were calling me like, "Hey, we got a new person we're hiring. We got a new person," and they seem to all be coming from Meta. So, in terms of answering the overall question, it's hard to say, well, there's going to be more companies are going to want more H1Bs or less. Companies want talent, and they have roles and jobs they need to fill. They don't care if they're H1Bs or non-H1Bs. Now, I can tell you this: if companies are hiring H1Bs, it's because they really need the talent, and it's there. If you think about it, to hire someone who needs sponsorship is going to cost them, in terms of lawyers and fees and all the headaches and potential green cards and perm filings and all those fees. If you look at it from a comparison basis, it's going to cost them a lot more, obviously. So if they're willing to spend that, it tells you, and it goes back to the first question you asked me, if they're willing to spend that, they don't have someone equally talented or even right there who's going to cost them $20,000, $30,000, $40,000 less in the long run, which goes to show you that the vast need, and I think it's only going to grow. We can see a lot of movement. I don't know if anyone's out there is doing AI, but a lot of those companies are coming up. And then the traditional companies like, the big FANG like Google and all of them, they're still hiring. Their numbers will fluctuate. I think there's going to be more opportunity, but it's hard to say, it all depends on what you're doing and what field you're in. And then, the market is still good for students, for foreign students coming out and then, sending in resumes and being hired based on their talents. Yeah.
Right. So, Kavya, I hope you have got your answer. Thank you so much for your question. If you have a follow-up, please continue posting your follow-up. We are here with Erin for some time. We'll be taking your follow-ups too. So right now we have questions from Rag, then RK, Ankit Goel, Lokesh. So many questions are here. Guys, I'm definitely going to take your questions and ask it from Erin. But before I do that, Erin, I would also like to know from you that what factors do you believe have contributed to, the decline in H1B visa approvals in 2024?
The decline in approvals. Well, I can tell you, so are you looking at statistics where you have the top 10 visa filers and like Amazon went down a few thousand? Is that what you're talking about?
Yeah, Amazon and then Google and so many companies actually.
So if the question is USCIS getting any more stingy or harder to approve? That's not the situation. I will go back to individual company hiring and the economy. When the economy is slow and these companies aren't making what they do, they tend to lay off. So that's probably what happened there. I don't know internally at like Amazon. I don't think they would say, well, we're just going to lay off. Although there are companies who do take a policy I've seen lately where they might say we're not hiring those who need sponsorship. I mean, obviously you can't discriminate, but for business necessity, you can ask that question when you're recruiting people. Will you need sponsorship? So that might be a trend, but I think it's more the economy has been bad. And we're in the last year or two, we're seeing ramifications of some of these big companies just wanting to lay off and making cuts and maybe not hiring as much until they can get back, until the economy can start rolling like it did, prior to the last several years.
Okay, so it has nothing to do with USCIS's strict approach or nothing to do with the government or the law?
No, I file H1Bs every day. They're very straightforward. Yes, you'll get an RFE. Sometimes you'll get an RFE when it's not warranted, but there's not. I would say it's even easier to get an H1B approved now than it has been. If you think about third-party client sites, they've completely, in the past, I can remember getting massive RFEs on the third party. Oh, where are they working? They're not working at the company. And they've stopped doing that the last several years. So we don't see those RFEs anymore. If you got a U.S. degree, they're not going to question the specialized knowledge. Yeah, they'll throw. Those are usually boilerplate RFEs. And you get those and they're unfortunate and they create a little bit of a delay and more cost. But right now, I don't see a huge uptick in those. I can tell you I have seen months in the past where wow, there's so many H1Bs or a particular year where they're going, but it really doesn't correlate with changes of administration from what I've seen in my experience.
Okay. Okay. Thank you so much for answering the question, Erin. Let me again move to our viewers' questions because we are getting quite a lot of them. So let me take maybe RK's question. So RK says, just like the perm process, if you have major layoffs, you can't file new perm. That should be the case. If you do major layoffs, your site should not be eligible, get H1B for the fiscal year. H1B is a great program, should help add workers, not substitute. If a company has 10 American workers, then apply for 5 H1B at the end of the year. That should have 15 workers, not 10 or worst 8. I don't think so there's a question, but this is what he says.
I think he's trying to say that, I think he's trying to say that he doesn't want H1Bs to replace American workers. I mean, I have a lot of clients. I've worked with big companies, small companies. I don't think these recruiters, and I deal with them a lot, I don't think the recruiters are trying to say, let's get this person because we don't want the American number one. And then he'll make the argument, well, maybe the H1Bs will work for less, so they're cheaper in the recruitment. I mean, we know about that when we're recruiting. Maybe we can get them cheaper. It's hard to qualify that. I just think if they need more, they're going to hire more workers, and they're going to hire them where they can get them and as fast as they can get them to get them in there. If a company's growing and the IT needs are growing and the AI is growing and all that stuff, then they need them. They're going to find it's a market out there. These recruiters are cutthroat. I mean, and then if you're coming out of school and you have a skill, like lately I saw maybe 4 or 5 years ago when AI started to become popular and all those AI jobs. I mean, I remember some of these students would come out and my client would be like, we got to offer them this and the perm and the green card. We got to give them everything because these kids come out of school. They got 3-4 offers. I mean, they got companies after them for these skills. It's amazing. So, yeah, I would have to counsel my client and be like, I mean, I'm doing your immigration, but yeah, I can see the talent pool. These guys with these niche talents, guys and girls with niche talents, they're so sought after that you're going to have to offer them the perm quicker. Some of the companies would start their perm right away, right at, even, they're doing their EAD and they're on their OPT and they start it right away. So, yeah, I just think it's economics basically. Are there cases out there where companies won't think they can fire Americans and hire cheaper labor? Probably it exists, but I think the overall mass numbers are because these jobs are there and these companies need them and they'll get them from wherever they can.
Okay. Thank you so much again, Erin. Let me Rizwan is here. Rizwan says, hi. Hi, Rizwan. Please post your question if you have any. And then Dezaljin, I hope I'm taking your name right. I'm sorry if I'm not. He says, hello, everyone. Please post your question in the comments below. And now let me take Rak's question. So here, Rak said, will L1A for a tech non-profit RFE? What do you have to say?
You broke up there. Let me see if I can read that question. Will L1 tech nonprofit face extra scrutiny or even an RFE? L1A for a tech nonprofit. So there's really no difference whether you're filing for an L1A for a nonprofit or a profit. The issue with scrutiny will come whether the company can support the salary of the L1 worker. And is there a structure in place where the L1A will be overseeing professionals or supervisors? So the scrutiny is across the board for L1A. It doesn't matter whether you're a nonprofit or not. That's what they look at. And yes, L1As have been harder over the past 10 or 15 years. They used to be just a piece of cake. You didn't hardly have to file anything. Now, when we do an L1A application, we put in org charts and emails of the manager actually overseeing people, really the nuts and bolts evidence to try to avoid the RFE. When I used to do L1A petitions, there were like 2-3 pages. Now my support letter has gotten to 15 to 25 pages. And I'm trying to avoid the RFE for my client is what I'm trying to do. So I'm trying to get everything in there, as much evidence as I can. So you can just see the trends. And, L1B has been traditionally the hardest, application to be approved of all the work visas. And those you really have to put together a very strong L1B argument. It's evolved over the past 20 years from, like I say, maybe 2-3 pages and a little bit of explanation to 15, 20, 25 pages and exhibits like this. So there's been a big evolution in the L1 field, even though there's been really no changes to any L1 restrictions or laws or adjudications or obviously numbers, because there's no limit or lottery on L1s. So it's interesting.
Okay, so Rak, I hope you have got your answer. Thank you so much for your question. Please continue posting your follow-ups. Sita is also here. Sita says hi. Hi, Sita. I hope you're doing well. Please post your questions in the comments below so that we can take it and ask it from Erin. Meanwhile, let me take Ree's question. Reese has posted this on LinkedIn. Reese says, so if most companies are laying off, why do we need to import labor? Does the law have some throttle for economic slowdown?
If most companies are laying off, why do we need to import labor? Mm-hmm. Well, we talked about 2 big companies that had big layoffs in the press. And yes, other companies do lay off from time to time. I'm not sure if most companies are laying off right now. I don't know if that's the fact. But assuming that is the fact, if most companies are laying off, and I guess you're talking about H1B fields, IT workers and STEM workers, mm-hmm. Do we need to import labor? Probably not. And that might be the reason why Amazon's or H1Bs went down 3,000 in 1 year, or some of the other companies in the top 10, their numbers went down. That's probably the answer, is they weren't importing labor or sponsoring a lot of H1Bs. So you might have answered your own question right there. Does the law have some throttle for economic slowdown? I don't know. What do you mean by throttle?
Reese, if you can please, write your question in detail. What do you mean by this? Because I was also trying to figure out what actually this question meant. So maybe if you can explain us what you actually want to know from Erin. Meanwhile, let me take Rizwan's question. So Rizwan says, hi, I moved from Pakistan to the USA 3 months ago. I am a front-end developer and I have applied for lots of jobs but not received job. Please, any job intern. Okay, well, again, he says this is about a job opportunity, which I don't think we should be talking about here. Rizwan, how about you send me an email on my email ID, which is rajni@staffingly.com. Reach out to me there, and I can help you with something if we have an opportunity for you. Okay, so Rak says people manager L1A has better success than functional manager.
Okay, where's the question? Okay, yeah. People manager, regular L1A has better success than functional manager. I would agree with that. Mm-hmm. We do functional manager, but functional manager L1A are much harder to prove. You have to really show that the function of the company that the person is managing has some intrinsic value or worth. So, for example, let's say it's a project you're managing. When we do those, and we don't do them a lot because, as he says, they are much harder. But let's say we have to do that because there's simply no management of people in the traditional sense. We would show that project, we would show the financial figures, number one, from that project versus, let's say, what the company's income revenue is. We really have to build a case and show them, yes, they're managing, but it's functional and how intrinsically valuable this is to the company. And you can do that with numbers. You can do that with revenue. You can do that with letters. If it's a project management situation where they're managing that project or that function for the company, it can be a project. Then you want to bring in additional evidence, maybe letters from the client showing the longevity and the importance of the project to the company, how that project, without that project, the company wouldn't exist, or things like that. But yes, they are very hard to do. He's right. The functional manager is very highly scrutinized. That's not to say that the L1As are not scrutinized as well, but it's just a functional manager. You have to really put in the worth of the function that they're overseeing or managing.
Okay, so Rag, thank you so much for that comment. And Ankit is also here. Ankit says, my company is filing multiple H1B petitions for different candidates, including me. How does USCIS determine if a company is trying to game the lottery system? Could my application be impacted even if I'm not involved in any wrongdoing?
So if he's describing a situation where an unscrupulous company is somehow filing multiple H1Bs illegally for the same person, yes, you could be impacted because even if it's approved, they're doing investigations and they can come back and revoke the H1B at a later point in time, which means you're going to lose your H1B, even if you're not even working for that company anymore. An example I gave at the beginning of the show was one of my clients. They're working for this company, but now they're challenging how they were picked in the lottery, and was that legal and was that correct? And that's something new. So that's interesting to see. And it's good that they've got people who are looking at this, and they maybe have a better electronic system in place where they can kind of, look at the data and see who's filing for who. And that's why they're asking for your passport number. Because they can easily see how many applications were filed for. Maybe 150 applications were filed for one person. They could see that, and that's where they're going to start looking. So that's good for them in their investigative process.
Right. So, this reminds me of a question that actually I prepared for you, Erin. So I want to also know from you, how can applicants actually ensure that their job offers are legitimate and not at a risk of being categorized as fraudulent?
Yeah, that's a good question. Research the company who's offering you a job. See who they are, number one. I guess if you're in India, and there's a lot of companies in India, and some of them are legitimate companies and some of them are not, right? And I guess that's the situation we have here. Some red flags are they're requiring you to pay for your H1B. You're not supposed to be paying for your own H1B, number one. So that's a red flag. If you're the company and they're like, hey, yeah, we're going to get you an H1B, we just need you to pay for it, or we need you to forward us some money here, be wary of that, number one. Number two, ask questions. Where am I going to be working? Where's the job? That should be in place. A lot of times, obviously, the employee is not going to see the contract between their employer and maybe, the client, but try to ask questions around what you're going to be doing, where you're going to be, where's the physical location of the job. If you're an employee and they're filing, you're entitled to see the LCA, although that will come later after you've already decided to go with that company. But your H1B employees are entitled to a copy of their LCA. They can see everything that's been submitted for them. You should also have a copy of the I-129, which tells the government, here's the job, where it's going to be, what the person's going to be doing, here's the salary. All of that stuff's in the application. So if you're an H1B, if you're looking to become an H1B, just research the company, look for some of these red flags, and don't pay money to a company in India who says, yeah, I can get you an H1B, just we need $500 up front or something. So look for those red flags.
Right. But Erin, do you believe that stricter penalties for fraud will deter companies from questionable practices, or do you think that can happen?
Yeah, I mean, if they're starting to crack down on them and they can actually get these companies and prosecute them, yes, certainly stopping them from filing H1Bs. The problem is, these companies, they morph. They're one set, and then they find them and they stop them, and then they open up new companies, right? So if they're in the business, and if they're in the criminal business of job shopping, they might not even be in the U.S. They can certainly prosecute the ones that are in the U.S. easily, and they have. There's been some cases, you've probably read about them. But if they're overseas and there's a lot of players involved and they're savvy, they simply open up another company tomorrow and they repeat the process, right? But yeah, hopefully they will have more efforts to be able to locate these, and then they prey on the cap lottery. This is their big money maker, right? Every year. So hopefully with all the it's gone electronic, but with all the data that they want, they can do a better job of pinpointing who the lawbreakers are and who are the actual legitimate H1B filers.
Right, right. So now with upcoming changes under a potential, under Trump's administration, what adjustment should applicants anticipate regarding H1B visa policies?
Okay, like we discussed before, I don't think there's going to be a negative impact to companies filing H1Bs, adjudications of H1Bs. I hope it gets better. Just this past year, we have fees on H1Bs and Ls and other business immigration visas that we've never seen before, called the asylum fee. I don't even know how this is constitutional, because these companies are filing these petitions and they're paying now an additional asylum fee on top of all the other fees we have to pay for the illegal asylum scam program that's going on the border. Now, why that floats into business immigration, I don't know, but you can see there's something that hopefully they will do away with. I don't understand why businesses have to pay an asylum fee for a program that is just overwhelmed and in my opinion is a scam. So hopefully that will go away. That will make things a lot easier for small companies who are already paying exorbitant fees, and now they got to pay an extra $300, and even bigger companies who have to pay $600 for every application, on top of the ACWI fee, the fraud fee, the I-129 fee, and all these other great fees that we have. When I started practicing immigration law, I was in Israel at the time. This must have been around 2000 or 1999. The fee for an H-1B was $85. There were no other fees.
Wow.
Now I file a fee for my client. They're looking at almost $5,000, not including premium, for one H-1B. $85, $5,000 premium. I remember when they started the premium program, it was an extra $1,000 or even less, I think. That's gone up every year. Now it's $2,800 for the file to add premium to your case. Lovely. And USCIS takes in so much money in fees. Just USCIS, if you think about it, if it was run properly, they could make massive profits for the government. But apparently they don't, because now they got to add more asylum fees onto it. So they're not making profits, and the wait times and the client service, in my opinion, in 20 years I've been doing this, has gone like this. Now you can't even talk to. I mean, a year and a half ago, I could at least get someone on the phone. Now they've gone to all these things where you got to email them. They've gone to the lockbox. The lockboxes are just a nightmare. Now they have vendor companies coming in and intaking all the mail before it even gets to USCIS. And I can tell you the folks doing that are not the best, let's just say. And these lockboxes are sending cases back at a rate I've never seen in over 20 years. We're getting cases back for the stupidest reasons, for little things here and there. It's just very frustrating what's going on right now. And I'm hoping with all of these efficient people that he's hired to look at USCIS and efficiently clean that up, because that could be a moneymaker with these fees as high as they are. You could be efficient and make money and bring back the client service that we used to have, which wasn't 100% the best, but at least it was some good client service where you could, they make mistakes and clients pay a lot of money. So when you make a mistake and clients pay money, you need to have some client service that can help efficiently. So hopefully that will change for the better as well.
Okay. Well, let's hope that. Thank you so much for answering the question. Erin, RK is back, and this time he says, do you think it would be a good idea to make it that 70% of the H-1B must be granted to individuals like F1 students who have already invested, lived, worked inside the US?
It's interesting. It's an interesting. First of all, as you know, F1 students, if they're in the STEM field, they're going to have 3 H1B lotteries to make it. Now, most of them do. I do have some. We have some that go 1, 2, and 3, and unfortunately, they get unlucky. So I can see that. I don't know if that would be a solution. Maybe something for F1s where after their STEM OPT was finished, and they could show that they applied for 2 or 3 lotteries and didn't get it. Maybe they could get some kind of extension. That could be a good idea. And then they could keep applying for the lottery. Maybe that could be when you focus on 70%, that might not be fair to other companies who rely on H1Bs who maybe don't have a lot of F1s. So I have both types of companies as clients. But there's a lot of things they can do. They've talked about in the past, making it. You could also say, well, some of these big companies, they get thousands and thousands, and you might be a little company and you only need 1 or 2 H1Bs. Is that really fair that they're depositing 3,000 or 10,000 H1B lotteries and you're depositing 3? And maybe all the ones who are small companies should get all those filled before all the big filers. Well, that would hurt the big filers. There's been a lot of different proposals on how to make it. They had it they proposed maybe H1B should go first to the highest salaried applicants. The problem there is now you're going to kill small businesses. Microsoft and Google, that'd be great for them because their salaries tend to be very high. Mm-hmm. But now you're killing the other side of the H1B filer. So I don't like that. There's a lot of proposals to make it more fair. Right now, as we stand, it's traditionally anywhere from 33 to 40% chance of you making an H1B lot, closer to 40 if you're a master's. If you have a U.S. master's, probably closer to 32 or 33% if you don't have U.S. master's. So those are pretty much the numbers. Now, I can remember one year, a few years ago, where we didn't have a lottery. I mean, they didn't fill the numbers. That was when the economy was really bad, if you recall. And the H1B went on. I mean, when I started doing immigration, there was no lottery. Of course, there were 300,000 H1Bs a year, and they went on year round. So we just filed them whenever they came up. Yes, this lottery system is interesting, but I guess it has to be there because the demand is so high. How else could you have a fair way of intaking them? But I mean, there's a lot of different ideas out there. I don't know what the best one is. It would have to be really thought through and fair to different kinds of H1B filers.
Mm-hmm. Right. I mean, people can come up with their ideas, but ultimately it will depend upon the government, what they come up with and what they decide to do, right? So thank you so much.
Yeah, F1 students are a big part of, they're already here, number one, and they tend to be very talented in terms of these niche IT fields, even more so than your run-of-the-mill, let's say, H1B worker at one of the big Indian companies. You know what I mean? These folks are very highly specialized. They're already here. Culturally, they're very attractive. They've already blended in. There's a lot of advantages to them. So maybe they should look at something to help the F1 students a little bit more. The STEM OPT is great. We haven't had that forever. That was new a couple of years ago that came in. Maybe an extension of that, but yeah.
Okay, so actually Lokesh also wants your advice. He says, I have been with my current employer on H1B for 3 years, but I received a better offer from another company. With the current climate of fraud crackdowns, how likely is that my transfer petition might face extra scrutiny? What can I do to avoid any delays or rejections?
Okay, so H1B transfer, or what we call H1B portability cases, is exactly here. You're working and you have a great job offer and you want to jump ship. You want to move to the new company. So first of all, the first thing to note is that your current employer will not see the new H1B application. They have no way to see that. So your current employer will never know that you talked to a new company or that even the new company filed an H1B for you. So as long as you're staying with your current employer and don't tell them anything, you really don't have any jeopardy of losing your current job. That's why a lot of the we do a lot of H1B ports. When the H1B workers are porting, they always want premium because they want to have the H1B approval in their hand. Mm-hmm. So first of all, H1B ports can start working when the application is filed. They don't have to wait for the approval, which is great. However, a situation like this, where you already have a good job and you got another good job, is going to file an H1B for you. This guy wants premium so that he can have the approval notice before he says anything to this job. I understand. It's a sense of security because you could start working with the other employee based on the approval, based on the filing, and then something can go wrong in that application. Now you screwed yourself, and you're going to be really screwed. So yeah. So if the new employer could file in premium, that might be good for you. That way you don't even have to involve your current employer until you have a new approval notice, and then you can move. That's usually what's been going on. That's what we see most of the time. My client gets a new one. They're like, yeah, but they want premium. And then the client's like, well, I don't want to spend $3,000 if I don't have to. They can start working with me now I'm like, yeah, but a lot of these port H1Bs will not start with you until they have that a little bit of the security of knowing they have that approval notice.
Right. Okay,
now, if you're talking about, go ahead, sorry.
No, please go ahead.
If you're talking about fraud crackdowns based on what's going on with the lotteries, that can come and hit you. If you were involved in a lottery with an unscrupulous company and you feel that maybe they were doing something, they were one of these, what I call job shoppers, then you got to be careful that could come back and hit you at any time. That's out of your control. You're not going to know what investigations are going to be done against a company that you had an H1B with 2 years ago, and then they're going to bust them, and now they're going to revoke every single H1B they had. And then, yes, you could be affected by that. So,
yeah, right. So thank you so much for that advice and for that answer, Erin. Lokesh, I hope. And Erin, we also have questions which are posted by the viewer on a Facebook group. So if you allow, I would like to share my screen.
Yeah, sure.
If it's possible.
I can run over. I have time. I can answer questions. That's fine if you want to go a little long. Yeah, I can hear you.
Okay. Thank you so much. Okay, I would like to share my screen. Okay. So this is one group where people have posted questions regarding H1B. So this anonymous member says, because of long waiting time of NIW, this is, I think, an EB1, maybe let's take H1B related question. Okay, Kaushik has posted this 14 minutes ago, and he says, hi all, if you valid visa until April 2025 and have renewed H1B petition till April 2028, you are good to enter US with the existing visa along with renewed petition without restamping with new petition, right?
As long as the visa is valid, unexpired visa, correct. So let's say I work for company A, I have a visa for 3 years, I port to company B, I got an approval notice, and now I want to travel. With the new approval notice of company B, you can use the visa from company A as long as it's valid. In my example, it's valid for 3 years. Yes, you can keep using that visa to go in and out, even though you're not working for company A anymore, but you must have the approval notice for company B to show them every time you enter, if you don't want to get a new visa stamp.
Okay.
But the visa always has to be valid. You can't come in on an expired visa. That's one thing you cannot do.
Right. Okay.
Okay.
Kaushik, I hope you have got your answer. Let me quickly read. So actually, we've been continuously getting questions on this group. Please respond fast. I have doubt. I have Dropbox appointment today. My pay stubs have old pay and company didn't mention my new salary in employment verification letter. And in Dropbox, they won't ask my revised offer letter, but I have it. How will they know about my new salary? What should I need to do?
If you've already submitted everything in the Dropbox, there's nothing you can do. They're going to you've already submitted your passport. They'll send it back to you with the new visa. If they have a problem, they'll let you know. Getting increased salary is not a big deal. In fact, if you're an H1B in the US and you've gotten a huge jump in salary, we don't file H1B amendments for that.
Okay.
So I don't panic. This person's panicking too much.
Right. So maybe they need to calm down a bit. It happens because you have just applied for the visa, so that's fine. This anonymous member says, can I get stamping to passport, which will be expired in 7 months? Once stamped, I can get passport renewed and can fly to US from India with all new passport and valid stamping.
Yes. If you have let's say you got an H1B visa, but then the passport expires, but the visa is still good, you get your new passport, you travel with both passports, and he will look at the visa in the old passport, and you can travel like that. Correct.
Okay. So, this person says, hi guys, I worked with DXE Technologies in India, which was an HP enterprise back then. Now I skill set. No, this is not related to. Hello, please assist me in understanding the table. Okay, this is again a table. Okay, this person says, I got NOIR, H1B after USCIS site visit. Any idea how long will it take for USCIS to take final decision? Employer replied for the notice.
So the NO notice of intent to revoke was received, and the employer already responded to them.
Mm-hmm.
And that was outside a regular filing. I guess or was it a premium case that was filed?
Not much details are here,
well,
but
I mean, if it
it
was
says H1B after USCIS site visit.
after a site visit, okay.
Yeah.
It's hard to say. Those can sit for a long time. I guess there's no premium in play here. So if they've responded, it's hard. It could be all over the map. It could be a couple months. I don't know. We've had those that have pended for a long time, and we were like, wow. I mean, the good news is you're still working and you don't have to leave or anything. So
okay.
It's hard for me to get timelines. Are the hardest questions I have from my clients, because you can look online and see time frames, and those are usually not really good. And then someone's asking you, well, when am I, it's not premium. When am I going to get my case? And we can look at trends, but it's hard to really give really good pinpointed timelines of when you'll, outside of premium, of when you'll get cases back. It's tough. That's a very frustrating part of it.
Okay. So, all right. Thank you so much for answering these questions, Erin. I think we have had a great show with you. We did try to cover a lot of questions, though still a lot of them are pending, but we still try to cover a lot in today's episode. So thank you so much for being here. And to our lovely audience, I would like to say that if you would like to get in touch with Erin, please give him a call on the number. I would like to display on screen, or maybe I would like to request a control to display on screen.
Yeah, 469-459-1771. That's the office. You can reach me.
Right. So please give Erin a call on the number if you're trying to get in touch with him. His number is 469-459-1771. I would like to repeat it, 469-459-1771. You can also email him. His email ID is erin@eeglawgroup.com. And you can also visit his website, which is www.eeglawgroup.com. Yes, you wanted to add something to it, Erin. Please go ahead.
I was just going to say, if you're calling me, I can give you advice and help you. But if you're really looking for a job and you don't have an employer, we're a law firm. You need to, find some recruiting companies. After you have an employer in place and maybe a job offer, and you need assistance or you have questions, I can answer those questions. But I can't. I sometimes we get questions where they're just looking for a job, and it's we're not in that business. So
if you're looking for a job, guys, you can get in touch with me. My email is rajni@staffingly.com. And if you're looking for any immigration, looking for a help related to your immigration related case, so for that, please get in touch with Erin. We have already displayed his information and also have read the information for you so that you can note it down. So make sure that you get in touch with Erin as soon as possible. And thank you so much for joining us today. Erin, thank you so much for being here. It was lovely having you. Maybe we can have you for another episode so that we can cover more questions in that show. But thank you so much for being here again today.
No problem. Good talking to you. Thanks for having me. Good to be here.
Thank you so much. And guys, thank you so much for your questions. Please continue posting them, because whenever Erin is going to be back, we are going to take those questions in that episode, or maybe we can directly ask him by writing an email to him asking for the answer. So we are going to reply to your questions in the comments below. So you make sure that you continue posting your questions in the comments below. But for now, that's it from my side. I'll have to take your leave for now. I'll be seeing you again tomorrow. But for now, thank you. Keep watching and keep subscribing to Immigration and Jobs Talk Show. Bye for now.
Hello and welcome everyone to Immigration and Jobs Talk Show. I am Napasa Prasad, your host for today's session. And before we move ahead with our webinar that's lined up with our amazing guest today, I have this important disclaimer. That is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. Once again, folks, welcome to Immigration and Jobs Talk Show. And we are here to dive into today's topic of discussion. Yes, we are going to discuss about, USCIS has officially announced that it has reached the H1B cap for fiscal year 2025. So, what does this mean for thousands of aspiring professionals and employers hoping to secure an H1B visa? And to unpack this, we are going to have our guest for today, a regular face who makes it a point to join us every week. So, without further ado, please help me welcome Attorney Prashanthi Reddy from the Law Offices of Prashanthi Reddy. Thank you so much, Prashanthi, for joining us.
Hi, Napasa. It's good to be back.
Yes, so maybe you could tell folks out there what can they expect from today's session.
I guess we're going to be talking about alternatives to the H1B cap. That would be a major chunk because now that the cap is over, you will not be able to be on a H1 until next March because that's when the next cap starts. So now that the cap is completed and no further lotteries are going to be done as per the USCIS announcement, we have to find alternatives for work employment, right? So for employment, so work visas, if there are any alternative work visas for employers as well as for employees. So we're going to discuss that, and we're going to discuss a little bit about, what is the scenario for the future, what changes, if any, are likely to be made. What are the good ways of ensuring that you have a better chance in the cap, et cetera, et cetera. So that's what we're going to be talking about today.
Absolutely. So, friends, stay tuned and thank you for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook, and also on X. So, please feel free to, participate in this conversation. Maybe you have some questions with regard to our topic today. So, please feel free to comment them. And another thing is, you can also join us in this discussion by dialing this number, which is displayed on the screen. And the number is 425 436 6335. And when they ask for the access code, dial in 988-888 and you will be able to jump in to this conversation. So very happy to do this. And absolutely. So whether you are an employer, a current visa holder, or someone considering applying in the future, this session is going to provide you insights and strategies to go through this complex landscape. So thank you so much, Prashanthi, for helping us today. And I think without further ado, let's go on with our questions. And I have this first one that is, with the USCIS announcing that the H1B cap for 2025 has been reached, what does this mean for applicants who were, not selected in the lottery? And are there any alternative pathways for them to work in the US?
Yes, so they are alternative pathways that obviously they're not as good as the H1 and they're more limited in their nature. So let's go and see what the alternatives are to a H1. One is, of course, cap exempt H1. If you're not subject to the cap, how can you be a cap exempt? As if you are, and if your employer or if you are an employer who is an institution of higher education, non-profit related or affiliated to an institution of higher education or a non-profit research organization. If you're one of these three, then you're cap exempt and you can file your H1 at any time. You're not subject to this so-called H1B cap. So you have to remember that not only are the direct employers are cap exempt, but also if you're an employee indirectly to an employer, that is, say you have a consulting company and the consulting company has a client who is cap exempt, then in those circumstances also your H1B petition would be a cap exempt petition. So that's something very important to keep in mind. The other alternative is, of course, you could file an O1 visa. O1 visas are generally reserved for individuals who have extraordinary ability in the sciences, and the arts, in education, in business or athletics. And by definition, not many people qualify for extraordinary ability because they are extraordinary. But where possible, it's good to review and see if you have if you qualify for an O1. Maybe if you are a researcher, you could more easily qualify for an O1 because it's easier to show that your research is extraordinary. So the O1 is definitely another option, but as I said, it's limited to only those who are extraordinary in their field. How do you show that you're extraordinary? You show that by showing that you're in the top 1%, say, of your field. That could be through newspaper clippings about you. It could be about peer review, so people that are top in their field, in the field that you're working, can give you a recommendation letter recommending that you are of extraordinary ability in your field. You could be a member of where membership requires, of a certain organization where membership requires really high standards. You could be judging other people's work. You could have published your articles in prestigious publications in your field. So there are many ways you could have received awards in your field. So there are many ways, as I said, of showing extraordinary ability. Other option is the L1, intra-company transferee. So there is an L1A and there's L1B. L1B is for those employees who have specialized knowledge. It does not have to be proprietary, but it has to be knowledge that they cannot train, in 6 months or 1 year. It's usually helpful for L1B if maybe you have knowledge of the systems, the processes, or maybe you have knowledge of the domain of the end client, which is not easily obtainable without additional training. So if you worked in order for an L1, whether it be L1B or L1A, you should have a company in India and there should be a company in the US, and there has to be a relationship between the two. And the company in India, say, I'm just giving you an example of India, should be transferring you as an intra-company transferee from India to the US and to work at the US organization. So as I said, L1B is one option where there's specialized knowledge. L1A is another option, which is for multinational, allows multinational companies to send their executives, top executives or managers. So if you are L1A, you have to be top executive or managerial level positions, and you have to show documentary evidence that you worked in the company from the past 1 year, either in the specialized knowledge if you're L1B, or as a multinational executive if you're L1A. And you have to submit documentation, etc. So it's a very document heavy petition, the L1. The advantage of the L1A is that you qualify for EB1 and therefore you can file your green card under EB1. You file an I-140 directly, you don't have to file labor cert. For the L1B category, unfortunately, it's not EB1 and you have to file a labor cert and an I-140 just as you would in a H1B situation under EB2 or EB3. So that's L1. Now, there's certain country-specific work visas. So people belonging to a particular country can only get those work visas. For example, Canadian and Mexican nationals can get a TN visa. TN visa is available and is not subject to any cap. And it's fairly easy to obtain. You can apply at the border as long as you qualify under one of the designated occupations. The designated occupations for TN are available online, which if you want to check them out. And that list also has the educational credentials that are required for that particular position. So if you have those credentials and if you are under one of the designated occupations, if your job is under the designated occupations, then you can get a T1 at the border, TN at the border. So for Canada, it's at the border. In Mexico, you'd have to actually file at the consulate. Another country-specific visa is H1B1, which is same as the H1B, but there's a special cap quota for it. I believe it's 10,000. And this is available for people who are from Singapore and Chile. Another visa available is the E3 for Australia. So if you're an Australian national, you can apply for an E3, which is very similar to a H1. You need to show specialty occupation. Again, you can go and apply directly at the consulate. You do not have to file a petition and get an approval from USCIS. And there's no cap again for the E3. So that's the E3. Then there's also E1 and E2, which is treaty trader and treaty investor. For countries, again, you can go online and check which countries this is applicable to. So if they have signed the treaty trader or treaty investor agreement, then you can bring your employee as a trader, treaty trader, or a treaty investor. Again, there's specific requirements for this. You have to show that the investment required has been transferred from the foreign company to the US company. The amount of investment is really, it's got proportionality test, meaning that depends on what investment is needed by that particular industry. And the company has to have done significant, for the treaty trader visa, significant trade between the US and that foreign company. And the employees must have skills that are required for that particular trade. And investment is, you're required to invest a certain amount of money depending on the type of industry that you're in. So that's E1, E2, treaty trader, treaty investor. Again, no cap for that. The other option is the F1 OPT and CPT. OPT is two types, post-completion OPT, and that's for 1 year after completion of your degree. And then there's STEM OPT, which is only available for people in the STEM field, and that's an additional 2 years after the completion of your post-completion OPT of 1 year. You also have CPT, curricular practical training. This is available for students where the school requires you or allows you to take to get hired off campus, but prior approval is required. Usually curricular practical training has to be related to the degree that you're studying. So that's CPT and OPT, so you have that as well. You can also file for a green card directly in EB1 for Indian nationals. And for people who are not from India and China, you can apply in EB2 and EB3 as well, because the priority dates are not that backlogged. You still do have to wait. You have to file the labor, I-140, and then file for the green card consular processing. And the National Visa Center will send you an application. You can pay the fee, upload documents, and then the consulate gets involved, and then they call you for an interview, and they will give you the green card if you qualify. So unfortunately, this is of course only available for people who are not from the backlogged countries, China and India. All other countries, EB1 is sometimes current, EB2 is not that far behind, so it's easier to apply directly for that green card and not have to apply for a non-immigrant visa. And have to go through the lottery, etc. Of course, you can always wait for April 1 for the next lottery, and then you can file that. So that's an overview of what the alternatives are for a H1B. Nipasa?
Yes, thank you so much, Prashanthi. I mean, those were great options, and folks out there, Prashanthi has in detail mentioned, the different alternative visas that you could apply for, and maybe to know which would be the best fit for you. It's always best to consult an attorney. So why not contact attorney Prashanthi Reddy herself, and you can do that by calling her on her number, and her phone number is 212-354-1010. You can also email her at prashanthi@reddyesq.com and go visit www.reddyesq.com to get to know more about Prashanthi Reddy and the law offices of Prashanthi Reddy. And at this moment, I'd like to say hello to Sneha and Ritika. Thank you so much for joining us with your questions. We are going to address them a little later in our show. And for now, Prashanthi, what are the next steps for individuals who have been selected in the H1B lottery, and how should they prepare for their petition submission to maximize approval chances?
So once you've been selected in the lottery, since we've had 2 lotteries, most probably, you already know your results and you've most probably filed your petition, because even for the second lottery, the filing deadline was sometime in November. But for next year, if you do get picked, then it's very important that you follow these few guidelines that I'm going to tell you. Number one, ensure that you send the application out to the service center that is on your registration approval. So it's no longer based on your address or your employer's address. The address will be that you need to send out your petition will be on the lottery approval notice. So keep that in mind. Number two, make sure you send out your application within the given period. It's 90 days to send out your application, and the last date will be mentioned again on your lottery approval. So make sure you keep track of that. Also, always important, don't send it in the last minute. Try and send it at least a month or 2 months in advance, so that for some reason, if the petition comes back because you did something wrong, then you have enough time to resend it again. Number four, make sure you send out the petition with the correct fees. Always important, because the fees are complicated. It depends on the number of employees. It depends on, so number of employees that the employer has. And also the asylum fee is applicable to some, it's not applicable to some. It's a lower fee for some. So again, it all depends on the number of employees that you have. So keep that in mind. And there's several different kinds of fees that are affected by the number of employees. So keep that in mind and submit the correct fees. Number five, what you should do is make sure that you send out a complete application. Make sure you fill out the forms completely, sign wherever required, choose the correct boxes, review your case thoroughly to make sure that you've not checkmarked a wrong box, or not checkmarked a box, or forgotten to checkmark a box. Make sure you sign. The attorney signs, the petitioner signs. There's no beneficiary signature required. Also, make sure that you submit all the documents that you need to submit for a H1B, which includes status documents, includes documents about your company, where the person is going to work, POs and contracts, if applicable. Don't leave anything to chance. Try to avoid an RFE. Submit evaluation documents, degree certificates. These are beneficiary documents, because otherwise you'll get an RFE, and then the chances of approval are lower if you get an RFE. And also the processing time is higher. So you want to avoid getting that RFE if you can. So I think these are a few pointers to what you should do in order to successfully file your H1B.
Thank you so much, Prashanthi, for those tips. And I'm sure they are going to be very, very beneficial for all our viewers out there who are, applying for their H1B visa or have been selected, at least in the lottery. Thank you so much. Now, let's go on to our next question. And that is, what does hitting the H1B cap so quickly in 2025 indicate about the demand for skilled foreign workers in the US job market?
Well, it means that there is a high demand for skilled workers in the US market. There's still a high demand despite the layoffs that we see in the IT industry. There is still an extremely high demand, which means that there are not sufficient US workers to fill those jobs. Otherwise, they would not be looking for foreign workers, because, as per Labor Department rules, the foreign workers have to be paid just as much as the US workers. So they have no incentive to look for foreign workers other than the fact that there are no U.S. citizens available, for the job. So, otherwise consulting companies could just hire US citizens and then contract them out to other companies rather than looking for H1Bs. So, and that's not necessarily the case. As I said, there's no availability of US citizens for a lot of these STEM related jobs and definitely in the healthcare industry as well. So, I just wanted to take this a little further and, what does it mean that the cap is being hit? What does it mean for the job market that H1B numbers are no longer available? What does it mean for the job market that H1B numbers are limited even? So just to answer that, we have to figure out first whether expanding H1B numbers will help American workers or will hurt American workers, right? So there's always talk about the H1B numbers have to be increased, but on the other side says that increasing H1B numbers will hurt American workers. So what are the facts of this? There are a lot of research that's being done on this, and economists have done research. There are several papers written on it, and in fact, the research shows that hiring the hiring more H1B workers, in fact, improves the job market for American citizens. Because this is how it works. If there is no job available for a particular STEM position, then that job tends to go overseas, right? Microsoft has started its operations in Canada and all over the world because they're having problems with the H1s and finding the right talent. So they're looking for that talent elsewhere outside the country. But if they found that worker here as a H1B, then based on that job, 5 other jobs are created for American workers. May not be STEM jobs, maybe administrative jobs, for which, there are plenty of American workers available. Or business-related job, MBA or BBA, business administration-related jobs. So that's what the research has found. So cities that get more H1Bs, and this is of course just random because it's based on the lottery, they see that the job market improves in those cities and more jobs are created. Bill Gates said that Microsoft has found that for every H1B hire we make, we add on an average of 4 additional employees to support them in various capacities. Bill Gates has said this. So even though the results may seem counterintuitive, it's a fact that more American jobs are created when more vacancies are filled by high-skilled workers, right? So this is something to keep in mind. And as I said, restricting H1B visas just basically leads to offshoring. As I was saying that, all those jobs just go out of the country, and that's a loss of so much loss to the economy because, all other industries boom when one job is created. There's a boom in real estate, there's a boom in spending, there's a boom in retail. So it's a domino effect. When one H1B is restricted, it restricts the entire economy in so many ways. So yeah, I would, Nipasa, to answer your question, I think it indicates, filling of the cap this year and all the previous years indicates that there's a high demand and the demand is not being met.
It's true. So true. Thank you so much, Prashanthi, for the detailed explanation and for helping us understand this better. Let's address some of our viewers' questions now. I think we should, and let's take up Sneha's first. I was selected in this year's lottery, but my employer delayed filing the petition. Now that the cap is hit, does that mean my application is no longer valid?
Well, if you did not file the application in the 90 days period that was given to you, you cannot file it now. If you've already filed it, then you don't have an issue. Your application will be processed, even if there is a delay in processing it. So the cap does not have any effect on a petition which has already been filed. And if the petition was not filed, then whether the cap is reached or not reached, you cannot file it again, because even if there was another lottery, you will not be selected in the other lottery because you are already selected.
There you go, Sneha. Thank you so much, Prashanthi, for taking this up. And now let's go on to Ritika's question. How does the H1B cap being reached impact the timing and planning for fiscal year 2026 filings? And what steps can employers and individuals take now to prepare for the next filing season?
So I guess in order to prepare the next filing season, you have to make sure that you've done your homework, make sure that you have identified, of course, don't miss the deadline. That's the most important thing. So keep an eye out for when the registration opens up. Ensure that your employer has all the necessary information for them to file the registration. So do some homework to see what information is needed. There's not much information needed, simply a copy of the applicant's passport. And also you need some information with reference to the company, the address, the federal ID number, phone number, other contact information, the signature, etc. of the employer. So ensure that you use either an attorney or you are well aware of how to file a cap registration, because if you do it wrong, or if you don't pay the fee correctly, or if your fee doesn't go through because the bank has blocked your credit card or something like that, then you will not be successful in your cap registration. So make sure all these tips are followed for the next year before you file your registration. Keep yourself informed, most importantly. With reference to timing, you should at least do all the preliminary work. Start it now. Identify the employees that you're hiring. If you're an employee, then identify the businesses that are going to register for you for the cap. So I think you should start now and be aware of what is needed to file a registration to start off with. And then after that, once your registration is picked, then you would go into the other information with reference to how to file a H1B petition. And you can, then look into that information and make sure that you have all that ready. You do have 90 days, but the sooner you file it, the better. So first step is registration, making sure you have all the information for that. And the second step is, if you get picked, then making sure that you have all the information required to file the H1B petition within the 90 days period.
Right. Thank you so much for taking that up, Prashanthi, for Ritika. And I think now we should go to Hari's question. This is also on YouTube. Hari's asking, we submitted our AOS I-485 in September 2021 when FAD is current. PD 8th 2013 India, I-140 approved in 2016. Now my elder kid is turning 21 in the coming month. How do I make sure he is protected under CSPA? Thanks.
He's as long as he's filed adjustment of status and the application is the 485 is pending, he's already protected. And even if he turns 21, it does not affect his green card application. So you should be good.
Okay. So Hari, if you have any further questions, you can keep commenting. But thank you for participating. And thank you, Prashanthi, for taking that up. And now we have Hardeep's question. How likely will the percentage of H1B registrations selected for fiscal year 2025 be higher than in the first selection round last year for the fiscal year 2024 cap?
I think it will be the same as last year. I don't expect that they will select a higher percentage of H1B registrations. I know why you're asking that. You're thinking that maybe they expect that a lower percentage will file H1s and therefore they'll select a higher percentage. I don't think they'll do that. They'll do, they'll follow a measured approach, because they can't be sure how many people will actually file H1s after they get the registration picked. So they'll follow a measured approach and go, step by step. They will pick a more number than required, because historically there is a certain percentage of H1s that are not filed even after getting selected in the lottery. But I think they will take a two-step approach, and they will do a second lottery rather than trying to pick as many as possible in the first lottery.
Right. Right. Thank you so much for taking that up, Prashanthi. And Hardeep, if you have any further questions, please keep commenting. Thank you for participating with your question. Let's move on to our questions, Prashanthi. And, for companies sponsoring H1B applicants, what strategies can they adopt for future CAP seasons to increase the odds of their employees getting selected?
Well, we know that the lottery system, it's a lottery system, so it's a random lottery system. So it's really hard to do anything to increase or decrease your luck. But there are some things that can be done. Number one, try to, if you have a US master's degree, use your US master's degree for the registration, as long as it's related to your degree. But you have to keep in mind that the US master's degree has to be from a private, from a not a public organization or a private not-for-profit. So it cannot be a private for-profit university. Then you will not qualify for the lottery under the master's cap. So try to use your US Masters, because the US Masters has a separate 20,000 lottery numbers. So that definitely a person with a US Masters has a better chance of being picked in the lottery than a person with a bachelor's degree. US Masters people get 2 picks in the lottery. They first get run into the Masters lottery. And then if they don't get picked, they get run again into the bachelor's lottery. So they have higher chances because they run twice, and also because there's a separate 20,000 master's cap for US master's degree holders or higher. This goes without saying, file multiple years, keep filing. So don't wait until the last year that your OPT is expiring to file your H1. So mathematically speaking, filing a H1 cap multiple years increases your overall chance of becoming successful in getting picked in the lottery. Therefore, in every opportunity to get, please make sure you file that lottery, file the registration for the lottery. So, if you're in a STEM, then you get most probably 3 years in a row you can file for the lottery. So make sure you make use of all those 3 years. So again, find, alternative ways to get picked. I mean, alternative ways. If the H1B is not picked, then I guess you'll have to find alternative work visas that, like we discussed. So, try to find that if you're not able to get picked and you're not successful. Also, sometimes you might be a master's degree, but you might not have completed your master's degree. See if you can still file a registration under master's cap, even though you have not completed it. Perhaps if you have completed all the requirements towards it, but you don't have the actual degree, you would still qualify. So, you might be able to do it that way. So see if there are any other alternative ways of doing it. File a registration with multiple employers. Now, this is a little tricky because USCIS specifically prohibits multiple H1B filings with the same employer or with different employers if there's collusion between the employers. But if you are approaching separate employers independently, and if there is a separate job that is being offered through each employer, separate job meaning the client is different, the job is completely different. It's not the same client and several employers are filing for you. So if that's the case, then you should file multiple. But now, unfortunately, even if you file for multiple employers since this year, they've removed that incentive, and that, so you will only be picked once even if you file for multiple employers. So that no longer holds good. Of course, file a perfect application. That's number 5. Make sure you don't make any mistakes. make sure your H1B is properly prepared, your registration is properly done, the credit card doesn't get declined. So all that, make sure it's a perfect application. So you will get maximize your chances of getting the H1B approval.
For sure, for sure. Thank you so much, Prashanthi, for taking that up. And we should address Girish's question on YouTube now. Girish is asking, how has the insertion of the H1B visa cap evolving industry trends and shifting immigration policies between 2025 and 2015 and 2025 impacted the diversity of talent acquisition strategies?
I think with the unavailability of visa numbers, or the shortage of visa numbers, what has happened is employers are looking outside the country to find talent, and they're moving the entire job outside the country. So as I said, a lot of jobs have moved to Canada, a lot of jobs have moved to India. I've given you the example of Microsoft. So yeah, that's how it's affected. Jobs have basically moved outside the country.
Thank you so much for taking that up for Girish. And
So
Girish,
they're
if you have
talking.
any more questions, yeah.
Girish is also talking about startups versus established tech giants. So startups have more issues, obviously, with filing or getting H1B approvals versus or getting talent into the country versus the tech giants. And being a smaller company is definitely more difficult for people to get their talent, mainly because larger companies, number one, they have more immigration options. They have better staff who knows about immigration and is able to go through all the loopholes. Also, they have the ability to find talent outside the country and continue to be competitive. Like Microsoft opens offices all over the world and finds the talent they need wherever they need it, if they're not able to get it here, right? But as a startup, you don't have those kind of resources to open up offices outside the country and to tap foreign talent outside the country and get them working remotely outside the country, because then you have to set up offices there in other countries. So you have to have the money and the resources to be able to do that. So finding talent outside and retaining them is not possible for small businesses, while it is for large companies. Also, large companies have the option of filing blanket L1 applications, L1A and L1B. This is pretty much gives them an unlimited stream of talent that they're able to tap and bring to the US. Small companies don't have that, because you have to be a large company to be able to qualify for an L1 blanket. Of course, there are issues with L1 blankets as well, but definitely a good resource for big companies to tap into. So also their employees have a higher chance of getting a visa approved rather than a smaller company, higher chances of getting a H1B approved with USCIS, not only a visa with Department of State, again, because it's a larger company. And USCIS also, unfortunately, discriminates with reference to their processing if it's a smaller startup when compared to a larger established Microsoft type company.
For sure. Thank you so much for taking that up in details for Girish. Girish, I hope you've got your answers. And if you have any more questions, keep commenting. Let's take up Ravi's question now. With masters from India, do I qualify for STEM category?
With masters from India, do I STEM category? I don't understand what STEM category means. Are you talking about OPT STEM?
STEM OPT, I think, yes.
Yeah, can you please be more elaborate as to what you mean by STEM category? What STEM category? F1 OPT STEM? Then you have to have a master's in the US in the STEM category to qualify for STEM OPT.
Okay. Ravi, we would like to know more about you. And in fact, you can also call us up, on this number 425-436-6335 and dial in this access code 988-888 Say hello after that, we'll be able to hear you. And hi, Rag. Thank you so much for joining. Rag says hello, Napasa and Prashanthi. Rag, please feel free to join us on this call also, or yes, just comment your question. We will address it soon. Let's move on, Prashanthi. Now, if you could tell us, given the limited number of H1B visas and the high volume of applicants, do you think the lottery system is still the fairest way to allocate these visas? Why or why not?
There are arguments for and against with reference to whether the lottery is like a blind system is the best way, or should the numbers be allocated based on where the need is, or where the country needs them, which the industry where the country needs them, right? So such as high demand areas such as IT or healthcare, etc. So the argument for, of course, there is. Let's talk about whether it's the arguments for the lottery system. Is this a good way of allocating H1B numbers, because there is oversubscription, and earlier it used to be first come first serve, but that was chaos because all the cases, thousands of applications were filed in one day, and then they would just reject applications that the excess applications, and there was no system on the basis of which they were rejecting them, because all of them were being received on the same day, right? So now they're trying to follow a system which is like a lottery system. So and then there is 90 days to file it. So it's a better system compared to the previous one. The lottery system grants equal opportunity. There's transparency in the process, and administratively it's easy. So you don't have thousands and thousands of pages of applications sitting in USCIS being and having to be processed and being sent back if they are not approved under the lottery. They're not selected under the lottery. That was the previous system. So definitely the new system is better in that way because it's fairer, and administratively it's much, much better. But there are arguments against the lottery system also, because if you're leaving it to chance, which is what a lottery is, it's not merit based. So you're not considering the applicant's skills or experience or the applicant's potential to contribute to the US economy before deciding whether to give them the number or not. Highly qualified individuals may be left out, while people less qualified will be selected because of the pure chance of the lottery. It discourages innovation because there's no incentive for employers to seek out the most exceptional talent, right? Or people with master's degree or maybe 10 years of experience, because the qualification for a H1B is the same for everyone. So what changes can be made because of this? What are the potential alternatives to the lottery system to allocate H1B numbers? I guess you could have a merit-based system where you prioritize and give numbers to those applicants based on factors like education and work experience or skills. Or you can allocate numbers based on industry specific. So say if you are a hospital or you're in the healthcare industry, you can give a certain allocation of visas, H1B visas to them, maybe to nurses, to doctors. Or you can just, the best alternative is to increase the H1B cap. Because we know that the numbers that are presently there are 3 times that are being filed. So you have to increase the cap by 3 times to meet the demand. Okay. So that's, in a nutshell, what the alternatives are and what I think about the present lottery system.
Visa lottery system, yes. Thank you so much, Prashanthi. Thank you for taking that up. Rag is here with his question now. But before that, let's take up Ravi's. Ma'am, I meant the H1B under master's cap for masters from India.
Okay. I'm glad we asked the question and he
yes, I'm glad.
responded. Yeah, a master's cap. To qualify for a master's cap, you have to have a US master's degree. So it cannot be an Indian master's degree.
Okay. So Ravi, unfortunately, I do not think you qualify for the H1B master's cap then.
Unless he does a master's degree.
again.
He can qualify.
Another
Yeah,
one.
if he does a master's degree in something else, then he could qualify.
Okay. All the best, Ravi. And now let's take up Rags. Rag is saying, what about the tech non-profits as compared to startups and the big companies?
There is no. I mean, is he talking about what about what? I mean, what is the question? The chances of getting a H1 visa, or is this a continuation of the previous question? I can't hear you, Nipasa.
Rag, if you could be more specific with what you want to know, maybe give us more details on your question, it would be, I mean, more
Yeah,
convenient
rather
for us
than
to answer.
me presuming what you're saying, and yeah, ask the question completely.
Yes. And Ravi
It's
says,
easier for
thank you.
the
Okay, Abbas
easier
now.
for
We
the
have, this is
viewers
on,
also that.
right, right. We have Abbas's question from Prashanthi's channel. So really good to have you, Abbas. If I have one of my company will file H1B, can I work with the other company without filing H1B? They are same job title while I'm in OPT and applying for H1B. Thanks.
So again, the fact scenario is not clear, but looks like the person is on working for another company on OPT and wants to know if they can continue to work on OPT while the H1 is being filed. Yes, you can. You only need to move to that company which files your H1 once it's October 1st, if it's a cap case, or the H1B is approved, whichever is later. Then you need to move to the employer that's actually filed your H1B cap. You cannot continue to work for the previous employer.
Okay. Thank you for taking that up for Abbas. Abbas, I hope you got your answer. If you have more questions or you need more clarifications, keep commenting. I think now we have some more questions, Prashanthi, and these are from our Facebook groups. So I'd like control to please display them. Let's take up this first one. For Dropbox H1B, is there any fingerprinting process or direct Dropbox?
There's no fingerprinting process as far as I know. I think it's just a Dropbox. And this because Dropbox is available for people who have previously had, filed a visa. So the presumption is they already have your fingerprints on record. But again, I could be wrong. So I can look that up and answer if there's any fingerprints.
Sure. Sure, Prashanthi. And while we check that, maybe we can read out this next question. This is from an anonymous member. I am on H1B visa. Now my mother is in ICU. If I am traveling to my home country and while returning, is there any issues? My spouse and my newborn kid will stay in the USA. And please let me know what all documents do I need to carry along with me. Thanks in advance.
I'm presuming this question is because Trump administration is going to come to power, so everybody's worried about traveling, at least until things are more clear. So I think, I mean, I don't expect that the laws will be significantly changed over this short-term period, because in order to change the laws, there is a certain process and we will be given notice. But what will happen is it'll become more difficult. There'll be more scrutiny on everything. There'll be more requests for documentation. So with reference to this particular aspect of traveling and coming back on a valid visa, and if you have, as long as you have a valid job, etc., there shouldn't be any problems, but they might ask for more documents. So make sure that you carry everything with you, including your pay stubs to show that you're in status, your H1B approval, of course. If you can carry the original, that'll be great. And be ready to be prepared to answer any questions. Make sure you're in status. You file the required amendments if needed. If you've changed job location, you are getting paid the salary as per the LCA. So make sure you're meeting all the conditions of the H1. Don't take it for granted. Review your petition, carry a copy of your H1B petition, ask that from your employer. And I would just be more careful rather than presuming that they'll just brush you through like they usually do. They just wave you through, right, at the port of entry. So presume the worst and go prepared.
Okay. Thank you so much, Prashanthi, for addressing this one. Let's move on to our next. This is another anonymous member asking, last year in September, my husband moved to the US on an H1B visa and I joined him on an H4 visa. Unfortunately, this September, he was laid off. To maintain lawful status, we applied for a change of status to B2 before the grace period ended, and USCIS has confirmed they received our application. Our B2 status is valid until April. In the meantime, I've been admitted to a nursing school to complete my prerequisites, and I'm eager to stay here to pursue my career in nursing. I plan to apply for an F1 visa, and once my husband secures a new job and returns to H1B status, I intend to continue my studies. Has anyone have has anyone been in a similar situation? And what are the chances of my F1 visa being approved under these circumstances? I would love to hear your experiences or advice.
Yeah, there are a lot of people who are in similar circumstances. In fact, every week I get several phone calls, almost once a day, from people who have been laid off and are trying to explore how to remain in the country and what to do with the 60 days grace if they don't get a job within that 60 days, because 60 days is not a long time to find a job, right? So most people do file for a change of status to a B2 or an F1. It depends on what their long-term plans are. I have not seen issues with change of status from a 60 days grace to an F1. They are asking for proof that you're maintaining your residence in India, and they're asking for property documentation, proof of residence, etc., Aadhaar card or whatever ID cards if you're from India. So they are sending RFUs related to that, and also proof that you have money to, you know, to continue your education or to pay for your tuition. So these are some questions they're asking about the F1. But in your situation, since you have a pending B2 application and you don't have the actual B2 approval, and you'll be filing an F1 from the pending B2 application, there might be a question of what is your present status, and they might send an RFE asking for proof that you have an approved B2. But USCIS has again said that they will accept bridging petitions. So hopefully, unless the new administration comes and changes that, you should be able to file for a change of status from a pending B2 to an F1.
Okay. Thank you for
Nipasa,
taking that up, Prashanthi.
sorry,
Yeah.
Nipasa, I have one more minute, and after that, I have somewhere to be. So
Sure, sure. Let's take up a buzz's question quickly then because he's here. So it's a continuation. Because I couldn't find a full-time job, I had one company I'm working with. They will file an H1B, but I still have other job offers for another part-time. But they said they won't file H1B. Can I work for both without affecting my OPT status? He's asking.
you can't. You should file, as I said again. You have to file the H1 because you have to file within that period of time. You don't want to lose your H1 if you get picked in the lottery. And you cannot work for the second company on OPT unless you file your H1 for consular processing. Then your H1 will not get converted to a H1 until you leave the country and come back. In which case, you can continue working on your OPT for that company and then change to the H1 employer when you want to by leaving the country and coming back on a H1 visa. But you cannot work for both OPT and H1 at the same time.
Okay. Thank you so much for taking that up, Abbas. And thank you, Abbas, for your question. Thank you for participating. And Okay, last but not the least, does the USCIS have a bias for or against grant taking nonprofit tech initiatives?
I don't see why there should be a bias
Okay.
for
Thank you,
nonprofits.
Rag.
Or yeah, I don't see that there will be a bias. I don't see a reason why.
Okay. Thank you so much, Prashanthi, for answering so many of our questions, especially our viewers' questions. I'm sure they must have all benefited, watching us here in the session and learning so much from the session. Thank you so much, and I'm looking forward to having you back once again in the coming week.
Thank you, Nipasa. Take care. See you next week.
Thank you, Prashanthi. Have a great day. And folks, you can always contact Attorney Prashanthi Reddy. You can write to her, you can email her or call her on this number 212-354-1010. And her email address is prashanthi@reddyesq.com. And go visit www.reddyesq.com to get to know more about Attorney Prashanthi Reddy and the law offices of Prashanthi Reddy. Thank you, everyone, for joining us. But stay tuned on Immigration and Jobs Talk Show because we have more sessions coming up like these. And yes, check out our space. For now, it's Nipasa saying bye. Have a great day ahead.
Hello?
Good afternoon, everyone. Thank you so much for joining us. Welcome to Immigration and Jobs Talk Show. This is Nipasa Pradhan, and I'm going to be your host for today. And it's lovely being here. So, sorry, it's not just good afternoon. It may be good morning or good evening. So, thank you so much wherever you've joined us from whichever time zone. So, welcome to Immigration and Jobs Talk Show, and I'm really happy to be here. We are streaming live right now on YouTube, LinkedIn, Facebook, and X. And I'm really glad that you have joined us. And before we proceed with today's webinar, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, yes, and you can also participate, by the way, in this session, friends, by commenting whatever questions you have, especially with regard to today's topic of discussion. And that is Trump's new team, a fresh start or a nightmare for immigrants? I'm sure all of you folks have many questions and are probably in a dilemma whether it's going to be good or it's just going to get worse for you. So, today, here in this webinar, we are going to discuss this further. And joining me is someone who needs no introduction, who has been a part of Immigration and Jobs Talk Show, makes it a point to be here. So, I'm very happy to welcome once again none other than employment-based immigration law attorney, but also a true advocate for the immigrant community, from defending H1B RFEs and NOIDs to guiding students on F1 OPT visas and offering expertise on TN and E3 visas. Justin has been a beacon of hope. So please help me welcome him back to the show. Hello to Justin Rivera from Wasden Immigration Litigation. Thank you so much for joining us.
Thank you for having me. That was a very nice introduction. I appreciate it.
It's been a while, I mean, I take it for granted sometimes, and maybe I don't say good things about you or let folks out there know. So maybe we have new friends. This is none other than Attorney Justin Rivera, today's special guest, and he's going to help us Today, on this topic, we're going to talk a lot on Trump's new team. So, before we head start, Justin, what do you have to say to everyone out there?
Well, anybody that's here that's celebrating, an early happy Thanksgiving to you, because that'll be coming up this week. If you're here in the U.S. celebrating that, happy Thanksgiving. I hope you have a short work week. But yeah, in regards to today, we'll just try to delve into, I think, a lot of what many people are doing right now, which is trying to kind of wrap our heads around what a new administration is going to look like and the impact that it's going to have on immigration in the country. And you can do that kind of by looking at who's being put in influential positions within the administration, and what have those people said about immigration, and what that possibly means they'll be actually doing moving forward.
Absolutely, friends. Thank you so much, Justin. And yes, don't forget to participate. And before that, if you have friends who would be interested in getting to know this more about today's topic, Trump's new team and its effect on immigration, please feel free to share this link with everyone or your friends out there and ask them to join in this discussion. So, yes, thank you so much once again. And let's go ahead, Justin. I have this first question. This is regarding Pam Bondi, and she has a history of aligning with Trump's agenda, including her role in his impeachment defense and her work with America's first policy institute. So, how do you foresee her policies impacting immigration cases, especially regarding federal prosecution priorities?
So, I think obviously it's a fortune teller argument here of what are you predicting or what can be done. But I definitely think that, there is an avenue to go after criminally, go after people that are, found to have committed visa fraud. Usually that's something that's applied to companies, organizations, usually the higher up individuals within the organization. And so, could they use that avenue moving forward more liberally than they have in the past? I definitely think it's an option. In regards to Pam Bondi, just kind of reading up on her and looking at kind of her record, I think she's probably going to be basically doing what Trump is asking her to look into. And from her perspective, I think the immediate things are probably not going to be immigration and that enforcement of, maybe fraud allegations against individuals. Now, that's not to say that couldn't happen, because honestly, it would be a pretty interesting tool for them to try to utilize if their goal was to actually start trying to crack down on the companies rather than the individuals, as a method of kind of limiting how some of the organizations that have been able to get away with using H1Bs would be able to use them moving forward. So I definitely think it's something to look into and think about. I do know that, from my understanding of Pam Bondi, her relationship with Trump had something to do with I guess the fact that he gave a donation to her of like $25,000 or something like that to her reelection campaign, and not as a direct result, allegedly, but maybe the fraud investigation into Trump University in Florida was no longer something that was being discussed or put on the docket. So that's on the Washington Post. You can see the inference formed there. But what that really kind of tells me is it's like you're going to see with a lot of these appointments, it looks like it's more of a loyalty issue rather than a skills issue. It's, is this person willing to carry out what it is that he wants to put forth with his administration? And so, yeah, I would say, would it shock me if there were more cases brought against people for visa fraud, especially the employers? The people who are actually signing the H1B forms? No, it wouldn't shock me at all. And honestly, if I were them, it would probably be something I would utilize.
All right. Thank you so much, Justin, for giving us a sneak peek into your thoughts about Pam Bondi, and thank you so much. You can also go check out the post on Washington Post, and the news is out there already. So thank you on that note, Justin. We also have Amay on YouTube asking a question. Amay, please stay with us. We will take up your question in a bit. hang on. For now, I have another question, and this is about Matt Gaetz. Although he withdrew his nomination, the controversy surrounding his potential appointment raised concerns. So, does the consideration of such a figure indicate a shift in how the administration might handle immigration related ethical and legal matters?
So, yeah, I mean, I don't know really if we're going to be able to frame it specifically through the prism of immigration, but I think what we saw with Gates's attempted appointment was the fact that there are still guardrails in place, regardless of how tenuous those guardrails are. There's still going to be some level of qualification required for these people being put into these positions. And the fact of the matter was that Matt Gaetz, he wasn't really qualified for the position that he was going to be put into. That being said, as well, would he have gotten the position were it not for his ethical issues? It's very possible. But what it really kind of does show me is that there is still going to be pushback on appointments, which is a positive thing. That people still should be held to a high standard. But in terms of immigration and kind of how I think it's kind of interesting, you could maybe draw this small parallel from it, but the fact that Trump was even willing to try and appoint Gaetz in the first place, it's not that surprising, and it's a bit indicative of his strategies. A lot of times they just kind of throw stuff at the wall and see what sticks. So if I'm looking at it from that way, I wouldn't be that surprised if you see a lot of quick changes to immigration that come in, and a good amount of them end up being invalidated by the courts. Just because they don't hold legal muster. So that wouldn't shock me. I definitely think that they are more willing to act and then just kind of see whether or not the court will let them act, rather than make a prepared, concise, well-researched change that's going to stick. So that would be my thought process, would be don't be surprised if you're seeing, within that first month of the administration handover, changes, fairly drastic changes in proposals that may or may not actually hold up in a court, but are still going to cause hiccups in the immigration system.
All right. It's scary how the situation is for many immigrants out there, I think. And with all these new picks, I think the situation is getting even more tensed. What do you say, Justin?
Uh-oh.
Can you hear me?
Yeah, sorry. The quick little hiccup right there.
No worries. Yeah, I was just saying, like, with these new picks, it's just getting scary. So what do you think?
Actually, someone just commenting about, I think it's Dr. Oz was allegedly being given an appointment. No, I know, Sakshi. I know. It's not ideal for me. I think for a lot of people who are looking at the individuals that are being named to these positions, there is a little bit of a wow factor to it, because I think in the first administration, I think Trump was a little more reeled in just by the nature of the fact that, like, it was fairly surprising for most people that he won. And I think there was a little bit of period where the Republican Party was kind of like, we're going to put we're going to put guardrails up. We're going to have people appointed, Rex Tillerson. There's going to be people put in positions that are experienced and qualified and know what they're doing. What we did learn, though, from that administration was there was a pretty high level of turnover, and that turnover basically correlates to, if you're not doing what he wants, you're going to lose your job. We saw it with Jeff Sessions, and then he even ended up having problems with Barr, which was, another person he had appointed himself for the AG spot. So the other thing to think about, too, with this is kind of a shelf life. How long are these people actually going to hang in these positions? And actually stay and deal with kind of the turmoil that this administration is inevitably going to bring. So that'll be something I think we're going to have to consider as well.
Right, Justin. Thank you so much that also was a very good insight, I would say. And we have Malutek USA and even Sakshi joining us with their questions. And I think that we can take Malutek's question for now, if you don't mind.
Yeah,
so
sure.
He's asking, Canada, Australia, and UK reducing temporary issues and student visas. Why Republicans act more left than Canadian Trudeau? 10,000 of American tech workers are unemployed, desperately need job. Okay. What do you have to say?
I think so. I've been kind of monitoring the Canada situation pretty closely because I found it very interesting. So during the initial Trump administration, Trudeau, who is still in a position of authority, Trudeau was very open to immigration. He was basically saying, like, oh, if you're not wanted in the United States, come to Canada. We want you here. We're more than willing to take people on. They looked into expanding their immigration regulations to bring in a higher influx of people. That may have come back to bite them. About probably around last year, the middle of last year was where I started seeing it. That's not to say it's not something that's been existing before, but I did start seeing a lot of attention on it in the middle of last year, and it's at the forefront this year. Trudeau's already made statements that he's reversing course. They are taking steps to curtail and limit immigration moving forward. He has made the spigot argument, which he's claiming that the spigot, the water spigot, has been turned too far one way and needs to be turned back the other way. That's his stance. I've been playing through my 34 years. What's up?
Sorry.
Oh, it's okay. But anyway, that's he's a politician. He's dealing with the vibe of what's going on in his country presently. But as a result, yes, I think you're seeing Canada move towards more restrictive immigration policies. Australia, I think I've also seen is possibly trying to reduce immigration. I'm not as well up on the UK. Why Republicans would act more left than Canadian Trudeau. If you're saying why would the Republican Party embrace immigration, legal immigration in the United States? Because legal immigration in the United States is beneficial to the United States economy. It's been well established. So there wouldn't be really any valid justification. I think that the whole point of these programs like the H1B program are to create the necessary guardrails that prevent U.S. workers from being kind of left out in the cold by, allowing there to be people who are going to be able to do the same job for less money. That's why you have the labor condition application that establishes the wage levels. These things are stringently enforced, both when someone applies for the H1B and through FDNS's site visit systems when they actually go out and make sure that the person's complying with the conditions of the H1B. So that all being said, it would not shock me if the Republican Party acts differently than the Biden administration. I know people are very quick to jump the gun and say, well, what has Biden actually done for legal immigration? Like, how is it that different than it was under Trump? I will tell you firsthand, as someone who practiced under the Trump administration, it was significantly different. You were dealing with an entity in USCIS that was borderline adversarial. It wasn't more so our job is to process these applications. It was we're looking through these applications almost with an assumption that there's something deniable in what's being presented to us. And I think that's what you're going to see as the biggest difference. And it will show you that the Republicans are not more left than any of those other countries. They are going to seek to draw out the time it takes for an application to be processed. They're going to do that using requests for evidence that I'm sure will become more detailed and require more information than is currently necessary. They're going to do that by attempting to limit validity periods any way they can, meaning, they're going to probably go back to trying to find ways to cut down people's requests for 3 years. Whether or not that will hold up in court, we will have to wait and see. But I'm sure that they'll be taking from the pages that they've used previously in order to grind the system as slowly as they possibly can. On top of that, yes, it's completely possible that they're going to be introducing new ideas and new ways to try and make the system even more difficult than it is presently, with the underlying goal being that they want employers to just not have to deal with the program, and if they do things like increasing the wages, making it to where you have to pay even more to have someone employed on an H1B. That's one avenue that they may look at. They may look at curtailing the definition of specialty occupation, making it more stringent to where it's more difficult to qualify for the position. They might make it harder for the employees to qualify with their degrees, unless the degrees are absolutely one-to-one correlated to the job duties being performed. So these are all things that they're going to do. And if they didn't do them, it would surprise me. But these are all things that I definitely think they want to do. And with Stephen Miller, who I'm not sure if we're planning to talk about today or not, but with Stephen Miller in probably a more influential position in this administration than he had been previously, all of these things are going to be on the table. And it's not really, to me, a matter of if, but when, and whether or not they've now also decided to find new things that they're going to be putting forth. I believe I saw last week, towards the end of the week, something about the dismissal of a case that had been backed by a Miller group where they were going after, once again, the H4 EAD. So it was another attempt for them to go after some part of immigration to curtail it, to make it more difficult for people that are here on that H1B visa if their spouse can't work. That didn't hold up in court. But you got to remember, they were challenging something. They're moving into a situation where they're going to be taking part in the rulemaking process. And that's going to change how they're approaching it and what they're trying to do. So all of that is to say, for Malutech, I don't think that the Republicans are going to be acting more left than the Canadians. I don't think that that's going to be the case at all. I think you're definitely going to see them crack down on legal immigration. It's not going to be the forefront of, what gets people's attention, especially initially. Where everyone's eyes are going to be drawn is where the election seemingly was decided on in a large part, and that's the border. And, the actions that are taking place at the border to curtail entry. And I think that's going to be what gets the headlines. But at the same time, it wouldn't shock me if they're able to walk and chew gum at the same time and also move forward with making those changes to legal immigration.
Right. Thank you so much for taking that up for Malu Tech USA, and thank you, Malu, for participating with your question.
I think it's a good question. I think it's also indicative of, in a lot of places, you're seeing a protectionist shift. I think you're seeing people in countries that are moving more so towards not maybe being outright anti-immigration, but being more selective in their immigration process. I think to say that is something that's moving forward in Western countries, I think to say that it would be realistic.
Right. But yeah, coming back to Stephen Miller, talk about his first family separation, including travel ban and all that. So what do you foresee? This could also influence this term as well. So how's it going to be, you think, for immigrants?
So I think, I apologize. I think we have a question on him. I don't remember the name of the border czar that has been appointed. But I remember I've heard about him. Tom Homan. Thank you.
Tom Homan, yes.
So Homan has really talked about his ability to enforce actions at the border, right? And it's when you really think about it from an immigration perspective, when you're reviewed for admission to the United States, that's a pretty big part of a process, because at that time you're being, assessed by an officer who makes a determination as to whether or not you are admissible to the United States, right? So for most people that are legal immigrants, this is a very quick part of a process. If you've been in before, you come in, you know what you're doing, you go through CBP, it's no problem, right? It wouldn't surprise me if the enforcement activities being promulgated at the border begin to bleed out into other facets of entry. And so what I mean by that is this: I've already actually seen it. I was reading about it before our discussion today. Homan has already come out and made a point about illegal immigration at the Canadian border. Basically saying, there's problems at the southern border, but what about the northern border? We have issues there too. We need to be, we need to be more stringent in how we're reviewing people there as well. And so I think for a lot of people that are, that travel between Canada and the US, maybe people that are on intermittent L visas, TN visas, things of that nature, I think you're going to see a heightened level of scrutiny. I think it's going to be created initially under the guise of trying to curtail illegal immigration, but it's going to bleed into the other facets of immigration as well. And I think that that's going to be, it's going to create a difficulty where one previously hadn't existed. So I would say it's pretty imperative for people moving forward when you're getting ready to really consider traveling and how you're going to re-enter, where you're going to re-enter, what documents you're presenting when you re-enter, and being prepared for detailed questions being asked in relation to not only that, but any of your previous immigration history in the United States as well. Because, I mean, we've already seen things that are popping up under the Biden administration that have been popping up for a while now, but issues with, people who have been on their H's for years that are now being questioned about F1 employment with, companies that have been blacklisted, basically, that USCIS has now come out and basically said, if you worked with this company, if you worked with this company, then you're basically de facto fraud. Like, you've committed fraud based on the connection to the company. So I think that is something that's going to need to be very well thought out by people when they're immigrating or coming into the U.S. Looking at what is it that you could be asked about in your immigration history or about your current job or any of those things that could lead to additional questioning or additional scrutiny. Because all of that, I think, is going to be on the table. Because if you're not readily prepared, you put yourself in a bad situation. You put yourself in a situation where you're going to be questioned by an officer. You may not remember some of the facts. You may misspeak one time. That's really all it takes, is one misstatement or one slip up. And it's enough to put you in a circumstance where you could be an expedited removal and end up having your visa canceled. So I don't say all of this through the desire to fearmonger. It's not my intent to make people scared to travel. I've also seen, people online already are starting to get upset. They're saying, "Oh, my attorney's telling me if I have any travel, it needs to be done before January, mid-January, because they don't want people stuck by any changes that are made. This is ludicrous. I've never done anything wrong." You have to understand that as an immigration attorney, our job is to advise. And usually when we're advising, we're trying to take the most conservative approach or strategy possible, because what we want to do is minimize risk. That's our goal. We minimize the risk that an individual has either when they apply for something or they go to a visa interview or they re-enter the U.S. That's the goal. Not to make you scared, just to make you informed. And I'll put it this way: if we didn't say these things and then in the middle of January you travel and something happens and you're stuck out of the U.S., who are you going to blame? You're going to blame us for claiming that we didn't tell you not to travel. And so that's why that's happening right now. It's really not because we want to make people fearful. It's more of we don't know exactly what's going to happen. And the best idea when that's the circumstance is to just minimize the risk as much as possible. But yeah, to just kind of button that question about Homan's leadership, the border policies, I think you're just going to see a lot more difficult issues with entry that you probably weren't dealing with in the past couple of years. I just think it's going to be a lot more scrutiny. They may bring back some of the issues that had existed beforehand, which were things like, did you do a second master's degree and do day one CPT? Did you go to some of these universities that are looked at as maybe less than compliant with F1 requirements, just things like that. And then there, obviously employer issues and stuff like that. So I just think all of that's going to be on the table.
Yes, absolutely. And talk about the borders are. We can expect a lot of difficulties for sure, as we've already spoken about. Maybe RFEs getting more and more. Maybe they would want more evidence than already required. So stuff like that is what we have been discussing. And I think there's more to discuss on this. There's so many new picks. And well, I would just like to say thank you to Pavan also for joining us with your questions. Just stay with us. We will take up your questions. All right. And Justin, getting back to our questions, earlier I had asked about Stephen Miller also, because we have seen a lot of family separations and also, travel ban as well. So I think this is going to be a little more tough on immigration. Immigrants now, right?
Yeah, and I mean, obviously, I think if you're sitting on this call and you're somebody that's on, a non-immigrant visa, you're sitting there thinking, well, what is the applicability of that to me? I'm not entering the country illegally. I'm not doing anything wrong. I'm not doing anything illegal. Okay, so that's fair. It's a fair assertion. But aside from the fact that there's a whole human rights issue regarding the family separation issues. I think it was Tom Herman is his name. I think Tom Herman, when he was asked about family separation, he said something along the lines of like, "Well, no, we're not going to separate them. We'll make sure they're deported together." That was the solve to the home and thanks. I'm gonna see what's gonna suck is that I'm not gonna remember his name, and then he's gonna be the bane of my existence for the next 4 years, and so he's gonna make sure I remember it. So I get that, like, okay, well, maybe it's not applicable to me, but I'll have you look at it from this perspective. From this perspective. I remember during the last Trump administration, something that they had tried to do at the outset was deny people's extensions and then say you're now unlawfully present, which means you're subject to, you can be deported basically. Yeah. And then there kind of became a quick run where we were kind of running around like, are they issuing notices to appear for these people? Are they going to be coming after them to put them in deportation proceedings? Because people need to understand this. If your status, let's say your H1B extension gets denied and you're no longer lawfully present in the U.S., you can depart. You have an opportunity where you can leave the U.S. You have a timeline where you're able to leave. And, outside of having to admit that you had a prior denial and maybe explain the denial, there's not going to be that wide reaching of a problem that comes back to bite you on that. If you were to get placed in deportation proceedings, that completely changes the game. That's a situation where if you leave without appearing in court, there's implications, and then there's implications of how long do you have to stay while everything is waiting? How do you sort things out? Can you apply again to get yourself back in status? So I do understand. I do understand people being like, I don't know how that's going to affect me. It can affect you because the policies, like I've kind of been reiterating on this call, that are initially utilized for people that are illegally immigrating, they can bleed out and subsequently be used in the future against people who have come into the country legally and then lose their status because, they've had a denial or something like that. So while I'm very hopeful that doesn't happen because it would just really complicate our jobs even more, it's not to say that they can't utilize that. And so just thinking backwards from that, I just think that, if it does happen, it's horrible, but I hope it doesn't. But I think people should be aware that it's something that I know they have on their table. It's in their arsenal of things that they might want to do.
I mean, imagine being like the second or the third generation in the country and suddenly like you and your family are having doubts if you can still be in the country or not. So
yeah, I mean, all that stuff's frustrating. I mean, especially I would not be shocked for a second. During the last administration, they really cracked down on the F1 program. They did. They went a lot harder at STEM OPT than they had ever done before. It wouldn't surprise me at all if they went after that again. I think that it's something that because you got to think about it this way. If they want to curtail immigration, what's one of the easiest ways they can do that? They stop people from coming in and doing F1s and working in the U.S. on OPT and STEM OPT. If you cut that out of the process, then those people have to leave the country. And yes, they may still go into the lottery, but it's probably going to be harder for them to get sponsored because they're no longer working in the U.S. They're working overseas in their home countries. So yeah, I think that's definitely on the table. It wouldn't shock me at all if they tried to come out with basically new enforcement mechanisms for the F1 program.
All right, let's just hope for the best and look forward. All right. Well, now, Justin, let's take up Rag's question. He's here on YouTube. He's saying, hi, Napasa and Justin. With a flurry of cases coming in, will the attorney's efficiency be compromised, resulting in more RFE or rejections?
So I don't know if it'd be the attorney's efficiency that creates the issue with RFEs. The issue with RFEs are you prepare a petition as best you can. You try to cut off all lines of inquiry where they reasonably exist. But if if you're dealing with a circumstance where the goalposts are being moved constantly and in real time, it's going to create problems. And that's what creates the increase in RFEs. You know, things like changing how you look at specialty occupation or how you make that definition. Things like how you look at how someone qualifies for a position, trying to reintroduce things like, you know, project documents or proof of specialty occupation work. Those are all the things that are, in my opinion, are going to lead to an increase in requests for evidence. That's really the big issue with it. I think that the goal is not only to just increase the probability of denials, it's to increase the time that it takes to go through the process. It's to draw this out and make it more difficult so that it becomes a circumstance where employers just don't want to deal with it. I think that's really the underlying goal. And that comes from mucking up the system by making things harder when they shouldn't be. When it comes to, you know, rejections, rejections are circumstances where when you're filing a case, there's something missing in the case or deficient, or it's sent to the wrong location. Those are things that typically an attorney should be able to deal with, regardless of what administration is in a position of authority. Where that could become problematic, just speculating here, because we've already seen it with Biden in some regards, is just changing things. You know, making quick changes to forms and saying, actually, you know what, you got to use this form edition, and we're not going to backdate it, so you got to start using it as of December 1st. And the form came out on November 26th. Well, if you're a normal, you know, business immigration attorney, you've probably got X amount of cases pipelined that have already gone through that process, went to the client for signature, and they're in line to be filed. If you don't catch those before they go out, those will be rejected. So that's definitely something that could happen. Just making constant, you know, updates and alterations to the forms. But at the same time, if that's going to be something that they do, then it's going to become incumbent on the attorneys to make sure that they're doing their due diligence at the time of filing, to make sure that everything that goes out is correct and proper, because that's really the only way you're going to combat it. The other thing they can do too is they can move around the mailing locations, which is annoying, but we do try to stay on top of that as much as possible. That's a lot. AILA deserves credit for that. AILA does a lot with making sure that any of those changes that happen are kind of blasted out to the attorney so that we're aware of it. But those are avenues that they could take to increase rejections.
Yes, I mean, changes and updates, these are very, very important things, and it's very important to stay updated. So, folks out there, just keep on researching and keep looking out for new changes. Because, I mean, I remember we had a lot of fee changes, and like you said, address changes, Dropbox location change, and stuff like that.
Right.
And this led to a lot of, cases becoming invalid because of the wrong fee and etc.
Right. And so that's another one too, that obviously, like when you talk about mechanisms to make the process more difficult, fees are such an easy one. You know, fee increases are always a great way to hit the bottom line of the sponsoring petitioner. So if they're able to kind of combine increasing fees with shortening validity periods, that's a win-win for them, because it puts them in a circumstance where they're really making it harder for the employer. But yeah, that would be my answer to that, Raj. Thank you for your question. I appreciate it.
Yes, thank you so much, Rag, for participating. And if you have any more questions, we're still here. So, Justin, my next question, this is about Pete Hexet's political appointment as Defense Secretary. You know, this brings attention to his hardline stance on national security. So, do you think this could lead to increased militarization of immigration enforcement, and what might that mean for immigrants at the border?
So I will say this is actually something I've really been thinking about. Maybe not necessarily for the border, but it's something that has been crossing my mind, and that is, what is the impact on legal immigration of increased conflict abroad, whether that be in Europe or in the Middle East? You know, do we see some sort of proclamations coming out as a result of those conflicts, limiting immigration for people from those countries, or limiting immigration overall? I say that as someone who, we had a discussion before this call, for something I had just been dealing with, where it looks as if that there are people from a certain country that's engaged in a conflict right now that are basically just being denied U.S. visas under a very interesting strategy where they're being told that they cannot overcome a presumption of immigrant intent. And by doing this, it's kind of almost become this blanket justification for a denial where they're just saying 214B, no presumption of, you have not overcome presumption of immigrant intent. Therefore, you are not able to qualify for, let's say a B visa to the United States. My wonder is that a strategy that could potentially become weaponized moving forward as the conflicts in the Middle East increase? Hopefully they don't increase, obviously, but it's pretty hard to watch the news every day and see what's going on, and think that the next 4 years are going to be really chill and not involve more foreign conflict. But does that conflict create an even higher inclination and desire in the United States for this protectionist nature, where you're basically saying like we're severing ties, we're keeping Americans in their bubble, and we'll let people in from a couple different countries, but other than that, we're just staying with what we're doing. Maybe, I don't know. We'll have to wait and see. But that's something I've now been worried about. I'm starting to think about. Right. What is the impact specifically of what country you come from and your immigration? Not even how you qualify for something, or is it a valid petition? That I think is going to be on the table as well.
Right. And I mean, we've seen a lot of cases and a lot of announcements about becoming anti-Muslim and not allowing, countries with major religion as Muslim, not to allow them to come in to the country. Right. So, and plus, like what you were saying about the case, imagine, you being denied a visa in spite of doing everything right, having all the documents.
Yeah, I'll just come out and say it. It's pretty much being talked about already. I'm talking about people from Russia, just specifically. Yes. There's been a big increase in 214B visa refusals, specifically for people from Russia. It's a blanket denial, basically, that's being issued. And I'm kind of wondering, how is this strategy employed moving forward with other countries in the event that those people from those countries, their countries embroiled in a conflict? So we'll have to see. But like you said, the so-called Muslim ban is another issue that's something that's probably going to get attention coming in day one. So we'll have to see the impact of that as well.
All right, Justin. Thank you so much for taking that up. I think we should get back to Malu because he has another question for us on YouTube asking, wage levels won't get enforced for H1B. I know H1B visa employees working for $70,000 per year, whereas citizens working for client for same position has double the salary.
Yeah, so if you're asking about wage levels being enforced, the wage levels should be enforced because you have to pay a specific wage level based on where somebody's working and residing. Where they sit is what's going to dictate the amount of money that they're paid for the position, based on what kind of position that is in the labor condition application. There's really two ways that USCIS and DOL can attack and attempt to undercut wage levels. The first of which is when you apply for a position, you have to determine what the wage level is at the outset of the filing. There's 4 wage levels. Wage level 1 is entry level, experienced, quasi-managerial, high level, four across the board. USCIS has the ability to question whether or not the position qualifies for the wage level provided. They've done that pretty stringently when it comes to what's called level 1 wages. So that's the lowest wage level. Basically, that level 1 wage level is only applicable at this point to absolute entry level positions. People just out of college with degrees that are maybe just now starting to work in their specific industry, they maybe have internship experience or something like that. But as a result of that, you can't use level 1 to go in and undercut a position that doesn't meet that standard. So that's the first way in which you're really not able to game the system as much as it could have been gamed in the past. The second issue is if the company is actually paying someone under what's in the labor condition application, that's a DOL violation, and that can be reported. So not only would I tell you, Malu, if you see this going on, not only would I say, feel free to report it to the Department of Labor, tell those people that are employees, if they're being paid under the amount of money that's in the LCA, to report this to the Department of Labor because this is a violation. And those companies should be held accountable for what they're doing because what they're doing is illegal. So that's kind of my opinion of how you fix a system that even has like some small issues in it, rather than just kind of make this blanket proclamation that like the H1B system is bad. Understand that there are ways that you can work within the confines of the system. I will tell you this, I file H1Bs all the time. It's been very rare for me to see anybody getting paid $70K a year. I think that is a tough beat at this point to find people that are going to be getting paid around $70K. Even when you're paying on the lower end of wage levels, I think that obviously location matters. If you're in California, you're getting a very high salary. If you're in Iowa, the wage levels might be a little bit lower. So it does depend on where you're located. But that being said, yeah, I think I've done 4 or 5, maybe 6 LCAs last week. And I can't remember one of those LCAs being for $70K. I think probably the aggregate among those was close to 115 to 120. And some of those were even higher. So yeah, I mean, look, is there a notion that the H1B is utilized as a way to undercut wages in the US? I think that, yes, that's an assertion that's been made. Can you do that now in the current 2024 iteration of the H1B? I don't think so. I think it would be very, very difficult to do. And I'll do you one more, Malu. I will definitely tell you this. On top of the, that being reported to the DOL if someone's violating and paying under that wage level, I definitely think you're going to see a big increase in FD&S visits. I think you're going to see people coming in now. I think you're going to see more officers getting paid to do site visits all across the U.S. to go to client locations or employer locations or even home locations if they're on the LCA. And they're going to be asking those kinds of questions. Things like, what are you being paid? Seeing if that complies. All of that stuff, if it's a violation and the company is violating the conditions of the LCA, they need to be held accountable. They absolutely need to be held accountable because that should not be the underlying purpose of why someone is utilizing an H-1B.
Right. Right. Thank you so much for taking that up. And I'm sure Malu is very happy with your answer, very detailed. And thank you, Justin, for taking that up. See, he has something to say already. Many of us have been replaced by H-1B visa employees. So H-1B wage level need to increase to 120,000 to minimum.
Okay. Well, I mean, that's what
so.
You're asking. You're asking me, you're saying, do H-1Bs undercut the wage level of U.S. employees? I've come back and said no. And now you're saying, well, the wage level has now gone up to 120K minimum. Well, that means that the wages are higher. So I'm sorry, I don't really know how else to answer your question. The underlying purpose was to prevent wage abuse, right? By hiring people that are paid less money to do the same job. So if that's no longer the case, then it seems that the program is being implemented in the way that the people wanted it implemented in.
They say they need to increase it to 120K minimum. So, okay, I think that's what But yeah, thank you so much, Justin. And I hope that, Malu, you have your answer to your question. But anyway, Justin, I have my next question. And I think without discussing about Elon Musk, this wouldn't be complete. So with Elon Musk advising on government efficiency, do you think his involvement would lead to changes in how immigration processes are streamlined? Or do you think his focus will be on wasteful spending, which will result in reduced resources for immigration service?
So I would definitely say this, USCIS is fee-based, meaning that the money that they get is generated by fees that come into them. So in that regard, I don't think you'd see much of a change because they're just going to basically do the same, pardon my language, but they're going to do the same crap they always do. If they're going to say, we don't have enough money. And then, we need to raise fees because we need more money. And then processing will stay almost exactly the same. And we'll wonder where the money's going. But in that regard, I don't foresee it being that big of an issue. Musk, I'll be honest with you, he confuses me to a little bit because I don't really know what his long-term goal is. For example, my understanding was that the Trump administration wants to get rid of electric vehicle incentives, which would seemingly be directly harmful to his own organization. And then I've also seen that, one of the agencies that they want to cut funding from is NASA, which I think, again, would negatively impact his SpaceX program. So I don't know if his goal is to somehow put himself in a circumstance where like his companies benefit from these changes, but then other people don't. I'm really not sure. Yeah, I mean, maybe he does want to be president. Who knows? Well, I don't know if he can be president. I don't think he was born here.
Yes, I don't think.
So I don't know, maybe, but I definitely think that he's enjoying the amount of sway that he has presently.
Attention, yes.
Because he's in every picture, basically seated at the right hand of Trump. So yeah, I think he's enjoying that. I think him and Vivek, what they're actually able to do and what they say they're going to do are probably going to be two different monsters. Because this really kind of gets back to the whole appointment issues with Trump. It's almost never a matter of just if that person's going to quit, it's a win, Eventually it's a situation where the person gets worn down and just leaves. So we'll see what he's actually able to do versus what the impact of it'll be. When it comes to like immigration, I've never really heard Musk come out and have any sort of anti-immigrant sentiment. I mean, I can definitely tell you through the grapevine that Tesla utilizes a lot of employees that are on NIV visas.
Yes.
So I definitely think that he's, someone that benefits from the H1B program. So it'd be odd to see him kind of, bite off his nose to spite his face or whatever the term is. But yeah, we'll have to kind of wait and see. I would be surprised if it has long-ranging impact on immigration. The things that could have an impact on immigration for him from a business immigration perspective are what are the implications of these kind of cuts to government contracts, and government projects? Because I will say that I've worked with companies that, there may be a consulting company who the third party is actually a state agency, and what is the impact of that funding that's coming from the federal level to the state level for that project? And does it mean that they cut employees or whole cloth, get rid of that whole project in the first place? That's something that I think could be a problem. But it's going to have to just be kind of wait and see. I mean, I know that they introduced a couple of policies that they want to talk about, but it's all broad strokes. There's no actual how-to of it. And until that really comes forth, we're not going to have the full scope of the picture. But yeah, I mean, hopefully out of everybody, Elon's at least the only person in Trump's ear saying, hey, immigration's a good thing.
Yes. Thank you so much, Justin, for that view. Well, I have a few questions on, our Facebook groups and also our YouTube channel. So let me see.
Yeah, I could try to do like one or two, but I am cutting time pretty closely, to be honest.
Sure. So let's go with quickly. I mean, these are just comments. Maybe you can just tell us your views on these. So this was on our channel saying, so conservative Republicans support people immigrating legally, but the border has been invaded by unwanted and the poor. We cannot financially support people who never put into our tax system, but want the financial benefit as a worker recipient. Yeah.
I think there's a pretty easy way to just say what this person's saying. Trump wants to block illegal immigration from coming in. People validly understand that undocumented immigration is a problem in the United States. The system does not operate efficiently, and it doesn't operate the way that it's supposed to. I personally will even go one step further and say when people that are immigrating to the United States come in and they're working on work visas, I think that it's a little bit ridiculous that part of the employer's job now is to throw an extra $600 into their petition, specifically to deal with issues at the border. The so-called asylum fee that has been added into these employment-based applications, I think is unfair. I don't think that it's necessarily appropriate for legal immigration for people who are sponsoring people here in valid non-immigrant statuses to have to take on the additional burden of dealing with problems that are occurring at the border. I understand that frustration. I also think that it must be incredibly frustrating for someone who has been in this country legally for 10 or 15 years that is still sitting here waiting for an opportunity to apply for a green card, be told that, the big issues in this country aren't you. The big issues in this country are people coming in from the southern border and, claiming asylum. And that's really where everyone's attention is going to lie. So I understand that anger. I get it. What I don't understand is this disconnect that seems to exist for some people that are here legally, that have immigrated here legally, this disconnect that Trump only has issues with illegal immigrants and Trump's only going to be creating enforcement activities that only goes after people that are in the country illegally. Donald Trump may believe that in his heart and soul. Stephen Miller doesn't. And Stephen Miller is the person that's going to be architecting the policies that are going to dictate the next 4 years. Yes. That's where the disconnect I see gets frustrating for me, because I really don't want to hear people complaining when we're a year and a half into this process and legal immigration has gotten more difficult. I don't want to hear the complaints about, oh, well, I didn't think this was going to happen. We were telling you it was going to happen beforehand.
Yes.
So I don't want this head in the sand crap that is inevitably going to spew up as a result of that. So yes, to this person's point, I get it. The southern border is a mess. It needs to be addressed. Honestly, it looks like it was pretty high on the list of reasons why Trump won. And that's something that he's going to be tasked with fixing over the next 4 years. We'll see how he does. I hope he does well. I hope that we're able to create avenues that create positive results where we're able to curtail this problem and make it better. I also hope at the same time he does things that benefit legal immigration. But we will see. Is it likely? No. So yeah, that's kind of all I have to say in relation to that comment.
Thank you so much, Justin. That was really valuable. And this next one is, I hope Trump bans sanctuary cities and ban illegal immigrants from getting any benefits from America.
Okay, we're kind of we're spinning on the same wheel that we were on previously.
I hope so also.
And look, I get it. Like, there's definitely going to be a lot of showdowns that happen over the next 4 years with illegal immigration. There's going to be issues related to state government versus federal government. The enforcement of immigration by local officers, I've already seen as an issue that people are bringing up. The idea of sanctuary cities being challenged or being brought up as well. All of this, in my opinion, really comes back to this notion that of people who came here the right way are frustrated that people who didn't come here the right way are getting benefits. And they're getting, it's a feeling of animus that I'm trying to do things correctly. I see people not doing things correctly, but those people not doing things correctly seem to be getting more attention and a better break in terms of benefits than what I'm receiving. Okay. I hear that frustration. I understand it. All I can say is what I do professionally, and what I've done professionally over the past couple of years, dealing with this exact administration and what we're going to deal with its new iteration. You're not going to just escape the impact of immigration policy changes merely by virtue of entering the country legally. It's not going to mean, do I think that Trump's going to hunt down everyone that's on an H1B and deport them? No, of course not. That's not going to happen. But we are going to see a tougher 4 years play out than we have seen under the Biden administration. And that's just a fact. It's going to be what we deal with. And that's regardless of what they do with illegal immigration.
So true.
So if you are happy that these changes are being made in relation to illegal immigration, okay, that's great. But do understand, if you are an immigrant and you are in the United States right now, or you want to immigrate to the United States, the world that you're going to be looking at by the middle of next year is going to be very different from the world as it is what we're speaking about presently.
Mm-hmm. Right. I think, thank you so much, Justin, for that. Last but not the least, if you would just like to take up this last comment from Rag, will legal immigration get a day one surprise, or could there be a bit leeway?
I genuinely don't know. I mean, I don't think it really makes sense for them to come out and make drastic policy changes in relation to legal immigration on day one. I think they're going to want to serve the master, which is the masses in their desire to make changes at the border. So I really think that's going to be what policy A is for them, is going after making whatever changes they think are necessary. I think they're definitely going to reinstitute the Remain in Mexico program. I have heard that they are trying to institute a similar program in Canada. So that'll be interesting because I didn't know that there was a lot of people trying to come in through Canada to claim asylum. Usually you hear about it coming from Mexico. So I know that those are going to be things that they're probably putting in at the outset. I definitely think that, the family separation thing is going to be big. And then how they handle different policies with removals and stuff like that. That's all going to be big. That's going to be, like I said earlier in our call, that's going to be what gets the eyeballs. What's not going to get the eyeballs outside of the immediate community that handles immigration on a day-to-day basis are going to be the policy changes that they implement throughout the duration of the 4 years that they're in. Because I think obviously don't agree with the things Stephen Miller does, but have to give some level of credit where credit's due. He's had 4 years to sit on the things he did last time, and he's had an opportunity to probably make changes and corrections to things that he was not able to get done before. So you're going to see, you're going to see somebody that's coming in with plans and ideas that he's going to want to implement. But yeah, maybe day one, will there be 150 RFEs issued the day Trump takes office? No, I don't think so. I think you're probably looking at more of a slow burn.
All right. Thank you. And Rag already says, thanks to Pasa and Justin. Great updates. Thank you, Rag, for participating.
Thank you for your time. I'll try to come on next time we get together with just something more positive.
Sure.
That
Justin, it's really, but it's seriously always a pleasure to have you here. Thank you so much. Today was great. I mean, it was a great and interesting discussion about all these picks that Trump has made in his new team. So thank you so much for doing this today.
Absolutely. Thank you very much for having me. You guys have a great week. Have a great Thanksgiving. And I'm sure I'll talk to you soon.
Yes, me too. And here's wishing you and your lovely family a very happy Thanksgiving as well. Happy holidays.
Happy holidays. Bye.
Bye-bye. So folks out there, thank you so much today for joining us in this very important discussion. And it was great having you. Please don't forget to like, share, and subscribe to Immigration and Jobs Talk Show. We are on YouTube, LinkedIn, Facebook, and also on X. So thank you so much. And stay tuned because we have more webinars lined up. And I think in just 15 minutes, we're going to have another. So yes, watch out. Immigration and Jobs Talk Show. It's Napasa saying bye for now.